Hello, everyone, and welcome to Immigration Talk Show. I'm your host, Sam. And today we are here with another very exciting and important discussion that is lined up just for you. So make sure to watch this webinar till the end because this is really going to be very important. And before diving into the topic and also inviting our today's very special guest, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information at your own risk. All right, with that, friends, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. And if you haven't followed us on these many platforms, then please do it right now. And also make sure that you like, share, and subscribe to Immigration Talk Show. Our handle is at Immigration Talk Show. So, talking about today's topic, I think this is a much needed one. And that is what are the top alternatives to the H1B visa in the US? So, of course, friends, whenever we talk about, go and work in the US, we always have this thing in our mind that, oh, now I have to look for the H1B visa. But is it the only option for you to work in the US? Or there are some more alternatives that you are not aware of? If yes, then I think this is a must watch session because in this webinar, we are going to share some great alternatives to the H1B visa where you can have a great life in the US and you can have your dream come true. And some visas that are really easier to get, faster to process, and perfect for your goals. So, without any further ado, also let me welcome our today's very special guest and very honorable one as well, none other than Ruby Pars, who is a board certified immigration attorney and also the founder of Pars Law Group in Houston. With nearly 2 decades of experience, she is not only a skilled legal expert but also a passionate advocate for immigrants and their families. And there are more to go. She's an author, educator, and a respected voice in national media like the New York Times, CNN, and BBC World News. So, friends, whether in the courtroom, classroom, or community, Attorney Ruby is driven by one mission that is to empower and advocate for others. So, hi, Ruby, and thank you so much for being here. It's really our honor to have a show with you. So, hope you're doing great.
Thank you, Sam. That was a very warm welcome. I'm very honored. Great to be back.
Absolutely. And to me also, I'm also very excited for this session because, right, Ruby, this is a much needed one. Right now, if we talk about current scenario, then everything is happening. I mean, most of the hot topic is happening with the H1B workers. So
Yeah,
it's a very important one.
right. This is that time, the registration happened, those were chosen. Of course, we're talking about the cap, but again, cap, if you're cap exempt, you can apply at any time.
Mhm.
But what if you weren't chosen? What are options and what are alternatives? So that is a hot topic.
A very hot topic. And of course, I think, friends, this is a very important one. So you shouldn't also miss out. And to keep watching, also make sure that you have liked, share, and subscribe to our channel. If you haven't done it, then do it right now. Okay, so I think, Ruby, before diving into the topic, I also want to know it from you that what our viewers can expect from today's episode. If you can
Well,
just give
I'm
us a brief.
Yeah, I'm going to give a little overview of the H1B program. A lot of people already know that probably who are watching, but then I want to give like a walkthrough of some alternatives to keep in mind. And in many cases, when individuals come to us or employers, HR advisors, CEOs, we walk through this option when we're talking about whether their candidates are eligible or not, and what would happen if they don't get chosen, with the registration process. But sometimes you're just fingers crossed everything's going to get approved and the registration happens, and so maybe you weren't really looking at the backup plans in earnest, and now it's time to do that because the first round has been chosen, and we're not sure if they're going to run more rounds of the registration through list of the registration numbers and names later on in the year to meet the numbers of the visa quotas. But yeah, we're going to walk through those, and then I can also stay on and answer some questions as well.
Wow. That's great. And I think this is really going to be a game changer episode because, most of the time people are just crazy about H1B, and of course, it's a very popular and demanding visa. So I think, friends, this is a must watch session. And with that, Ruby, here's my very first question to you. If
Okay.
we talk about current scenario, then of course we have seen so many things that's happening, especially talking about recent news that Silicon Valley and tech giants H1B layoffs are happening. So
Mhm.
I want to know it from you, like keeping the current scenario in mind, do you think that H1B visa is still popular for international workers, or are other visas becoming more attractive for them?
I think it's still attractive for the individual in the international worker space. There's a lot of different industries, growing ebbs and flows. And for the most part, the employment-based visa processing has not been changed that dramatically in the new administration, unlike some other areas. And
Mhm.
so I think a lot of there I know there's a huge labor shortage in different areas, and I think that the employers are still wanting to lean in to fill those roles with the H1B. So I know that like sometimes there can be layoffs and changes in the labor market, but there are a lot of there's a lot of room for growth, and there are a lot of demand. So I think it's still it exists for a reason, for that educated specialized skill type of a worker. And the alternatives are really just if this doesn't work. But for the most part, this is the ideal visa for certain types of work. And sometimes you just have to find an alternative temporarily until you have a chance to try again at the registration process.
That's right. And I think that's perfectly explained. So thank you so much, Ruby, for putting up this. And I also want to know, like, go ahead with the next question, and that too a very important one.
Mhm.
So besides the H1B, of course, we have alternatives, but we want to know it from you in a detailed manner. If you can explain, like, which visa would you like to recommend for international workers and why?
Well, if I may show a little, I have a few slides about a couple of options,
Okay.
and I can sort of walk through what those might be. But there isn't, necessarily one that's like, okay, this is the alternative for everyone, because it really depends on your skill set, what your goals are, what the employer's goals are as well, and also like, are you bringing in family? Does the spouse need to work? Lots of those types of things. Those are all things to consider. So if I can, I think you can see my if I can share my screen, I'll go ahead and walk through a couple things. So just like you mentioned, I'm board certified, about 17 years of experience. So bringing that to the table, we had the H1B lottery or registration, if you will. It was closed out on March 24th. And we found out the results leading up to March 31st, a couple of days early for some folks. And then those who were chosen have to submit the I-129 before June 30th. And so those who choose not to go forward, or those who are found out not to be eligible, then those visas are going to go back to the drawing board, and they'll be giving those out to other individuals who had already registered. And so but it is important to know it takes a while for them to go through that process. And so don't put all your eggs in that basket, as we one would say. If you have a U.S. Masters, we know you have a higher selection chance. You get two lottery attempts. And the second lottery possibilities, you can see that there were extra selection rounds done in many of the last years, except for in 2023. And really, it's going to depend on how many people go forward and apply, or who might be denied. And again, like I just want to mention, it could be that you are CAP exempt in certain universities and affiliated nonprofits, nonprofit research institutions, government research. So keep that in mind, because then you don't have to be concerned about this time frame of going through the registration process. Okay, so that is something to note. Okay, so let's go ahead and get into some of those alternatives. Um, So the O1, okay, this is one that, individuals with exceptional skills, science, education, business, or athletics. Now, it is a pretty high standard, but if you can meet the qualifications, so three of the eight O1 criteria in published work, major awards, membership in elite organizations, then this can be a really great option. It could buy you some time here, and maybe you could switch over to another visa later on, or it could be a pathway to a green card, maybe a national interest waiver or something along those lines. Now, again, if a person doesn't meet H1B for any reason because they don't aren't make it in the registration process, they could go work on their skill set, their expertise, and then either try again the following year and or start building up their resume for potential O1. So this one is a one really good option, but the standard is pretty high, and it's not just for everybody. The L1, which I think somebody put a question about that. So you're usually looking at L1A for managers and executives. The bottom line with this one is that you've worked 1 year in the last 3 years in the foreign country, and then they're intercompany transferring you over here. There could be L1A for managers, executives. There's the L1B for employees and specialized knowledge, and there's also can be the blanket L. And some companies might qualify; they didn't realize that they did, and that could make it a lot easier for them to qualify for their employees. But the biggest thing to remember is 1 year in the last 3 years that they worked for the foreign-based location and that they're transferring over here. So that could mean like, okay, you didn't make it this time, go work for the company abroad for 1 year and then work on being transferred after that has happened. So that can be a great option. The other thing that's great about the L's is that spouse can work, and L1A has a 7-year cap and L1B has 5, but you can recapture time just like the H1B. And if you're gone from the country for one entire year, you can restart the clock as well. There's actually an L1 new office. So if you were to go start a company abroad and you wanted to make a new office in the US, you could also come here on the new office L.
Yeah.
Um,
I'm so sorry, Ruby, but
yeah,
like asking you, I'm so sorry to interrupt. But
no problem.
can you also please let us know the L1 and O1, how much long does it take for a process to get in completion? Because I think for H1B it takes years and years. So what's about the O1 and L1 also process? If you could please let us know about it.
You mean
The visa
completion?
process.
You mean like what's the max of it, or how long does it take to get it if you were to change status to it or to apply for it?
Not changing the status, only the beginner who is just going to, apply for the visa for the L1. So maximum, if you could please let us know approximate time, like how much will it take for that applicant to get the L1 visa approved?
Oh, okay.
Yeah.
Well, you could do either consular processing or you can do a change of status depending on where you are, and it really could mean a matter. So there's one aspect of how long does it take to get your all your evidence
Yeah.
together, right?
Okay.
So that really is up to you and your attorney. And then there's how long does it take with the government to process. So let's talk about the consulate because this affects pretty much everything we're talking about here.
Yeah.
There's a lot of there's a lot of consulates locations have been closing. There's been some staffing changes. I actually saw a headline about the State Department even today, that there's some changes happening. And when administrations change, usually there's a shift in personnel. What does that mean? Well, it could mean that things are going to take a little longer, or things that we knew before are not what they are today. So you can look online to see what the visa processing times are, visa wait times for certain visas at different posts around the country, around the world. I don't know if they're all accurate, but hopefully they are. And so it could be a matter of that processing time. Also, with the change of status, if you can do a premium processing,
Okay.
right? That's $2,850, right? Yeah, and you can get the decision in um, about 3 business weeks. That's
Okay.
not available for everything, but yeah. So I mean, I didn't exactly answer one exact answer for everything because it depends. Some things have premium processing, some don't. Some you might want to do a change of status because you're here in the country.
Okay.
Some you're going to do straight up consular processing.
Mhm.
So it really can depend on that. So I think it really will. How quickly can you get the evidence you need? A lot of cases, I'm just going to tell you, it can take, I don't know, 3 to 6 months sometimes for clients to, like an O or a national interest waiver. Really see a lot of clients take about 6 months to get that together. So anyway, hopefully that gives a little perspective, but the processing times have been ebbing and flowing. So you really look to the State Department website about how long it takes to get a visa scheduled. You
Mhm.
also can look to the processing times on USCIS website. And then you also look to how long does it take for you to get your documents in order and how busy is your attorney. So a combination of all those factors.
Absolutely. I mean, that is a little different thing. It depends upon case and case, and we can't just give exact number that these many months will be there and you'll get your visa. But also, Ruby, if you could also let us know that how L1 is better than H1B, or in what terms, if you can just give a brief comparison between the two visas so that it will be a little easier for us to understand that why this is one of the alternatives of H1B.
Yeah. Okay. Well, so one of the biggest things is that the L allows a spouse to work, and the H4, it's in very rare circumstances if they have like a perm pending, can they do that? That's
Mhm.
one big thing. The second thing is the L1A is usually goes to an EB1C or more of a green card pathway, and you don't really have to wait too long to be in that L1A role to do that. So that seems to be a natural progression. The L1B, you're given that 5 years, but again, if you leave the country at during summer holidays, whatever, you can recapture that time. But it's a perfect. Um, it works really well with the perm process, just like the H1B does. So it's, I mean, it doesn't mean like it's astoundingly better necessarily, but those are some of the things to consider. And you're not, you know, relegated to the registration process. If you
Yeah.
meet the qualifications, and you could apply it whenever you qualify, the 1 year in the last 3 years, and the company wants to go through the process. So those are the things that come to mind that just sort of jump out at me. Yeah.
All right, that's great. And so sorry, Ruby, to cut your flow. You were going exceptionally flawless. Then please go ahead.
Oh, okay. Thank you. Well, I mean, there's still the STEM OPT extension. There have been a lot of like student revocation visas, unfortunately, in the last, week or two, but there has been a lot of litigation reinstating those. So, that's a very hot topic right now where things are, and usually that is a pipeline, right? It's usually F1 to H1B. That's a traditional pipeline. And then having the STEM allows you to have a couple bites of that registration apple, if you will. And so, that was great when they did the extension of the STEM OPTs. So, that's another thing what most people know about that
Mhm.
anyway. This next one is really only specific to Canadians and Mexicans. And this is so it probably doesn't cross some people's minds, but if you are eligible because of nationality, certain professions like a certain instructor, teacher, or lawyer, accountant, engineers, scientists, there are certain professions that are eligible for the visa, and Mexicans have to apply at the consulate. Canadians can apply directly at the port of entry. It's really seamless for the Canadians. And so this can be a really great option. It's a non-immigrant visa. Spouses cannot work, but there really isn't what do you call a expiration date? No, that's not the right word. I'm trying to say there's not a limit to how many you can extend it to. So some people can be in it for quite a while, but this is very limited to just those two nationalities. Another thing that's limited to nationality is the E2. So it could either be for the investor or the employee. But so maybe if you're like, I want to invest and be an entrepreneur and not actually be an employee, this is another option.
Mhm.
So it doesn't. the countries do not include India or Venezuela, but they do include Pakistan and Mexico, for example. And depending on the reciprocity, you might get up as much as 5 years at a time, which is awesome because it's difficult to run a business. I mean, I know I've had one for like 15 plus years. And it's difficult when you're in a foreign land and you're learning how things work, right? And so the E2 could be you make a business up from scratch. It could be you buy a franchise, and you also could be an employee of like if you're Pakistani, you could be a Pakistani employer of a Pakistani E2 business, for example.
Mhm.
Um, just to give an example. So this is a substantial investment, and and the other thing is spouse is allowed to work, so that's another great one to have as well. The H3 is another potential option. This is if your employer wants to bring you here to do some training, learning something specific to the way the business is done, and this could be a short term visa to come here to the United States. It could help build up your resume, build up your options for the company wanting to keep keeping you in the fold and supporting you and keep trying at the H1B in the future or some other mechanism, or even to do the perm process. Who knows? So this is something I think a lot of people don't realize it exists, but it's an option. CPT program, and then like there's the green card options, but again, like if you don't have a basis to stay in the country while you're doing it, then it would be done outside. I rarely find through consular processing, I really find a lot of employers willing to do this unless you've already had some type of relationship where they've seen your work product and won a petition for you. So, but at least I'm just throwing that out there as these are other options, including the national interest waiver, which it was um, a little bit, the standard was more clarified and easier under the prior administration, and we're starting to see things change as to what the national interest truly. And some of the things have differed dramatically. And then also just the standard has gotten a lot more stringent. So there were a ton of applications in the prior 4 years and a lot of approvals. And I think we're going to see a lot stricter adjudication. um, thinking about dependent visas, who can work and who can't. We sort of ran through that while we were talking in some limited cases about the H4, very limited. L2 is allowed to, and E2 is allowed to as well. And so, just evaluating what your options are. And the other thing to consider is maybe your spouse can apply for something, and then you can be a dependent. For example, if like they can apply for an E2 or an L, and you would be able to work on the dependent visa. So I often like to talk to individuals and say, what's your spouse doing? I don't mean to be, you know, too inquisitive, but I mean, it's really because maybe we can have two options running at the same time. And, if we can look at their resume, we can try to see what we could try to get them into a visa, and then that can option, and especially if they have another nationality as well, that can also play into your options. So anyway, that was more or less some of the those are some of the things to consider. There's also like the J1 and some other options, or going back to school, the F1. Some people do that and get another degree and then have no more options on the OPT, but that can get costly. So, it might not be what people want to do. So,
That's right.
um, that's a little bit in the summary of some options for individuals.
I think that was wonderful, and Ruby, thank you so much for putting up so much effort and preparing this presentation and showing up in front of our viewers. I think this was really giving a proper understanding and in a very detailed manner to each visa alternatives. Right? I think this was really important and much needed. So once again, I would say thank you so much for bringing that up. And friends, I'm sure that you have went through the presentation, and in case if you have any question regarding any visa or anything, then please go ahead and put your questions on the comment section. As I can see, there are so many people have joined us: Jadav, Shokat, and Jose. So hi guys, and thank you so much for posting your questions on Immigration Talk Show. We will definitely take these questions, but let me go ahead with one more question that I have. So, Ruby, I think, of course, this was a really very well presented, and we have got the understanding what each visa is made up of. So, I would like to know from your end that you are an immigration attorney and you have like a very good experience. So, according to you, what is that eye-opening case that you have went through where an alternative visa, anything O1, L1, or J1 have worked better for an individual who initially considered the H1B? If you could please let us know any
Oh,
case study, I think that would
well,
be great. Yeah.
it might take me a minute to think about that, but because sometimes when individuals don't make the registration, we part ways and they maybe don't try again, or they with the employer that I was working with, and maybe they go to another employer prospective and another attorney. But I'll just share one thing that came to mind recently because I see a question about TPS and someone having TPS.
Yeah.
We
Absolutely.
just recently we had the whole Venezuelan TPS concern, and so we were like, okay, let's go out there. Let's check out. Maybe we have an H1B. Let's do a registration. Let's consider other options. And not only did the TPS like get, I guess what's the right word? I don't know. There's so much litigation going on, but like
Yeah.
I don't think reinstated. I don't know. It's we still have it, right? I'm a loss for the words at the moment, but the client was chosen the H1B registration, and we're working on an O as well. So I'm really happy for the client that we have, that we tried, that we put her hat in the ring, and she got a couple options, and the TPS didn't end, and so that gives us more options as well. So that I think really it is a team effort, right? It's the prospective employee or the employee, it's the employer, and it's the attorney. They all have to be working together in unison, and so and if anybody wants something different, it might, put the process, hold it back, or not be able to go forward. So I think one of the things to say is just the more communication, the more the buy-in from the employer, the better, because then you're more willing to consider options. Because sometimes employers are like, I'm going to try. If it doesn't work,
Mm-hmm.
it is what it is, unfortunately. Or depending on the situation, they might work really hard to find other alternatives. So, um, yeah, that was a happy. We're still in the process, but it was a happy story so far, considering everything that's going on. So,
Absolutely, and that was really great. And also talking about TPS, Ruby, as you mentioned. So I think let's take up a viewer's question as well. So Jose
yeah.
is here, and Jose has asked, "Can I apply for H4 even if I have pending asylum and TPS?"
All right. Righty. Okay, so I just listened to a CLE, Continued Legal Education, like about a couple hours ago on transitioning TPS,
Okay.
because it can be confusing, and it was an attorney who presented to other attorneys. But let me just issue spot with you some of the things that come to mind with this question. So the good thing about the H4, it's a dual intent. That's great. Asylum has a lot of immigrant intent in there about wanting to stay here in the country, and the TPS is, well, we won't. That's a temporary status. Now, one of my biggest questions to you, and we might not solve it on today's call, but I would say it's a consultation, is like, how did you enter? Did you have any unlawful presence time at all between your entry and applying for asylum or TPS? And did you ever work unlawfully? So those would be some of my questions, because depending on some of those answers, most of those answers will affect whether you could do a change of status to the H4 or not. But as I was saying, that call that I was on was really about this particular issue. How can we transition those who are on TPS to other things, especially with we don't know what the future of a lot of the TPS is. Now, just in general, I when people have an asylum pending and they try to switch to another status, there's lots of different factors involved about whether they ever had worked illegally, had any unlawful presence, how they entered, and also can depend heavily on where they are trying to do a change of status
Mhm.
or an adjustment of status. And so that's where this can get a little tricky. So anyway, that's pretty much the extent of my answer. It is in theory possible, but it
Yeah.
really depends on your entry, how much unlawful presence or unlawful status time, and if you worked illegally in between your statuses. It would help answer the question. So I need to know that information.
That's right. All
Okay.
right. And Jose has shared something, so let me take up this as well. I entered with the tourist visa and I applied for asylum while I was here as a tourist.
hmm So in general, it should work. We didn't talk about working illegally or anything else or
Hmm.
any other aspect, but in general, if you entered legally and went from a status to a status, but I would be curious. Sometimes asylum is not considered a status, asylum pending. And I've seen this be inconsistent around the country interpretation. So, really like to also see when you got your TPS in view of when your tourist visa expired. So, yeah,
All right.
I don't know if we're going to solve it on this call. Like we might, because I would probably want to look at some documents and dates. But yeah.
Absolutely. I think that would be great. And Jose, why don't you go ahead and get in touch with attorney Ruby Pars because she's definitely going to help you out. And we also have her email ID, phone number, and website, and that is just on the screen. Yeah, this is the number. 713-589-2085. With the email ID, you can also ask question by emailing her, and that is contact@rubypowerslaw.com. And you can also visit her website, that is www.powerslaw.com. So, Jose, go ahead and get in touch with attorney Ruby. And till the time, if you haven't subscribed to our channel yet, and also make sure to get in touch with us as well and subscribe to our channel now. So, I think, Jose, you got your answer. And in case if you have any follow up, then please go ahead and ask another question. We are here for another half an hour and we will take your question again. So, Ruby, I think let me take up Shokat's question now. And
Mhm.
Shaukat is saying, I'm a current student on an F1 visa and I'm looking at options after my STEM OPT expires. So, could you help me understand the possibilities for transitioning into a work visa that doesn't require a lottery? Or is there something else I should be looking at?
I think we covered a lot in the presentation at the beginning, so maybe you answered your question since you asked this. It also depends on your nationality, and if you have a spouse, what their nationality, and like what other options there may be. Like we said, the E2, the L, the O, TN, H3. You could also go back to school. We didn't mention this, but there is the diversity lottery for certain nationalities. That also is another lottery where you're trying to stay away from the lotteries here. But I just wanted to mention that one because I didn't talk about that. There's also the religious worker R1.
Yeah.
There's some of those other ones, or if you invest, there's also some creativity happening where, like, I mean, this might be too creative, but like if you get a visa, if you can get a citizenship in another country that qualifies for the E2, for example, and then wanting to, or it qualifies for the TN, or something like that. So you can think about those types of things as well. And while people are waiting out to come back in potentially, or if you're running out of status here, there's a lot of nomad visas that are around the world that can give people options to temporarily live in other countries where maybe they're working remotely for an American-based company, potentially, I don't know, but there may be the individuals want in their home country, whatever their goals are, So really thinking outside the box is another thing when you're exploring alternatives as well. So hopefully some of that helps, but doesn't take the place of a consult. But yeah, there's exploring those options are important.
That's right. And I think thank you so much, Ruby, for putting up that. And Shaukat, also, thank you so much for asking this question. In case if you have any follow up or want to know more about the topic, then please feel free to put them in the comment section. We will definitely take them up. And also, Ruby, as you mentioned about remote work and nomad visas. So I think let me also deep dive into this question that with remote work as it is becoming very common after pandemic especially, so how useful are visas like B1 or digital nomad visas for people who don't want to work, who don't want to go with H1B?
Well, you mean so it's really important to be careful about whether you're physically located in the US and you're using the visa that doesn't allow you to work. So I'm not talking about that, but what I'm saying is like if an individual, let's say they're running out of, I don't know, H1B time, and someone they didn't get petitioned, or they're running out of F1 and OPT time, but they still want to stay relevant and in touch with like a US based company. Potentially, they could go work abroad, either like purposely, like with the foreign company's location, the company's foreign location in 1 year in the last 3 years, so they can get transferred over on an L, or maybe they just go work on the nomad visa, a nomad visa somewhere. You know, I think they're popping up everywhere. Um, Still working for the company, but they're not physically located in the US, so they don't have to have US employment authorization. But like what I've seen almost all the time is that you need to be in the US to build the connections with the US employers, to have somebody who knows you, to have some reason that they want you particularly, because there's it's when you see a lot of different resumes, but and they're trying to choose from one person to the next, it really can depend on having that like that little extra connection as well. But
That's
if they know that they can keep working together, but maybe you're in another country on some type of temporary visa where it's legal for you to be over there, but you're still working for the US based company. Also, could be possible you're working for the US based company and you're in the perm process too, and that that you're temporarily abroad waiting for more of a long term solution for a green card potentially. So it's a very mobile world, and just sort of have to think creatively. Um, but you also need to have an employer that really wants you to. So that unless you create your own opportunity and have your own business potentially.
That's right. That's wonderful. And also, Ruby, as you mentioned about that, it is also important to build up connections and to have a good networking, right? So you are an expert. So there are another question also that our viewers mostly ask that how can they build up a better connection or have a better contacts? So if you could also give us a brief about just a little guidance, how can they have a better connection to US employers or people those who want to get in touch with the US people?
Yeah, that's a good question. I think it can go different ways. Like it could be making a connection on LinkedIn, standing out somehow and trying to make a contact. I think it helps if you're a friend of a friend or something like that, where you're like, so and so said we should talk, or I'd love to make a connection with you. I think that warms things up and opens the door. If you're able to come to the US on like a B1, B2, whichever what your intent is, and you can go to some conferences or have some meetings, that aren't necessarily work, but you can make some connections, and then that can help start the conversation in the future that could carry through on over LinkedIn or Zoom and phone and things like that. I think that's why it's so valuable for those who've gone to school in the US, on an F1 or a J1, or temporarily even on exchange of some sort, because they've come to the US, they've made a connection, they've built up a little bit of a network, and that is helpful. But if you don't have that, then you got to work a little harder in different ways. Like maybe it could be through a webinar, or through mutual contacts putting you in touch, um, LinkedIn, or just reaching out to somebody and see if they'll respond. Those are just going to conferences. Those are some of the things that come to mind as well.
Yeah, I think that's brilliant. And, these are the things that needs to brushen up through and through, because most of the time our viewers forget about these, small pointers, and then they just get in trouble. So I think, Ruby, that was really important. And thank you so much for shedding light on those. And I think till now you have covered a lot of things. And I think let me go ahead with Jadav's question here. So, hi Jadav, and thank you so much for putting up your question. He's saying, I'm currently on an L1 visa, and while it's a great option, that's right, I'm wondering if there are any other alternative for someone in my position who wants to stay in the US long term but has a unique set of skills.
Yeah. So I think we covered a little bit of that in the presentation part, but usually if you're on an L1A, you're going to want the company to petition for your green card within those 5 years so that you don't run out of L
Mhm.
time unless you can recapture it. And that's usually your manager or executive of a department or individuals, and you can show how essential you are. The L1B, it's the perm process, and that can take a few years. And so you don't want them to wait too long to start that up because you want to make sure that you get it moving. If there's an audit, that could delay you some time. And unfortunately, and you really don't have a lot of control over that. Um, but it can happen. So the L1A and the L1B, they are a natural pathway to a green card.
Mhm.
But if you're saying, but they are dependent on the company being playing ball and being involved in that. So if they don't want to, or they get to it late, or you don't like the terms or whatever, if you have a unique set of skills, it could be an O1 or a national interest waiver. Those are the things that come to mind right away. Now, again, the national interest waiver is a green card process. You don't have to be in the U.S., but if you could take the control of that in your own hands, you don't have to have a job offer. So let's say the company is not wanting to do a perm or the EB green card process for you. I don't know which L you are, but then you want to take control of your destiny with a national interest waiver, or even potentially an O as well. So those could be some options. Again, we're just talking hypothetical without having more details, but that comes to mind as an answer.
All right, that's great. Okay, so thank you so much, Jadav, for your question, and hope you got your answer. In case if you still have any follow up, or want to know more, then please go ahead and put them in the comment section, and we will definitely have a lovely conversation on that as well. So don't hesitate and put them right on there. And also, I would like to say, Ruby, with your permission, we do have some of our viewers in Facebook as well. So I think, should we take up those questions as well if you're comfortable?
Yeah, yeah. I've got maybe another 10 or so minutes, so we can take some questions. So sounds good.
Okay, that's great. Okay, so Control, if you could please share the screen. All right. So this is the question we got from anonymous participant, and it is, me and my husband are both Sudanese. I am a U.S. citizen, and my husband is currently living in Egypt. We recently got married through Sharia law, but we haven't traveled to see each other. So we don't have any pictures together. Unfortunately, we have a marriage certificate. Okay. Due to current circumstances, I'm not able to visit my husband in Egypt. So is there a way I can still submit the I-130 form without having to travel? I'm desperate for help. Any piece of advice, please help. Thank you.
Okay, so without me checking some things online, these are some of the issues you have to work through. Um, this sounds like this was a proxy marriage. I don't know if they were physically together when the marriage happened. If it was a proxy marriage, um, well, according to the law, I'm trying to remember if it's a regulation or where,
Mhm.
um, the relationship has to be consummated. So anyway, we're getting into some complicated territory if you physically cannot. Um, so let's just go back a second. Was this a proxy marriage, which means that you weren't physically at the same place when the marriage was officiated? That's going to cause more complications. Okay. And then the other one is that is the law of the land that where it was officiated, is that legal? Is that the way you have a legal marriage? So those two things, and then plus the fact that you haven't seen each other in a while,
Mm-hmm.
those things are issues that I would my issue spotting brain is bringing up. Um, so if any of those are going to be an issue, then it probably is not safe to file the I-130. And I will say that when couples haven't seen each other for a while, I see the USPS and the State Department give a really tough time. So I think you might want to try really, 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 really hard to go see each other and
Mm-hmm.
make sure it's legal wherever you officiated it without me knowing that off the top of my head. Um, and um, and I mean that's just the bare minimum, right? The other aspects are, commingling funds, photos, leases, taxes, all that other stuff. But I'm just trying to issue spot like the crux of the legality of the relationship. So anyway, I that's definitely a consult situation because the you have to look at the reciprocity and the Foreign Affairs Manual and things like that about the laws of the country that you officiated at. So it can get complex. So
That's right. I think, of course, those pointers are very great. And Ruby, I think we are definitely going to share with our viewers about the pointers, and I'm sure they will get their, solution in a better way. So let's move ahead with our next comment that we got. And Helen is here. Helen is saying, "Hi everyone, my employer applied for my H1B in January and I got approval last month. I applied for change of status for my spouse from F2 to H4 with the I-539 form online 3 days after my employer filed my H1B. So currently, the I-539 form is pending. I received the receipt notice for the I-539 form online in the account, but never received it in a mail. So is it normal? Will they send the receipt notice through mail for form I-539? I checked the address I put in there and it is correct. Anyone experience the same? Please let us know. Yeah.
well, okay. If they're sending it through USPS, I mean, it's been known to not work all the time, right? If you have an attorney, which I think you do, the attorney might have gotten the notice. So check to see what they got, because
Yes.
that's one of the benefits of having an attorney is that you get a copy and they get a copy. And if there is an email loss, that you have it in both places. I think there was a lot of change happening in the last few months with the change in administration. So it's quite possible that something went awry. But there's also, you can call USCIS and say you didn't get the notice and see if they'll send it to you again
Mhm.
after they confirm your address, all of that type of stuff. And sometimes when people just somehow the apartment number or the suite or the whatever, a drive or road gets taken off and or a zip code, and it could be a clerical error that has nothing to do with you or your attorney.
Mhm.
So those are just some things that come to mind, but it can happen.
That's
Um, I could
that's
probably take one more question if it's brief. So
Okay, that's great. And I think this was really important. And we are definitely going to share with Helen that how much it is important to have in touch with attorney. It's not only for Helen. I would suggest that, friends, it is a very tough time right now. And I think it will be great if you can directly get in touch with the attorney. So here are the contact details. As below your screen, you can see it is moving continuously throughout the show, the email ID, the contact number with the website of attorney Ruby L. Power. You can get in touch with her and also have any question or any issue if you're facing. You can directly share her on the contact number that is 713-589-2085, and the email ID is contact@rubyparslaw.com, and the website is www.rubyparlaw.com. So this is the contact detail, and with that, I think let me go ahead and take up another question that we got from James. So he's saying, "Hi everyone, our PD of Form I-130 is on September 21, 2013. That is F3 category, married son or daughter. Petitioner is US citizen. So until which month can we expect to be approved? Please guide. Thanks.
Oh, well, who knows the answer? You go to the Visa Bulletin and you put on your thinking cap, and then um, you didn't tell me what country. You
Yeah,
didn't,
country it wasn't
yeah,
mentioned.
it
Mhm.
was not mentioned. So, um, okay, Mexico. Okay, oh, Mexico. Okay, so, and then you said, could you put the question up a little bit higher, bigger again? So you said third preference, unmarried. So Mexico, third preference. For April's calendar, the final action dates for Mexico, third preference, they're working on January 2001.
Mhm.
So about 12 years away from your, and the same for dates of filing. So they're about 12 years away from
Mhm.
the date you just said, um, if it is in fact Mexico. So you just have to go to the Visa Bulletin every month and watch it. Again, it could move. A lot of times, things move really quickly in October when the fiscal year begins, and they clear out some cases. Sometimes people get green cards other ways, or they decide not to proceed, or they're not eligible, what have you. So and do remember, like this doesn't if the individual is staying in the United States, it doesn't make them eligible to be in the U.S. just by having an I-130 pending. You need to have some other visa to allow, or you could be outside, preferably outside of the country if you don't have status. And so these are just things to consider, as well as making sure that you don't overstay or work illegally, things like that. So it is unfortunately going to take a while, especially if the country of origin is Mexico.
Mhm. Okay. Okay. All right. So let's move ahead with the next comment. And the next comment that we have got is another from anonymous participant. Is about last April 9th, 2025. My USC husband received an email saying USCIS has taken an action on our case. Till then, we did not have any further updates. We checked our document tab, but there's nothing there. PD was January 13, 2024. I am worried as it is already 15 months and I have seen a lot of approvals around our PD. So, what could it possibly mean?
Is this an immediate? This is an immediate relative I-130. I did just
Mhm.
that's only a couple weeks ago. Um, I if this is an immediate relative I-130 spouse, I did, or even just immediate relative, I did get an I-130 approved for something I filed in January 2024 just recently. So, um, I mean, you could check again online. You can call the 1-800 number, but you're probably going to get something in the mail soon. You're probably going to get something because it's been a couple of weeks. Maybe it's or they're just still thinking about it. But yeah, keep an eye on that. I think you're in that time where it's something you should get something soon.
Oh,
So, but I'm glad it's moving. That's good. Well, I appreciate you having me on today's show. I have to hop off to do some more immigration things, but hopefully this helped with answering some questions, and because there's a lot of changes going on, and I'm glad I could be a resource for everyone on today's show.
I think, yeah, that was absolutely great. And we are really honored to have a show with you, Ruby. It was my first time that I'm connecting with you. And I really enjoyed. I mean, I didn't know that you were, this energetic and this great in answering the questions. So I really loved it. And hoping to have another show with you. And soon we are going to connect again. But that's okay. You can continue with your work. Of course, we know how busy your schedules are. So that's completely all right. And thank you so much for joining us again. And it was really a pleasure having you and have a great day.
You too. Thanks, everyone. Take care.
Thank you, Ruby. Thank you so much. Have a great day. Okay, friends. So those who have joined us, I think it was really great having you guys. And Jadav, Shaukat, Jose, and Seema, thank you so much for being here. In case if you have any other doubts regarding our today's topic or anything, if you're navigating any complexities in your immigration journey, then please go ahead and get in touch with Attorney Ruby Pars. The number is 713-589-2085. And you can also email her on the email ID contact at rubypowerslaw.com with the website www.rubypowerslaw.com. And till the time, friends, that's it for today's episode. I hope that you liked it. And if you have liked watching this webinar, then make sure that you like this. Also, share this with someone who really needs to know about the alternatives of the H1B visa. And most importantly, don't forget to subscribe, because by subscribing it really motivates us, and we obviously come up with amazing shows and amazing attorneys every week so that you can get more and more information. And also press the bell icon so that whenever we come up with any new video or any new webinar, you get the notification and you directly come up and participate in our webinars. So, till then, thank you so much, everyone, for being here. Stay connected, stay empowered, and don't forget to like, share, and subscribe to Immigration Talk Show. Meanwhile, I'm Sam signing off for now.
Hello and welcome everyone to Immigration Talk Show. I'm your host Napasa, and I have a very interesting webinar lined up for you. So stay with us before we have our guest for today join us. I have this very important disclaimer to read out. So, folks out there, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, with that in mind, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, X, and also on Instagram. So, check us out, connect with us, and don't forget to subscribe to our channel at Immigration Talk Show. Hit the bell icon so that whenever we have discussions, you can also join us and ask your questions. Better even, this could be like an opportunity for you because we have these amazing immigration attorneys join us where you can get immediate answers to your questions. Yes, friends, and that's it. Today we are going to discuss about 100 days in, how the Trump's campaign return is already shaping US immigration. So we are going to speak at length about this today and touch up on many things. Of course, we know every day that there have been a lot of changes and a lot of things that are affecting and shaping the US immigration. So stay with us, friends, and let's explore this today. So today's guest is a very, very amazing managing attorney, Ingrid Boris Perez. And she's an accomplished immigration attorney with a passion for helping immigrants on her legal journey. Yes, friends, because she was also born and raised in Brazil, Ingrid personally experienced the immigration process when she moved to the United States herself at 9 years old. And this first-hand understanding really fuels her commitment to providing empathetic and effective legal representation. So, without further ado, please help me welcome her once again to our show. Hi, Ingrid. How are you doing today?
Hi, Napalsa. Nice to see you. I'm doing well. Thank you so much for having me.
Thank you so much for joining us. Good to see you. And yes, your new office seems all set now.
Yes, it is.
All right. Lovely. So, very interesting topic we've chose to discuss today. What would you like to tell folks out there to expect from today's discussion?
I think people should expect, a lot of information. It is a lot of moving pieces, a lot of moving parts all the time. There is always something new in the world of immigration these days. sometimes it's hard to keep up. So, I think that it's important for people to understand that, um, it may seem by design. There are a lot of changes, and that is where the country is going, and we have to learn to adapt to it.
Absolutely, we have to. There's no other option, friends. We need to learn the changes, keep ourselves updated because we cannot give an excuse that we didn't know about it. We just have to know everything about it, especially that we are immigrants and all the rules and laws apply to us. So that said, friends, you can also join us in this conversation by commenting wherever you're watching or dial this number to join us on call. And the number is 425-436-6335, and the access code when they ask for it is 988-888. Join us. So, Ingrid, with that, I have my first question. Now that President Trump is back in office, and we have already seen his first 100 days when it comes to immigration priorities. So, I mean, would you like to highlight some of the most important ones that we saw in the last 100 days? Hey, Ingrid, you
Goal
mentioned.
is the
Sorry, we lost you a little bit. Could you just go
Yes,
for
can
it?
you hear me?
Yes, yes, we can.
Okay. So I think what stands out in most people's minds is, and the things that people are seeing every day is the level of enforcement, immigration enforcement that we're seeing. Of course, we were anticipating enforcement at the border, sending the National Guard to the border, promising to rebuild the wall, and using the military to enforce entries or prevent entries at the southern US Mexico border. Those things were expected, and I believe a lot of those things are happening. Border crossings have come down significantly. So those things have started to take effect. The other piece of this that is most in our faces, I think, is the internal enforcement that we are seeing. Obviously, there's a lot of videos and a lot of news out there about people getting um, stopped by ICE, arrested, and placed in deportation proceedings, or being removed outside of the United States. We see a lot of that as well. And also enforcement for people who are here in United States with status. So we see people who have student visas or even permanent residents who are being detained and placed into removal proceedings as part of the internal enforcement, internal immigration enforcement. So we see a lot of that as well. I think, though, that it's important to keep in mind that, the numbers are also something that people should be, aware of because, according to, I think, some reports by ICE, the data that is reported by ICE, the number of deportations in and of themselves have not increased. The numbers have stayed relatively steady. It's just that the targets and the people who are being enforced, immigration is being enforced, is changing. I think it's just more in our faces, these stories that we see every day. So there's a lot of that going on. I think another thing that has changed significantly is the humanitarian protections for immigrants, right? So limiting asylum access, terminating TPS and other humanitarian routes. These things are things that are being litigated in court. So there's a lot of changes in that area, but that is something that the Trump administration vowed to do and something that they, pursued for sure. And of course, I think the one sort of change or one sort of priority that stood out the most and happened earlier in the administration was the attempt to end birthright citizenship. I think that is a significant step in enforcing and changing immigration policy. Of course, that is not in effect right now. The Supreme Court will hear this case in May. So we're waiting to see what happens with that.
Absolutely, yes. Thank you so much. I mean, yes, you brought us those great and important highlights. throwing back to Trump's 100 days already. I know how time flies, and it feels like he's been here for quite some time now because we've seen so much happening, and every day is an interesting day with new updates, new things in how we're catching up. And how's it going with you and your law firm, by the way, IBP law firm?
I think for us, we're trying to stay in our lane in the sense that we are sticking to what we know. Of course, there's a lot of interest in immigration services, and different ways to navigate different issues. We are sticking to what we know best: employment-based immigration, family immigration. Of course, we have to stay updated on all the changes to make sure that our clients are getting the best representation. And it's what we always have done. It's how we operate. And I think, this time around here in the office, in the first few months, it was very stressful, very difficult dealing with all the changes. But, like anything else, we get used to it. We're resilient. We care about the clients, and we're going to do everything we can to, you know, take care of them and make sure that things work out for them.
Absolutely, yes. Always. And we'll sure hear one of your stories very soon. But before that, also, Ingrid, if you can tell us, have there been any executive actions or policy changes so far that, are directly affecting visa holders?
Yeah. So, in the beginning of the Trump administration, I mean, I know we're only, we're barely 100 days in. It's still the beginning, but I think in the very few days, there were many executive actions or executive orders that Trump signed, asking the various agencies, the various departments within the Department of Homeland Security and within the government to review policies and make recommendations. So those things, I believe a lot of that is still going on, and we're waiting to see what a lot of those recommendations are going to be. There is, a policy of America first, and I do anticipate that visas like TN or H1Bs and Es, we're going to see some different policies and different recommendations as well in regards to those visas. To I think the Trump administration goal is to protect US jobs, American jobs, and revisiting policies around those specific visas to see which recommendations that the administration would choose to adopt. We also have, TN specifically will be looked at, I believe, next year. The agreement between the United States, Canada, and Mexico is set to expire, and there will be renegotiations around that as well. So I expect some changes in the TN visa category as well.
Sure. I mean, I think all we can expect are more changes every day. That is what is happening. And I think by now, the people of America, the immigrants, and everybody in America are ready. They are ready for all the changes that are being thrown at them. So let's get on it, and more changes on TN as well as expected, so we'll look for it. Friends, if you are here, don't forget to subscribe to our channel for more updates and the latest updates on US immigration. Our handle is at Immigration Talk Show. Check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram. And also now, hi to Sakshi, by the way. Hi, Sakshi. Thank you so much for joining us here on YouTube. We will take up your question very soon on this show. Just stay with us. So, Ingrid, I was saying, we really wanted to know what kind of cases are you seeing most frequently in your practice lately? And what challenges are people facing in those situations?
Well, happy to say that, we've seen a lot of H1Bs, a lot of EB2IWs, a lot of O1s for individuals who maybe were not selected in the lottery for the H1B. I'm seeing definitely an increase in interest in e-visas, which is great. I think that there's an interest still in people who want to come and invest in the United States and who want to live the American dream. We focus mostly on employment-based immigration. So those are the kinds of cases that we're seeing. And I'm glad that, people still want to come here, employers still want to hire, and it's great.
It is. All right. Perfect. Then thank you so much for sharing that with us as well. Any specific case you want to share that's coming to your mind, or something that's different?
Yeah, absolutely. So I'll share actually a good story. About a couple of weeks ago, we had a family of five in my office, and they got their green cards through the EB2 and IW category after waiting for, I think, like almost 2.5 years. So it was a really great moment. It was a family of five, a couple and their three kids who have a business in the United States, and they were able to really build that business and create lots of jobs. And the business was a great addition to the economy. And finally, their green cards arrived. They did not get an interview because really these clients did everything perfectly. And also, I think they were very lucky. Things worked out for
Yes.
them. And they got their green cards. And it was so wonderful to see that happen. And it felt really great. And then just yesterday, we got another family based green card approved. This was a marriage based green card application, and it was approved without an interview. So that was surprising because we were expecting practically all cases to be called for interviews, all clients to be called for interviews. And I definitely see more interviews, happening. But it was a nice surprise to see that these two specific cases were approved without interviews. So that was really nice, and I'm sure that the clients are all relieved.
That is so wonderful. I mean, yes, like you said, we are expecting more interviews. We were expecting these RFEs, but lucky for these two families that, they could make it so easily, really. So I think this is a shout out to all friends out there that, that you can also get lucky. Don't think too much. If your documents are on the right path, on the right place, all updated, there's nothing really to worry about. So I think best is always to consult with an immigration attorney for your case so that you're guided on the right path and see how easily you can come through it. Yeah, and why not contact attorney Ingrid Perez herself? You can call her on her number 407-906-0068, or go email her at info@ibplaw.com, and definitely go visit www.ibplaw.com. So that is, those were really amazing stories. Thank you for sharing, Ingrid. And yeah, surprising because at least, with all the news, we were not expecting that,
Yeah.
but lovely, really lovely to hear. So,
I think you have to share the good news too, right? All the approvals, all the conquerors, and all of that. I think it's important to share those as
very
well.
important, yes, because it gives out hope and a positive side. People sort of they feel very anxious right now, and when you say stories like these, makes them hopeful.
Yeah.
Yeah, and well, now if you can tell us, have there been any updates or trends in how NIW petitions are being reviewed?
This is my favorite topic. I love talking about NIWs.
Go ahead.
so I think the last time we talked about NIWs exclusively, and we were talking about the different, the new policy guidance that came out January of this year. And and in talking with other attorneys and seeing trends and doing our own analysis of trends internally, we definitely see that immigration has shifted, right? Some people may say that it is, they're moving the goalposts, right? And I do agree with that sentiment quite a bit when it comes to EB2 and IWs. So now we are learning to adapt and anticipate these goalposts being shifted. I think that over the last month or so since I've talked to you, there's a lot of people who contacted my office with RFEs, requests for evidence, on I-140s for EB2 and IW that they either filed on their own or with another law firm, and they were looking for help to respond. And I've been collecting these RFEs for quite a while now, just so that I can have my own database and look at these. And I see that immigration is, definitely looking for broader impact in a person's endeavor. But what does that mean, right? Broader impact, really, I think in the eyes of immigration today for the EB2 and IW is how strategically, how will your endeavor benefit an important strategic interest of the United States? How is it going to help make America number one on the global stage? How is it going to help an industry in the United States be number one on the global stage, right? So, and I'll give you an example, a micro and a macro example, right? A micro example could be, perhaps you are an engineer, or maybe you're a specialist in your field, and you were able to do a project or solve a problem, right, that maybe nobody could solve, and you were able to do it very quickly. And you set sort of a new standard now, right? Even if you were doing this on a project or for your employer, well, that is significant, because now you are having a broader impact in the field, right? And you could come to the United States to have that same impact in the US field, right? So in the US engineering field, you can come and you have this special technique, or this technique that improves a certain process. So that is how, on the micro level, right, an EB1A may work. On the macro level, right, by virtue of you coming to the United States and helping the US industry or the US field become more efficient because you're introducing this new technique, it will help the United States become a leader on the global stage in that specific industry. So I think that for EB1A petitioners or self-petitioners, it's really important to understand what immigration is looking for as far as the impact is concerned. Now, I know that not everybody, will be submitting petitions with attorneys, but if you want to understand how to perhaps argue your case, right, you have to show immigration that the problem you are solving is going to help the United States become a leader. It is going to help the United States be number one, right? We're talking about American exceptionalism here, and that is what the United States is looking for in EB2 and IW petitions. So we've still received approvals with EB2 and IWs. Of course, we're getting RFEs as well. But that is what the focus should be. I think also, it's important to be very strategic with these filings, not dump everything at USCIS, at the officer who's going to be reading your case. Really be strategic and focus on maybe 1 to 3 points, right? 1 to 3 arguments of how your endeavor will help the United States. That is how we're approaching these filings right now, and just trying to make them leaner, more succinct, and really just, to the point of exactly, driving the point home that we really want the immigration officer to come away with.
All right. There you go. Thank you so much, Ingrid, for sharing that with us. And we should definitely speak with Sakshi and reply to her comment as well. So let's take that quickly. Sakshi, hi again. She's saying, I've heard rumors that Trump campaign plans to tighten the eligibility for green cards, especially for workers from certain countries. As an immigrant who's already been waiting for my green card for a while, what could this mean for my application?
Well, I think that, we heard, well, during Trump 1.1, we had the Muslim ban, where people from certain countries were unable to come to the United States, and a lot of people were affected by that. We do have reports as well that Trump is putting restrictions on certain countries, although that has not been official yet. And I think the New York Times was reporting something like there was a list of like a three tier list, a red list, a yellow list, and maybe an orange list of countries. I don't recall exactly, but if you were on the red list, then these people would now be allowed to come to the United States. People on the yellow list, or the countries on yellow list, had to have heightened scrutiny, and maybe the countries on the orange list had to, abide by some requirements from the United States in order to have their citizens be able to come to the U.S. So I have not seen anything that is official yet. However, I do have clients from, the countries that were mentioned on those lists that are worried, right? They're worried because they're in the process, they're in the immigration process, and they're worried of whether or not they won't be able to, actually complete their immigration process during this administration or until this ban is lifted. So I think as of right now, there's nothing official yet. This was, something that was reported in the New York Times, but I think it's definitely something to watch and something that people should be prepared for. And not make, if you're outside of the United States, don't sell your house, don't sell your car, wait until you have that visa on your passport so that you can make that transition more confidently.
Right, right. Very, very good advice, I would say. A good tip because we need to make sure, be 100% sure first and only then move forward, especially big decisions like, your properties. So thank you so much for that, Ingrid. And now, Sakshi, thank you also for your question. If you have any more questions, please feel free to comment. And folks, you can also join us on call. The number is 425-436-6335, and the access code is 988-888. Join us. And hi, Bhargav. Well, hi. We got another question, so we'll quickly take that up as well. Bhargav is saying Trump's immigration crackdown to target 2 million undocumented individuals with criminal records or final removal orders via large scale enforcement actions and workplace raids. Does this policy mean that? I think Bhargav is still typing. But what would you like to say for this first part? Anything, Ingrid?
Yeah, so this is a very ambitious goal. I think it was reported somewhere that the goal is to deport 1 million individuals, 1 million undocumented people a year, which is a very ambitious goal. It will cost the United States a lot of money to be able to do that. So, I think I think people have to be mindful of what they hear or see as headlines on the news and what could actually happen, like the real logistics that it is required in order to make this happen. One of the things that has been said recently by the Trump administration is that they want to expedite these or make these removals faster, which is why they are removing people to like El Salvador, for example, without giving them the opportunity to have their case heard in court. And of course, there's a lot of controversy around that because our entire American system of justice is based on this idea of due process, right? So right now that is being challenged in the courts. And I believe that there is a pause right now where the Trump administration cannot deport people this way. And if you think about it logistically, to deport 1 million people a year requires a huge operation. At the same time, the Trump administration is removing, firing judges and limiting the size of the judiciary and immigration courts. So, it becomes very difficult to achieve this if the infrastructure is not in place. So at that point, we run the possibility of having these actions that bring a lot of shock to the population, right? And that is challenging court. And I think makes it harder for them to achieve this goal. So I think it's really important to keep that in mind. I think I mentioned earlier that the numbers that have been reported by ICE and Customs and Border Protection, as far as the number of people that have been removed, have not changed significantly from last year. And that is, enough, that is in part because removing people from the United States requires an infrastructure, and our infrastructure, our immigration removal infrastructure, is not great. And I'm not talking about detention centers. I'm talking about judges. I'm talking about cases in immigration court that have been lingering for years and years and years. Asylum applications that have been also pending for many, many years. Just a system that is completely broken and operates, by mail. And it's very difficult for people to navigate the system. So, that is the infrastructure that I think, any administration should focus on if they want to make immigration more efficient, if they want to resolve the problems of our current immigration system. The things that we have going on today doesn't meet the needs of today's society. And I think that's very important to understand.
Absolutely. And we got the second bit of Bhargav's comments, where he's asking, does this policy mean that anyone who has committed even a minor offense, such as a misdemeanor, could face deportation? Or are there specific criteria for determining which crimes make someone eligible for removal?
So this is a great question. Under the Biden administration, Biden did issue a set of priorities, of enforcement priorities, which really allowed, immigration enforcement to focus on a specific subset of individuals who were in the United States that that the prior administration had identified as removal or enforcement priorities. Right, people who had convictions, criminal convictions, those were the priorities. Trump did away with those Biden priorities, and there's no real, understanding with Trump other than everybody is on the chopping block. We still have crimes that make people removable from the United States, right? That make people inadmissible, meaning that if they have those convictions on their records or those activities, they aren't able to get a visa or unable to get permanent residency. That has always been the case, But what we are seeing is, and especially what is being reported, is that, there is greater enforcement now for violations that are relatively minor, that may not fit within these crimes of moral turpitude, or these crimes that make people eligible for certain immigration benefits. Those violations are also being, people with those violations are also being targeted. And of course, there has been lots of reports of people with minor traffic stops, or traffic citations, or misdemeanor convictions that have been targeted. And I think it's really important for people who are permanent residents, people who have green cards, if they have a criminal conviction of any kind, speak to an immigration attorney before you leave the United States, because there's been a lot of reports about green card holders being, detained at the border because they have money. Important to keep that in mind.
Yes, absolutely. And also, I hear people are facing sort of some difficulties, coming back into the US again if they have stayed way too long outside, maybe in their home countries. Would you like to say anything about that as well?
Sure. Sure. Yeah, and that's happened to a few of my clients as well. I mean, and sadly, a lot of my clients, even those, even green card holders and naturalized U.S. citizens, are calling us and asking, hey, should I be worried? And my advice is, any, for a green card holder, any non-citizen, anytime you leave the country and you re-enter, you are asking for permission to come back in, right? Obviously, if you're a US citizen, the US has to let you in. If you're a green card holder, they will generally let you in, but if you have something on your record that flags more, secondary inspection, they will take you to secondary inspection and ask you questions. I think in that situation is really important that people have an immigration lawyer's card available in there if they're ever in that situation. It's also really important that people do not sign anything at a port of entry unless they know exactly what it is they're signing, because Customs and Border Protection can have you sign, or can ask you to sign, a document where you are abandoning your permanent residency, and you don't want to do that inadvertently. And I'm not saying this to spread fear or anything, but really just to spread awareness that you can say no, right, to signing anything, and you can ask to speak to an attorney first, and it's very important to know that you have those rights. So I think that for people traveling as well, it's important to have your documents in order. It is important, if you're a permanent resident, to maintain your residency in the United States. You don't want to be spending a majority of your time outside of the United States, because that could, cause a CBP officer to conclude that you are trying to have it both ways, that you're, just coming to the United States temporarily to keep your green card. So it's really important that you maintain your physical presence here, file your taxes, do everything the right way, be a good citizen, so that you can become a US citizen eventually and not have to worry about this anymore.
Okay, okay. Thank you so much, Ingrid, for taking that up as well. And thank you, Bhargav, for your question. We also have Ganesh join us, so let's take that up as well, Ingrid. This is about J1. So I'm on J1 visa right now, and I've been told that Trump administration might impose new restrictions on certain visa holders, especially in sectors like tech and healthcare. Could these changes affect my ability to stay in the US after my program ends?
Well, it depends. It depends on how you're looking to stay in the United States after your program ends. So, for example, assuming that you're not subject to the 2 year home country requirement, of course, right, where a lot of J1 visa holders are subject to the 2 year home country requirement, and later on you want to switch to H1B or an O, or maybe you meet a US citizen and you decide to get married and get a green card, right? So it just very much depends on how you're planning on staying here in the United States. But if you're specifically thinking about tech and the healthcare sector, right, I think it's important to review the priorities of the administration, in these specific fields, and how they perhaps, are being advanced, right, through immigration policies. So in AI, for example, right, there is an executive order or an executive memo that talks about the importance of the United States advancing AI, right? See, look into that, because that is something that may affect, immigration policies. Again, we're still within the first 100 days of the Trump administration, and we're waiting to hear these recommendations that Trump ordered all departments to make, right, to revisit the policies and things like that. But can it affect certain sectors? Absolutely, right. So, in part of Donald Trump's platform is to keep America competitive, right? Keep America as a leader in the world stage when it comes to different industries. And if technology and healthcare, if those are areas that, the United States has a priority in, then I think,
Yes, for sure, Ingrid. Thank you so much for taking that up as well, and um, thank you, Ganesh, for your question. And folks out there, please feel free to join us with your comments. And to all those of you who resonate with our content and whatever Ingrid has been sharing with us, her expertise and knowledge, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So, Ingrid, can you hear us now? We lost you
yes.
a bit. Yeah, I'm so sorry. We lost you a bit. But if you want to add more to Ganesha's question, you may.
Oh, I'm sorry. No, I was just going to say that I think that, there's still a lot to be seen. I'll just wrap up by saying that we're still waiting for those recommendations for specific sectors, but I think it's always important to kind of know where the priorities are of the administration, because I think that will inform a lot of immigration policies as well. So just, be on the lookout for that.
Okay. Thank you, Ganesh. Thank you, Ingrid, for your question. Thank you, Ganesh, for your question. And thank you, Ingrid, for taking that up. So, Ingrid, also wanted to know if, because are we seeing more requests for evidence, RFEs, or denials in employment based immigration cases under the current policy?
I think in the world of self petitions like EB1As and EB2NIWs, EB2NIWs, definitely, there has definitely been an increase in requests for evidence, especially out of the premium process, office. I think that if you're filing a case, premium process, expect an RFE. So I think in those fields, we're definitely seeing an increase in requests for evidence. Um, those are discretionary benefits. And because of the recent policy guidance changes, applicants are adapting, attorneys are adapting, and I think the USCIS officers who are learning, to navigate this new guide are also adapting. We are seeing a bit of, inconsistent requests for evidence where, perhaps newer requirements are being created, right, where they don't necessarily exist in a law. So I think it's important to, keep in mind and be strategic on the responses, right? And if cases do get denied, which they have been getting denied as far as EB1As and EB2NIWs, and the demand for EB1As is also very high, and those cases are very difficult. I think that, it's important to keep in mind the options, whether to refile or, do a motion to reopen and reconsider. I think that the industries that are perhaps, or the individuals, professions who are perhaps hardest affected by the new guidance are people in the IT industry, software engineers. These individuals, I think, are having a harder time convincing immigration, to approve an NIW, just because of the new policy guidance. And of course, what happened over the last, couple of years since 2022, where there was just so many people applying, or so many people submitting petitions in this category. And there was I think now we're going through a period of recalibration in these types of visas.
Right, right. And you were saying about new things that they are asking for. So biometrics is what I hear. And another one is addresses, their home addresses, even for H1B applicants only. So would you like to highlight anything on these lines, or if it's already started, the practice has already started?
I think, for employment-based visas, it's very important for employees and employers to stay compliant and on top of, these cases as much as possible, because there has been announcements that there will be more in-site inspections, confirming that the individual is working at the location, that it's a bona fide job offer. I think it's very important for employees, people on H1Bs and different work visas, to keep their documents with them, organized in a safe place, make copies of everything, keep everything stored in a really safe location, keep track of dates. Keeping track of dates is incredibly important, especially if you're here with family members and maybe family members came to the United States after you, keeping track of their dates as well, because you don't want to inadvertently or, unintentionally miss a deadline. No, I always tell people, put on your calendar, that your status expires, in 6 months, so you can plan and have enough time to figure that out. I think that's also really important. And any travel plans need to be discussed with your attorney. I think that's also very, very important in this world.
Yes, yes, absolutely. Thank you so much, Ingrid, for highlighting those very important points to keep in mind. And yes, friends, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And you can also check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So check us out and join us now to ask your questions. All you have to do is comment wherever you're watching, or call us on this number 425-436-6335, and the access code is 988888. So today, friends, we are discussing on 100 days in, how the Trump's campaign return is already shaping the US immigration. And we have with us none other than attorney Ingrid Perez. And yes, it's really nice to have her here, to explain to us and shed light on all these questions that we have for her today. So thank you once again, Ingrid.
You're
And
welcome.
we do have more questions, so we will address them. But also at the same time, I would like to tell you that we will take up some of our Facebook questions that we receive in our group. So, Control, please display them soon. But meanwhile, Ingrid, if you can tell us also, how have visa interviews and consular processes changed, if at all, since Trump resumed office?
The biggest change that has happened is the interview waivers, right? During the prior administration, a lot more people qualified for interview waivers. And now a lot more people have to have interviews at US embassies and consulates abroad. So that has been the biggest change for sure. And, one thing that I would also add is that in certain countries, we're seeing a lot more scrutiny for employment based visa applications, where the embassies or the consular officers are refusing the visas and sending the petitions back to USCIS for reconsideration. So I think that for any person going to an employment based visa interview, whether that is an immigrant visa or a non-immigrant visa, it is very important to be ready to discuss your case, be ready to talk about your qualifications, where the job is going to be, the work that you're going to do, and how you are going to be able to actually do the work, right? So I think it's really important to prepare for the interview and be ready to talk about the work, your profile, your background, your resume. All of that is very important. So you don't run the risk of the consular officer having doubts about the petition that USCIS approved and having it sent back to USCIS and refusing your visa. I think that's very, very important to prepare.
For sure, yes. Thank you so much, Ingrid, for telling us that as well. And I hope that people out there, folks out there who have joined us, all viewers, I hope you're taking notes and keeping in mind as well. So, yes, if there is anything we can help you or assist you with, with answers, do comment. And yes, our handle is at Immigration Talk Show. Subscribe and ring that bell so that you will be notified whenever we have discussions like these. Right. So, Ingrid, let's take up some of our Facebook questions now. So, this is saying, my friend's I-140 got denied recently at first attempt, even without getting an RFE. Has anyone got this experience? Any chance to be approved? EB3 unskilled.
So that has never happened to me, but I know that that has happened before. I would tell your friend to look at the reasons why the petition was denied and see if they can do a motion to reopen or reconsider. It's kind of hard to say exactly without understanding the reasons for the denial. You know, if for example there wasn't an RFE, are you sure there wasn't an RFE? Because a lot of times USCIS does send an RFE, but maybe you never get it in the mail, or the employer, the petitioner, never gets it in the mail. So it's very important to monitor these cases, because if you don't receive the RFE in the mail, right, it's like you never got an RFE, but it was actually sent over. So it's important in those situations to contact USCIS and make sure that, you know, if you see on the case status website that an RFE was issued, then you actually received the RFE. So double check that. But yeah, so I think, you know, keeping in mind the dates on the denial and the dates, the deadlines to file a motion to reconsider is really important in this situation. You know, it's hard to say without understanding exactly the reasons for the denial.
Right, right. It is happening. So thank you so much, Ingrid, for taking this up. And now let's go on to our next one. This is from an anonymous participant. Hello. Usually, how long the process of I-130? My husband is my sponsor for my I-130. He applied that was last year, August. Thank you.
So the I-130 is an immigrant petition for the family category, assuming that this husband is a US citizen and the person is outside of the United
Mhm.
States. Unfortunately, these cases are taking a really long time. The processing for an I-130 petition by a US citizen spouse for a foreign spouse who's living abroad is incredibly long. Even on the USCIS's website, it's saying that it's something like 3 months or so, which is insane, right? Compare that to if a person is here in the United States, and it's a spouse petition by a U.S. citizen for a foreign national who's physically present in the United States. That case can go significantly faster, especially you know, in a situation where the foreign national is also filing a concurrent green card application or an I-485. I've had those cases get approved relatively fast compared to just how the I-130s are taking for spouses who are outside of the United States. I have a lot of I-130s that have been pending for longer than a year. And when we do inquiries with USCIS, there's nothing we can do because according to the normal processing times, these are taking some 30 plus months, which, you know, it's really unfair for a couple that, you know, to be forced to live apart from each other for that long. It's really difficult on the family. You know, so I can imagine how difficult it must be for this person as well. Check the monitoring, check the case processing times, make sure that you're always on that website. And as soon as you're able to submit an inquiry as to why the case has been going on longer than it's supposed to, you know, make that inquiry.
Right, right. It sounds very interesting and sad at the same time. And with all this, I mean, this whole, process, this long wait, I mean, relationships also could see many changes because of the challenges that they have to stay distant from each other, right? Ingrid, has it ever happened to you?
That's
Do
right.
you have any cases like that?
Well, I've had cases where, U.S. citizen is filing for a petition for a foreign national, and then their relationship doesn't work out, because the distance is so it's difficult. I mean, things like that happen, right? That's unfortunately it does. But it does create such a strain in the couple, right? Especially for perhaps one person who's trying to, you know, go back and forth, usually the US citizen who's going back and forth between the US and the spouse's
Country.
country to make sure that they maintain that relationship and to see each other. It's really difficult. And flights aren't cheap. Travel's not cheap. It's a huge financial strain.
Yes, true, true. Thank you, Ingrid, for highlighting that as well. Now we'll go on to our next question. This is also from an anonymous member saying, hi everyone, I'm currently on H1B. Control, if you can zoom in a little bit, please. I'm currently on an H1B and recently transferred roles within the same company from a product manager position to a software engineer role. I made the move assuming it would be a smooth internal transition, but I've now realized that an H1B amendment should have been filed before switching, since the roles are quite different. And has anyone been in a similar situation? Did you have to face consequences, or were you able to fix it by filing the amendment after the switch? Any guidance or suggestions would be greatly appreciated. Trying to stay calm and figure out the best next steps before talking to HR or anybody legal.
So this is a situation where legal should have been, brought in before this change for sure, because the H1B is tied to the position. I mean, even if it's within the same company, product manager and software engineer, those are two completely different job titles. And I'm going to, go out on a limb here and assume that they have completely different job descriptions, job duties. So for sure, an H1B amendment should have been filed before the switch. In this situation, there may be an able to save this person's case by doing a non-protunct request. And I would say speak to the attorney as soon as possible and bring this up to his or her attention to get this resolved, because you want to make sure that you stay compliant with your H1B.
Right. Right. Thank you so much, Ingrid, for taking that up. And anonymous member, I wish I knew your name, but thank you for your question. Let's go on to our next one. Vignesh is asking, when can I expect my PD to become current? EB2 India, May 2015.
I wish I could tell you, but I can't. Um, you know, we'll see if we have any jumps in the new quarter, of this year, and we'll see if we have any jumps in fiscal year, next fiscal year, October 1st. But I'm sorry, I wish I could give you an answer. I don't know.
Yes. Sure. Thank you so much, Ingrid, though. And folks out there, Vignesh, also please do not forget to subscribe to our channel and hit that bell icon so that you're notified whenever we have updates on this as well. And we really look forward to visa bulletins every month. So let's hope for the best for you. All the best. Now we got another anonymous participant asking, if F1 student decide to change it E2 in the middle of the degrees, will it have a negative impact during the interview?
Um, I think like any other change, like I have a lot of individuals who change from tourist or B2 status to E2. Based on this question, I am assuming that the person is going to apply for an E2 at the consulate abroad, so they will be going to an interview. I think that it is, expected for the immigration or the customs. I'm sorry, the consular officer to ask questions around the F1 students' activities. To make sure that they weren't inadvertently working without authorization or anything like that in the E2 company. I don't necessarily see a problem with this because if you have been maintaining your non-immigrant status, you're now just switching to another non-immigrant status. I don't see a problem with it, though. We live in a different world now, so it's very important to be prepared. If you're doing an F1 change in the United States where you're just changing your status with the USCIS, you're probably not going to have to be going to an interview abroad, and this change can be approved by USCIS. However, if you then later on decide to get an E2 visa, you should be just prepared to provide evidence that you were maintaining your status, and all of that, so that they don't refuse your visa for those reasons.
Okay. Thank you so much for taking that up, anonymous, and also anonymous participant, for your question. I think with that, we have definitely covered all of our questions from our audience, Ingrid. And also, I did have a couple more questions. So before we leave, if you could actually give out some legal tips that you give out to families or individuals out there who are waiting on green card approvals during this period of change.
Yeah. The question that I get asked most often after we file a visa application or a petition or a green card application is, what's going on with my case? Once we file a case with the immigration authorities, we don't know what's going on with the case. Immigration communicates with us by mail, right? We can't see, unfortunately, behind that wall where the immigration cases are being handled to know exactly what part of the process you're in, right? But I can generally explain that, first a case has to go through the normal background checks. Under the current administration, there is, more extreme vetting. So these cases probably will take longer, the further in we go. So just expect the cases to take long, and not there's not much that can be done to make things go faster. So I think it's important to have patience and understand that the government operates on their time and not on our time. Immigration is slow, it's bureaucratic. It's important to be patient, so just so that you can maintain your sanity. And that's maybe not so much legal advice, but just more, personal advice, so that you maintain your sanity during the process, and not go crazy waiting for when things are going to happen. However, of course, on the flip side of that is if a case does go beyond what is typical, right, then there are ways to address that as well. But for the most part, I think it's important to just, you know, remain updated on the case, make sure that, you track expiration dates, communicate with your attorney, especially if you're moving, update your address with immigration. That is very important. Carry your documents with you, especially now where, we're seeing a lot of domestic enforcement. It's very, very important for people on H1Bs or green card holders, anybody here on an F1 visa, to carry proof of their status with them. That is incredibly important.
Yes, extremely important points. Thank you so much, Ingrid, for highlighting them. And I hope you've taken down those tips, friends, before we ended our show. So I think I can only say thank you so much, Ingrid, for your time and for sharing your expertise and such important updates and information here in today's session. So it was really lovely having you here with us today.
Likewise, thank you for having me.
Thank you, Ingrid. And folks, do not forget to contact attorney Ingrid Perez herself if you especially need a one on one consultation with your case. Her number is 407-906-0068. And you can also email attorney Ingrid at info@ibplaw.com and go visit ibplaw.com to get to know more about attorney Ingrid Perez and IBP Law. So thank you so much once again, Ingrid. Have a wonderful day. I hope to see you soon.
Thank you. Likewise.
Sure. Folks, you can also join me or ask me your questions. You can write to me. My email address is nipa@staffingly.com, and you can also call me on my number. This is also my WhatsApp number. My number is 408-335-6444. And I hope that you really resonated with today's session, with Attorney Ingrid Perez from IBP Law. It was really lovely having her. Don't forget to check her out. She's there also on LinkedIn, and check us out. We are on, well, not just on YouTube at Immigration Talk Show. Do not forget to subscribe to our channel. Share this handle also with your friends and family who could benefit most, because we come up with the latest updates on US immigration. So please share this and ask them to like and share as well. So, yes, check us out. We are on Facebook, LinkedIn, X, and on Instagram as well. Thank you once again, everyone, for joining us. But stay tuned because we got some really amazing webinars lined up here on our channel, and you would not want to miss out on these latest updates and great informative sessions that we have. So yes, we do have more joining us. So we do have Deepika Gupta, who's going to join us very, very soon. Dr. Deepika Gupta at 9 a.m. Eastern Time. We also have Ms. Attorney Uma Mantravadi joining us at 3 p.m. Eastern Time. So check them out and stay tuned here on Immigration Talk Show. Bye for now. Hello, everyone, and welcome back once again to Immigration Talk Show. I'm your host, Napasa, and I have another very interesting and insightful session lined up for you. So stay with us. Yes, and before we head on with today's discussion, and I have our guest join us, I have this very important disclaimer to also read out. So, yes, friends, by watching our videos, you agree and understand that the information shared by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind. And also, welcome once again to Immigration Talk Show, friends. It's going to be very, very interesting because we are going to have another very insightful discussion. And yes, this has been creating actually a lot of uncertainty and concern in the recent months. If we look back as well, border issues or visa delays and sudden changes at US consulates worldwide. So all of these things are what we're going to discuss today. And if you've recently also faced some sort of unexpected questioning at the airport, long visa wait times, or are even confused about shifting policies from CBP or consulates, you're not alone. And you're welcome, very much welcome, to ask your questions, to clear your doubts. And you can do so by commenting wherever you're watching, or join us on conversation on call. And do that by dialing this number 425-436-6335, and the access code is 988-888. So, yes, without further ado, to help us unfold today's discussion, please help me welcome Attorney Justin Rivera, Senior Immigration Attorney at Boston Immigration Litigation, based out of Houston, Texas. And Justin always brings a wealth of experience and deep commitment, to helping individuals and companies successfully in immigration maze. But also, it's always great having Justin here with us because his insights are really very helpful. So hi, Justin, once again, and welcome to Immigration Talk Show.
Hey, thanks a lot for having me. It's good to be here.
Yes, same here. So I'm looking forward. I know sometimes we don't have too much of good news to share with all of our audience, but these are important points and we really need to mention. So Yes, today's discussion on the topic trouble at the border, what CBP, visa delays, and consulate changes mean for you. So I think it's only obvious what we can expect, but do highlight some points so that people out there stick with us.
Yeah, I think it's imperative moving forward as we've kind of got we've gotten through the first quarter of the year, right? We're pretty much moving into the mid part of the year, and we're starting to collect data. We're starting to have information that's going to give us an inclination as to what to expect over the next 4 years. And I think that most of that data has led to the conclusion that what you can expect is a more aggressive approach when it comes to immigration in the United States. And that's going to be applied across the board. And that means USCIS will probably be more stringently adjudicating their cases. CBP will be more stringently reviewing people for inspection and admission, and the consulates will be, utilizing the enhanced vetting to more heavily scrutinize applications for visas. And so I think across the board that's already been seen, and it's gonna lead to a need to educate and prepare individuals for all aspects of immigration, not just the filing at USCIS. I think the days where you can just send someone abroad and confidently know that they will come back into the U.S. are gone. I think that's just how it is. And to just anecdotally mention it, so to give you guys an understanding of kind of what we're dealing with right now, I actually this morning had an individual who got a visa, an H1B visa, issued to them on, I believe it was the 11th. They picked up the visa on the 11th, I believe, at the consulate in Hyderabad. And they went to travel yesterday. And while they were traveling, they were stopped in Qatar and actually told that they could not board their plane because their visa had been canceled. Now, this visa was only issued 6 days ago, and it was approved by the consulate. Between that time, when it was approved and when this individual traveled, the consulate canceled the visa, did not notify the individual why the visa was canceled, and gave the individual no opportunity to respond to an issue or provide additional information. He had no idea whatsoever that this had happened. Now, this is the first inclination of this that I've seen, but according to him, when he was in Qatar, when he was at the airport, he was actually stopped by individuals who basically took him aside and waited until members of the U.S. Embassy actually came. And those individuals told him that he couldn't come in. What was really ludicrous about the whole situation was they could not explain who canceled his visa or why his visa was canceled. There was nothing. There was no paperwork provided. There was nothing communicated at all to this person. He was literally just told, you can't travel into the U.S. on that visa. They turned him around and had him leave. So that's the kind of world we're living in presently. And I think people need to be aware of it and prepared to deal with those issues. Now, this person I truly believe will exist as an outlier. At least that's my hope. But we'll have to kind of wait and see. But I do want to kind of give you that personal story about something we've dealt with very recently that highlights what it's like traveling abroad right now.
That's crazy. I mean, if the person didn't even know why he had to go back, he doesn't know. I mean, what about the situation now? Even now, there's no real.
So they told him to contact the consulate for an explanation. Now, what's interesting about that is it is very hard to get someone from the consulate to speak with you while your visa is being reviewed. After your visa is approved, it's darn near impossible. You can't just walk into a consulate and say, hey, I have a visa that got canceled. Can someone talk to me? You're not going to get into the consulate without an appointment. And so we are corresponding or attempting to correspond at this time with the consulate to obtain some sort of information. Now, the caveat to all of this, truthfully, is before his visa was issued, he was someone who had one of those SEVIS termination emails.
Mm-hmm.
And at the time, our thought process was, well, that's in relation to his F1 visa. It has no bearing on the H1B. Otherwise, it would have been brought up at the consulate when they were doing his interview. My thought initially is, hey, maybe the officers were wrong. Maybe they thought the F1 being revoked, the F1 visa, somehow played into the H1B, also somehow being revoked as well. That's possible, but it doesn't make sense. Like there's not a justification for that. Like it's not logical to say that, oh, that F1 student visa, which by the way was actually withdrawn at the port of entry because of this case. I won't go into the further specifics of it, but it had actually already been withdrawn, this visa. So when the SEVIS termination happened, it actually canceled or revoked a withdrawn visa, which makes even less sense. All that is to say, we don't have a justification. We're trying to get one from the consulate. I will let you guys know, like next time I'm on, what the conclusion of that is. But I think at the end of the day, the problem is you've just inconvenienced this person. Like this person now has to very likely go to another visa interview, hopefully get issued a visa because they already had an issue getting it given to them the first time, and then travel again and hope that they can come into the United States. And by the way, just to put a button on the end of this individual isn't somebody who works at, a 7-employee consulting company or one of these employers that the Trump administration clearly is targeting in regards to H-1Bs. This person works for a university. They work for a prominent university. And the fact that that person is now incapable of returning to their employer at that university because of this mix-up, it's ridiculous. But I think it is telling in that we'll see a lot of this kind of stuff happening over the next couple of years.
Sure. I mean, we just have to be ready for anything and everything, friends, and also be prepared. I think the best way possible with all the documentation, right? But still, we don't know what can happen. Let's just hope that we are lucky and pray hard. I think that's all we can say for now. But let's come to our discussion for today's topic, friends. And yes, I do have questions. And quickly, I'll just say hello to Yuri. Hi, Yuri. Thank you for joining us here on YouTube. We are going to take up your question very soon, but stay with us for now. So, Justin, we've really heard a lot about these secondary inspections lately, and if you can explain what they are and why travelers are increasingly being flagged for them.
So, yeah, I think secondary inspection. So, just to explain what secondary inspection is, when you come into the United States, you go through CBP, right? CBP has the authority to inspect you and ultimately grant you admittance to the United States. Now, most people's inspections are brief. It's a couple questions, maybe none, and then you're flagged in. Look at the docs, say hi, where are you going, where are you working? That's it. You come in. Others, typically people who have a flag in their immigration record. Maybe something like they've worked with an employer that's previously been flagged, or they work in a contractor situation where they work for an end client. Maybe someone who has been in the U.S. for a long time on one type of visa and then has moved to another visa and is then coming in. It's a litany of justifications that are now being utilized. But by and far across the board, when secondary is invoked, it's because there is allegedly some information that is displayed on CBP's data hub that leads them to believe that they can ask additional questions. Now, I think before the administration change, that CBP secondary inspection was something that was more readily available for kind of outlier situations, circumstances where maybe there was a clear flag that was placed by FDNS, who is USCIS's fraud detection agency, in relation to a case, and the person's taken into secondary in question for that. Now, we're seeing it used with a much broader scope, and secondary inspection has been utilized now on, visa holders, legal permanent residents, and there's even been occurrences with U.S. citizens being taken into secondary inspection, which is really interesting because a U.S. citizen can't be denied entry to the United States. but they're still taking them into secondary, which is, it's odd. But once you're in secondary inspection, you are there for as long as they tell you are there. Meaning,
Mhm.
if they want to hold you for 2 hours, they can. If they want to hold you for 8 hours, they can. And during that time, they have the ability to review any of the electronic devices that are on your person and any of the information that you have on hand, physical copy of a resume or something like that.
Mhm.
So I think before, most of the time when you had someone traveling into the US, the thought process was you got your visa. Let's say you're on an H1B. You got your visa, you got your approval notice, you got,
Mhm.
your an employment verification letter saying like, we need this person to work in the US. You're good to go. That was before. I think nowadays people need to be prepared for the thought of CBP having deferred inspection occurrences with way more regularity. And unfortunately, we've heard about certain ports of entry specifically that have more aggressive CBP officers than others. I specifically would highlight Atlanta, the airport in Atlanta, who we've gotten reports of officers doing really questionable activities. Anyway, once you're back there with CBP, they have access to everything you have on your person, and they're gonna, ask you any questions related to anything in relation to your immigration record. That could be, previous H1B, previous F1, your current H4. Anything is on the table. Now, I would be kind enough to CBP to say that before the administration change, the only people they were really hounding on were people that they thought that they already had issues for fraud, like fraud finding issues, and they were basically just trying to get the person to admit to the commission of fraud or misrepresentation so that they can put them in expedited removal. Nowadays, I think that they are more aggressively employing intimidation tactics with the end goal of trying to secure more expedited removal orders to make their immigration records look better. That's my personal opinion. Now, the reason for that is to go around and deport people that are in the country illegally, you have to find them. And it may not be that easy to actually find people that are actively hiding in the United States. Someone that comes in through CBP has to be inspected and admitted. They avail themselves to the officers. So if someone's right in front of them and they think that they have a way to get that person removed or cancel that person's visas, I kind of think that's the way they're going to behave presently. And I think we've seen that play out with a unfortunately high level of frequency over the past few months. And that's really it. I mean, that's kind of all of it in a nutshell. It's unfortunate, it's disheartening, but I think it speaks to the anti-immigration desires of the present administration.
Right, and it's happening. So, friends, whatever you've been hearing is true. And I know this is really bringing up a lot of different mixed emotions, rather. People who had dreams to come to America, they're now rethinking rather, or maybe routing out to different countries as well. That's what we hear. I mean, I'm just saying it from the news. So, yes, that's there. But anyway, yes, friends, traveling is still on, but do make sure of your plans and see that, yeah, I think all your documents they need to be on point for sure. And now let's go on to my next question. What specific categories of travelers, whether students, workers, or visitors, should be most concerned about being questioned by CBP upon entry?
So I think that students engaged in OPT and STEM OPT, I think, should be very cautious over the next few years with travel in and out of the United States. Um, I don't think it's any secret that Stephen Miller, the proponent and architect of the Trump administration's immigration policies, Stephen Miller does not like that the F1 students have work authorization. They, take the stance that that work authorization is unnecessary and that after individuals complete their studies, they should either, transition to another visa or depart the United States. Basically, once you're done studying, you should go. You should leave. It's ridiculous, obviously, because the United States benefits from highly educated individuals remaining here and working, and usually a lot of those people transition to an H1B. But those individuals, I think, they're definitely being targeted at a significant rate. H1B holders who work for traditional, bigger organizations, like really, your Metas, your Googles, all that stuff. Those people seem okay. The people who I think are seeing the biggest pushback are people who work in contractor situations, people who work at third-party client locations. I think those individuals have been getting pulled aside in secondary more. There is a really big. I've just seen this from several cases. There has to have been with CBP some sort of internal memo or something issued about verifying somebody's placement when they're working at a third-party location. And that's either, through them producing a client letter or producing the name and, the contact information of a person that can verify their placement at the location. I think those are the individuals that I've seen with the biggest level of pushback. And that all being said, there's also been individuals who've come in on B2 and had their visas canceled. I think there was a very big public hubbub recently about some European kids who were trying to go on vacation in Hawaii who got their visas canceled because they admitted that while they were in the US on B2, they might actually do some work for their client that was, in Europe. And they said, that's not the purpose of the B2 visa. Your visa's canceled. So they will look at everyone across the gamut. But in terms of the general people that I think have the biggest risk in travel right now, I think it's the F1 students that are here solely subject to work authorization and the H1B holders at contractor companies.
Right. Well, thank you so much, Justin, for that detailed explanation. And folks out there, thank you for joining us. Hi, Jay Bhatt. We are going to take up your question very soon. And please feel free to comment, whatever questions you have. We are going to take them very soon. Also, don't forget to subscribe to our channel. Our handle is @Immigration Talk Show. Also, check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Follow us, subscribe to us, and stay connected. So, yes, I think let's go on to the next question that I have for you, Justin, is why do some immigration experts suggest that returning to the US should be treated like attending another visa interview?
Because it has the potential to be, honestly. When you go to the consulate for your visa interview, generally, the officer's trying to affirm at the consulate that the statements and facts within the petition are accurate and correct, and that the individual will utilize the visa within the parameters of what the visa is for. Perfect example that would be, if you're applying for an H4 and you go, what are you going to do while you're on the H4? And you say, oh, I'm going to go, in the United States and I'm going to live with my spouse. Are you going to work? And you say, yeah, I'm going to work. Well, you have to have an EAD to work. So unless there's some level of clarity there, saying, oh, I'm going to work once I have an approved EAD or I have an approved EAD, you might be operating outside the confines of what the visa allows, which is a problem. So that traditionally was something that you dealt with at the consulate. And at the consulate, they have the opportunity to review any of the information that you submitted in the DS-160. The DS-160 can ask if you've ever overstayed your visa. Have you ever been violated your status? Have you ever had a visa canceled? So all of those things are grounds for scrutiny. Before the new administration came in, that was all done at the consulate. And then once you came in with CBP, and you would hear of the very extreme outlier individual situations where CBP deferred inspection led to an expedited removal. And it would almost always be a dead to right situation where, FDNS has basically clearly established some sort of fraudulent activity in relation to the company or the individual. They come in, they put them in secondary, they procure a document, or they get an omission that, oh yeah, I did something that was fraudulent. You go through expedited removal. Now, because they have really augmented the purpose of secondary inspection to encompass previously, unthought of scenarios or issues. Now you have secondary inspection being used almost like an opportunity to do another visa interview. It's another opportunity to, say, use an H1B, for example, go through the petition, but not only the petition, the individual's immigration history in the country as well. And that's something that I think people need to realize as the kind of new reality. Now, the difference between the consulate and CBP is obviously when you go to the consulate, most of the time your interview's 10, 15 minutes. Outlier situations, they might take you into another room to ask you a couple additional questions. But by and large, it's a quick thing. It's a fast process because the consular officer has 40 other people to see today, so she's just trying to move people through. Secondary inspection is not like that. Secondary inspection is intentionally slow. It is an intentionally drawn out process. The reason for that is the CBP officers are basically trained to utilize making an individual uncomfortable, with the underlying purpose being that you're going to want to avoid the situation you're in. And eventually, if you're worn down over a certain amount of time, you're just going to give up. And you're just going to say, all right, whatever, say whatever you need to say to get out of the circumstance. And that difference is important because it really highlights the fact that by and large, the consular officer, they're going to be looking at you and saying, okay, I'm going to try to adjudicate this fairly. We hope. CBP, just based on what I've listened to over the past couple months, I am not giving that kind of good faith to anymore, especially in certain locations. I think the desire is more actively to cancel visas and have people removed. And that's why I think now the consulate obviously getting your visa is important, but if you have any of these factors that have been highlighted so far, a previous overstay, a violation of status, a problematic employer in your work history, anything, a speed bump, a ticket, an interaction with the police, any of that needs to be prepared for, because when you come through CBP, they can, and in this current day, very likely will raise it as an issue.
Okay. Well, there you go, friends. I hope you're taking notes. And thank you so much, Justin, for that detailed explanation. So, we should take up some of our questions from our audience since they've been waiting. And let's go ahead and take up Yuri's. Yuri is asking, if my visa is delayed because of changes in consulate policy or new procedures, do I have to recourse? Can I appeal or request expedited processing to mitigate the impact on my situation?
So you can request an expedite of your visa appointment under certain circumstances, and those circumstances are country specific. Generally speaking, an expedite request is for something like an extreme humanitarian justification. I think off the top of my head, in Canada, you can expedite for a humanitarian reason or for a work-related reason. Like an example being, I am on an H1B. My employer needs me in the U.S. by, June 1st. And if I'm not there by June 1st, I'm going to lose the work opportunity. I'm probably going to lose my job. So there are ways to expedite the appointment. Now, once the visa interview has occurred, if you're placed in administrative processing or your passport is taken and they're saying, we're going to issue the visa, if your case is being held up, there are very limited things that you can do. If you're in a 221G, you turn over the documents and information that they ask for, and you're placed in the queue to wait. Sometimes you can move things along if you're able to show that you have urgent travel. Like for example, I had a client once who the consulate had their passports for, I think we'd been going on 10 to 11 days, and they had tickets showing that they needed to travel because it was almost New Year's, and they were trying to get back to the U.S. And so I sent the tickets in to the consulate. I said, look, can we do this for them? Like, we need to move them along. And they did issue the visas the next day. They gave them back passports with the visas and everything, and they came in. Outside of those kind of certain outside of those avenues, it's generally hard to get your case expedited. So yeah, I think for the most part, it'd be proving imminent travel, the need for imminent travel, and then you have to have proof. You have to have actual proof, meaning airline tickets showing that you're going to be traveling, and consulates will typically be sympathetic to that. Outside of that, there's really not much more you can do.
Okay. All right. Thank you so much, Justin. And Yuri, I hope you got your answer. Thank you for joining us. Don't forget to subscribe, friends. Our handle is at Immigration Talk Show. Check us out, and also check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. All right, so now let's take up Jay's question. Jay is asking, what if CBP holds my documents at the border for more than the standard amount of time? Should I be concerned, and how can I get the legal assistance to resolve this quickly?
So there's not really a standard amount of time in terms of secondary inspection. And remember, this goes back to the idea of a delay tactic. There is a benefit to the officers in making you uncomfortable and having you wait for long periods of time in between rounds of questioning. Makes anybody irritable or scared. If your devices are seized by CBP, they have two things they can do. They can do a quick search, which is where they basically have you unlock your device and they look through the device. Which they're going to kind of maybe go through your texts, look at your emails, something, WhatsApp, whatever. So that's kind of usually the route that's gone when it's like you're put in secondary, but they don't really have anything concrete against you to actually have a finding placed against you that'll get your visas canceled and get you revoked. The other method is an enhanced search, and that's where they basically have technology that they can use to look through your devices for specific documents or information. I don't have a perfect understanding of the way the system works, but my inclination and what I've gleaned from others is that they basically will look for certain words, because they already have a preconceived notion, and then they're just looking for what they want to get the proof, the definitive proof. So one thing that they're big on is the idea that someone paid for an H1B employment. And so what does that mean? That means you paid the H1B employer in return for them to sponsor your visa, or you paid for the filing fees to USCIS or the attorney fees. So they'll look for paid H1B, paid attorney, paid job, and they will look through your devices to see if there's anything that comes up that reflects that information. What they're looking for is the dead in the water, the silver bullet. They're looking for, is there a text that says I'm paying this in return for this, or is there an email that says something like that? And then can they use that document to work backwards against you and say, hey, we have this and you said it, like you clearly said it, so you did this, right? And that's what they'll use to cancel your visa and put you in expedited removal. So those are the different ways in which they do the search. Now, either way they do it, they're not going to do it quickly. They're going to be very slow. I think we're looking nowadays at a traditional secondary inspection being 2 hours long. And the purpose of that, again, is to make you uncomfortable. But I think it's very important to remind people that in order to have your visa revoked, during a CBP inspection, have your visa canceled, it requires you to either make an affirmative statement to them that you have done X, whatever offense it is that makes you inadmissible, or have them procure evidence that establishes that you did X, which leads to you being inadmissible. Absent of those factors, they have to grant you admission to the United States. An example that I will give is I had someone who went through, I believe it was Logan Airport in Boston, Massachusetts. They went through Logan Airport and they were in secondary inspection for 5 hours. and they were there for 5 hours. They said they spoke to 3 different officers and 1 supervisor. And at the end of the day, even though they were told repeatedly, we know you did this, we know you committed visa fraud, like just confess and everything will be okay. He said, I stuck to my guns. I had talked to me, the attorney beforehand, and I knew what was true and what wasn't true. And I just, kept reiterating the truth of the matter, and they had to let him in. And he ended up being admitted to the United States. Now, have I subsequently told him, hey, maybe don't travel for like 3 years? Yeah, I've absolutely told him that. But I say all of this to tell you that there isn't traditionally a way for them to do these kinds of things without justification. There has to be a basis or a rationale to the decision making that's made. So while it is frustrating that there's this increase in secondary inspection, I think as long as an individual has been prepared thoroughly to understand what the process looks like and what to say and what not to say, not because not saying it is withholding the truth, but because you're not saying something because you're not trying to avail yourself to information that could lead to a problem. I think that's all important. I think that's why it's really important to either, speak with the employer before you're traveling or speak with an attorney, just so you have that opportunity to be prepared in the event that this happens. And so I hope that answered your question competently. Yeah, and how can I get legal assistance to resolve this quickly? It's a good question, and that's the real big issue with going through CBP. You're not entitled to legal representation because you haven't been admitted to the United States. So yes, you can present evidence of representation by an attorney, but then you're at the discretion of the CBP officer whether to invite that, whether to allow that. And I would say by and large, they're not going to do that because they don't want to get an attorney involved, because they know that once the attorney comes in, it shuts down a lot of the intimidation factors that they are dependent on to get the result that they want.
Right. Well, there you go, Jay, and thank you so much for this very interesting question. Thank you, Justin, for taking that up, really. And now I think we should take up generics as well. Hi, generic. I'm sure that's not your name, but I wish I knew your name. Anyway, so for H1B holders already in the US who are petitioning for a second term, 3 more years, that is there anything that they should be concerned about?
Yeah, I mean, not in terms of travel, obviously, generally speaking, but if you're just talking about filing a USCIS extension, yeah, I think you should be concerned with an increased rate of RFEs, just to be blunt. You're probably looking at a significantly higher risk than during your original petition's approval of getting a request for evidence, probably for specialty occupation, if not for something else. But yeah, I think really that's it. I mean, you're just probably going to be looking at more RFEs. The idea that there was going to be kind of like a big surge in site visits for H1B holders hasn't really occurred that much. I don't know if it's my honest belief is that they're waiting until after quota, after H1B quota, so after the end of June. I think from July to September, the end of that, I think that's where you're going to see a bunch of H1B site visits occurring, because because I think what's going to happen is they're going to approve cases and then try to subsequently invalidate them, like basically get cases denied for people, like basically, once the person transitions to H1B, issue a notice of intent to revoke or something like that. That's just theory. That may or may not be true. But for people that are looking at second extensions, I think that, you're probably going to have a higher rate of a specialty occupation RFE. Now, if it's an H1B where it's the same petition, it's a continuation of employment, without change, there's likely going to be less scrutiny on those. But I think that where there are, extensions with change or amendment plus extensions, I do think that there's going to be a higher level of scrutiny on those cases.
Okay. Thank you, Justin, for highlighting that, and thank you for that very interesting question as well, generic. I hope folks out there are taking points because these are very important points that we have been discussing, and Also, Justin, what do you have to say about the latest, that they're asking for biometrics as well for H1B applicants? And that is also apart from address changes, which you need to also update to the USCIS.
Well, yeah, I mean, biometrics are one thing, but as just speaking personally, the AR11 stuff, like we people need to be careful with the AR11 stuff because um, there, I think I saw an F1 RFE that actually just came into our firm a couple days ago, where the person was filing a change of status, and they're basically saying that they never updated their address where they were living, and that their failure to do so was a violation. So that's interesting, but that is to say, I think it's imperative to make sure that you're updating your information. You can't leave any cracks at this point. There can't be
Right.
anything that's left out there that gives rise to the possibility that USCIS can try to claim you were violating status or seek to revoke your visa.
Right. Thank you so much, Justin, for telling us about that also. And now, what would you like to tell us? What are the key documents that travelers should carry to be prepared for unexpected questioning also, or document requests at the airport?
So generally speaking, if you're an H1B holder, I think at this point it should be routine to enter with um, your your petition. You should have your H1B petition. I would have an employer letter that says that you're currently employed and they have continued need of the individual. You obviously need a copy of the approval notice and the visa and all that. You need all that to get in. But the other thing to remember is when you're coming in now, you need to make sure you're aware of the fact that what you have on your person is subject to search. So anything you bring in, particularly that's an electronic, is something that can be looked at. So do you make the decision then to travel without your laptop, and just travel with your phone? Do you make the decision to just travel with your work phone and leave and bring your personal phone in or ship it into the United States ahead of time? These are all factors that I think people need to consider that they would never have thought they needed to consider before. So while it is important to carry certain items, I think it's almost equally as important, if not more so important, to not carry certain items. I've been pretty much telling everybody across the board that I don't think it's smart to travel with your computer anymore. If you do travel with it and you're coming into the U.S., you should ship it in. That way, it's not physically on your person, and that's really across the board. I don't even care if like you were the most squeaky clean person who's never had any immigration record problems. I still would generally give that as a recommendation. So yeah, I mean, really, in conclusion, it's just you need everything that establishes that you're coming in for the intended purpose of the visa. But I also think stuff that's not going to help with that might be stuff you decide not to travel with.
Okay. Interesting points. Thank you so much, Justin, for taking that up. And now, also, if you could tell us, what are some common mistakes that travelers make during CBP inspections that can actually lead to delays or even worse, um, especially denied at entry?
I think people need to be aware that you have to actually stop and think about the things that you're saying, as particularly to the initial inspection officer. And what I mean by that is this: I had a case that I worked on a couple months ago where essentially the person was coming in and they were being asked questions like, like, how did you get this job? How did you get a job with this employer? And he was like, oh, he said something along the lines of like, oh, I was working for a company on F1, and they told me, if I got selected, if my case was selected, they'd file for me, and then I would work for them. But when I started working for them, they would get a percentage of the purchase order. And the officers was immediately like, somehow inferred from that statement, oh, this guy paid for his H1B. And because he's paid for his H1B, we can cancel his visa and put him as expedited removal. He went into secondary inspection where basically no matter what he said, no matter how hard he tried to explain that what he was talking about was the purchase order and how there's a contract between, employer, vendor, and end client, and there's a purchase order, and that the employer takes a portion of the purchase order as payment. That's what he was talking about. In no way was he talking about paying the company for his H1B or the company garnishing his wages in return for them filing his H1B. It didn't matter what he said. They had already formed this conclusion based off of what he thought was a really innocuous statement during that initial questioning that they then worked backwards from to get to the point where he ended up being removed. He ended up undergoing expedited removal. So that's what I mean by you have to be thorough with your question, with your answers, because you need to say what needs to be answered and nothing more. If you're asked by a CBP officer when you're coming in, and you're coming in and they say, hey, where are you going to be going? You should be answering, I'm going to be going to my work or to my house, or, I'm going to be going to, fulfill the obligations of my visa. What you shouldn't be saying is something like, oh, I'm going to go do XYZ, and then I'm going to go on the coast, or I'm going to go over here and do this, or I'm going to go visit my family and friends for a couple days. All that stuff is fine. But when you start word vomiting to the officer, then the officer's looking at you thinking, well, this person seems like they're nervous or there's something wrong. They're behaving in a way that's questionable. We should probably get them put in secondary and see what we can get out of them. So I would say just be prepared to answer the questions purely within the prism of what's being asked. Don't offer up any more information than what's being requested of you, and try to be calm during the situation. I think most people and most times you're going to be okay. But just weirdly, because of the world we live in, we do need to make sure that we are prepared. And that's why I've told pretty much anyone that I do consultations with now about travel, I want you to prepare as if you know you're going to secondary inspection. Because that way, ready and collected during the situation.
Right, right. So thank you so much, Justin. I think we just missed the last line. If you can just repeat.
Yeah, it's the weather. Just in conclusion, I would just say prep to travel.
As if there's going to be secondary inspection.
As if you're going to be in secondary. Exactly. Yeah. Thank you.
All right. All right. So there you go, friends. I think, yes, it's always good to be best prepared and most prepared, but also be prepared for the worst. Have a plan B just in case, so that you're not that heartbroken at least, or you know what to do even if something bad, the worst case scenario happens. Anyway, yes, I think now, Justin, we'll just take up some of our Facebook questions as well before we leave. So, Control, if you can display them, please. Um, so, yes. If you can zoom in a little bit. Okay, this is Alice Anderson. Hey, I've been managing a business that serves US clients remotely for a while, but we never formally set up a US entity. With all the recent tariff issues, the market's been quite unstable and it's impacted our operations. Ironically, that shut slowdown gave us the space to explore the L1A route and consider opening a US office. But since things are slow right now, we don't have active contracts in the US. So we're not sure if that would make the visa harder to get. Do you think it's still worth applying at this stage, or should we wait until the market stabilizes a bit?
So a new office L1A it is an actionable route, but it is very, very heavily scrutinized. The new office L1A, it's tough because you basically have to show that you're coming in to establish this business. What is the plan? What is the model? What are you going to be doing? What is the connective tissue with the foreign entity? How is everything going to be accomplished? And you're basically asking USCIS to either say, yeah, I buy this, or they're going to say, no, I don't really think that's what you're doing. You're just kind of trying to get a visa to come into the United States. And it makes it very hard. We, even at my old firm, we would typically discourage new office L1As, even for individuals that qualified. So in the era of Trump, I think that you are looking at a difficult situation. The L1A by its very nature is it's document intensive. It's very heavy. You have to supply a lot of information. And then when you add into that the fact that you now have to establish that you're opening a new office, it's going to make it more difficult. Do I think you can do it? Yes. Do I think that it's going to be harder to do now than it was even 6 months ago? Absolutely. But it is an option, but you have to have really strong documents. I mean, you really have to have everything ironed out to where you clearly show what the model is going to be, what's the capital that's invested, who's going to be doing what with that company, what is your anticipated hiring looking like, how are you setting things up for that organization and how quickly it's going to grow, and then go forward from there. But yeah, I mean, I think it's possible. If that's something you'd actually want to discuss in more detail, I would actually recommend scheduling a consultation, and then we could take it up in more detail.
Absolutely. And there you go. You should definitely consult with Attorney Justin Rivera, and you can go check out Boston Immigration Litigation on LinkedIn as well. You can find Attorney Justin Rivera. Thank you so much, Alice, for that question. Those questions, rather, the situation that you're going through. And now let's take up this next one. This is from anonymous member. We are currently in the US on L1 visas that expire at the end of the year. I started a delivery business last year and I'm considering changing to an E2 visa. I'm planning to purchase a vehicle and rent a commercial space for a year. Is it mandatory to hire an employee immediately for the E2 visa application in this situation? And what are the advantages and disadvantages of pursuing an E2 visa for my delivery business? Will it be worth having a vehicle and business place? I would really appreciate your thoughts and suggestions.
Yeah, so that's an interesting question, and I've that's funny that this happened because I actually had someone else recently talk to me about an E2, and they were looking at E2 versus L1. I want to take a step back and tell you this immediately. If you're an L1 and you're in the US working subject to an L1, like I assume it's an L1A, you need to be looking at the L1A to EB1C route for a green card. That's I really think the pipeline that you should be trying to explore much more so than I would worry about moving over to an E2 visa. Is it possible for you to move over to an E2 visa? Yes. There's a lot of planning that needs to go into that. And I think that it's going to be difficult for you to do transitioning over from an L1. Is it mandatory to hire an employee after the E2 visa? I mean, I think it's position specific, but the advantages of the E2 are, it's obvious that you have your own business and that's great. But when you have an L1, the L1 is kind of not the gold card, because I don't want to use a Trump term, but it is like the higher tier standard of work visa. I mean, yeah, the O1 is slightly above it, but the L1 is really great because it allows your opportunity. I mean, it allows you, if it's an A, to transition to that EB1C, which is one of the easiest green card pipelines there is. And so, yeah, I would need to look at your case more specifically, but it's weird. This must be something that is like circulating right now on the internet. It has to be this idea of going from L1 to E2, because this is the second or third time this has been brought up to me. I would look at the specifics of your case, but barring a significant change in my current opinion of the E2, I think being on an L1 is the better route 9 times out of 10.
That up, and thank you, Justin, for taking that up. And now let's go on to this next one. This is also from another anonymous member. Control, if you can please display that, please. Oh, sorry, not anonymous. This is. Could you please zoom in a little bit?
This was written by a mouse.
Masahi. Hello, all. I filed my I-140 and concurrently my and my wife's I-485, I-131, and I-765 all at the same time, putting them together in one packet. My I-140 was just recently approved. Are my and my wife's I-485 processed together, or are they processed separately? My I-765 was also approved, and USCIS sent me my EAD card, but my wife's one hasn't been here yet. So Looking at her My USCIS account page, estimated processing time of the I-765 in 38 months. It's stupidly long, it says. So he's wondering whether their cases are going to be reviewed and processed separately, even though she is his dependent.
So they typically run them together, on average. Um, yeah, I mean, typically they should be run together. Your EAD being approved though, and your wife's not being approved is not entirely uncommon, but it can happen. When a dependent's petition gets split off from the primary, it typically, yeah, usually is because there is an issue related to that person's status or previous time in the United States. So, for example, like let's say hypothetically, you and your wife, you've been in the United States, you're filing to adjust status, and before that, your wife was in F1 status, and there was a violation of status for whatever reason. They could split it off and issue an RFE specifically on your wife's application, and that's completely unrelated to yours. So yeah, if it's been split off, that's definitely a possibility. I know that's probably not the answer that you want, but it's very likely what's occurring. The other thing that could be occurring is just that USCIS is stupid, which they definitely are, and they adjudicated your 765 and just forgot to do hers, which could also happen as well. You can usually use the EMA tool to reach out to USCIS to get an update. If you've already done that, you can try calling them to get information. They weren't helpful in the last administration. I've got to imagine they're even worse now. But those are really kind of the only avenues you have to explore, because you can't really proactively submit anything because you don't know what the issue is. So those are really your only options.
Thank you, Justin. Thank you. And I think we just have a couple more and we'll quickly take them up. So, Control, if you can just display that, please. So, anyway, I'll go ahead and take up CL visa. I mean, I'm selected this year in lottery. Uh, So, okay, let's take this one first. Sasi Raj is asking, hi, are people who got into H1B lottery this April this year going to expect calls from software companies here in the US? How will be the IT industry market for new H1B visa holders this October 2025? Can new H1B visa holders expect interview calls?
I don't know what that means. I'm a little confused by what the question there is. If you're picked in the lottery, it's because you had an employer that agreed to sponsor you for an H1B, and that sponsorship is based on the fact that at the time of filing, you have a job offer, a bona fide job offer,
Already.
an actual opportunity. Yeah. So if you get to the stage where your H1B is selected and you're taking interviews, that doesn't make sense. Your employer is responsible for having that work lined up. And if they don't have that work lined up, then that's a problem. Now, alternatively, if I want to paint this in as nice a light as possible, maybe that question is trying to say, I got selected for an H1B with ABC Consulting Inc. And ABC Consulting Inc. is trying to make sure that I have a long-term project to be placed on when my H1B is filed. And if that is the case, and you're saying what's the IT market going to look like, I don't know. I think generally the economy's not looking great right now. I'm just going to be, blunt with you. That I'm just being honest with you. The markets are doing what the markets are doing because of volatility, and there has been a lot of talk in big industries about hiring freezes. And anytime hiring freezes become the commonplace, that they're not adding new employees, especially to bigger companies, that's really the first cost-cutting measure. You're saying, okay, we're going to stop on the expansion and deal with what we have. If you continue down a road where profitability is an issue, the next part becomes reduction. And so, yeah, I think that, look, things could definitely change immediately. We've already seen how the president behaves. Tomorrow he can cancel all the tariffs. Who knows? It's we're really living on the coattails of the whims of a person who makes decisions based on mood. So the tariffs could end up being gone, or they could raise taxes on everybody. We really don't know. But what I can say for now is, if you have a selected H1B and you have a project that's a confirmed project, you need to file. Like, you need to file and you need to get that H1B in and get it approved before all these companies start pulling back on their need for contractors and third party placement individuals.
Mhm. Mhm. Thank you, Justin. Thank you for taking that up. And now this last question of the day is from Sia. I'm selected this year in lottery. My B1 B2 visa was rejected in 2017. Can it affect my H1B visa interview? Can I mention in DS 160 that my B1 B2 was rejected before? Please advise.
Yeah, I think a question in the DS 160 is if you've ever been denied a visa or had a visa revoked. So it's something you have to disclose, because if you don't disclose it, you're making a material misrepresentation and you're not going to
Yeah.
get your visa, and you're going to have a fraud finding placed in your record. So, yeah, you have to disclose it. I think that as long as the rejection or refusal of the visa isn't tied to something that makes you permanently inadmissible, it's not going to be an issue. So, yes, you have to disclose it, provide an explanation, justify what happened, and you're fine. 95% of B2s are 214B refusals, which means that you haven't convinced the officer that you're going to either visit the U.S. temporarily, that you have you have non-immigrant intent versus immigrant intent, or that you haven't shown you have strong enough ties to your home country, which would lead them to believe that you're going to abscond and stay in the U.S.
Mm.
214Bs can even just generally be issued as, like, I don't like the cut of your jib, like, I don't like your vibe, and as a result, I'm issuing a 214B. So if that's the case, it's super common. It's not going to be a problem for you. If it was due to you blatantly making a misrepresentation, then yes, it's a problem. But I would say 9 times out of 10, no, it's going to be fine, and admit it. The last thing I'd give you guys before we get off the call: don't try to hide stuff from consulates. You don't know what information they do and don't already have access to. The government has a system that connects CBP to DHS. They share information. Assume that if one entity has it, the other entity has it. The worst thing you can do is lie and then get caught lying at the consulate, because then you will get a permanent ban to the United States. So, yes, in conclusion, yes, bring it up.
Yes. There you go. Thank you so much, Justin, for taking all of these questions from our audience and from me as well, so patiently, and for all the information you shared. I loved this conversation we had today. So much good information and important information from your end. So, thank you. And maybe if you have any end notes or tips or anything you want to say to everybody watching us right now before we leave.
No, I'm good. I got to get a drink of water. I've been talking for like an hour straight. It was a pleasure having me on. Thank you very much.
But thank you so much, Justin. Yes. Have a great day ahead and see you soon.
Yeah, you too. Bye.
Bye bye. Folks out there, if you do need to have a one-on-one consultation with attorney Justin Rivera, you can also call him up, and his number is 844-592-7366. You can also email him at, sorry, I'll repeat the correct phone number. It's 844-592-7336. And the email address where you can get in touch with attorney Justin Rivera is support@wasden.law, and go visit www.wasden.law to get to know more about Wasden immigration litigation. And also, don't forget to check them out on LinkedIn. They are Wasden Immigration Litigation. Also, friends, if you have questions that you would like to address, and which I could take up in our next webinar to the attorneys, you can also contact me. My phone number is 408-335-6444. This is also my WhatsApp number. And you can also email me at neepat@staffingly.com. So thank you once again, everyone, for joining us. If you haven't as yet subscribed, subscribe now. Our handle is at Immigration Talk Show. Also, share this handle with your friends and family who could benefit most with all our U.S. immigration content, the latest ones, especially, because we don't miss out on updating you as soon as possible. So check us out and share this handle, like, share, and subscribe, basically. So thank you once again, everyone, and see you soon. So stay tuned to Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, and I'm going to be your host for this session. So, thank you so much, everyone, for joining us. And if you think that this episode is going to be helpful for your loved ones and your folks out there who could benefit, especially with today's discussion, please do not forget to share this link with them. And they can join us, they can watch us, they can even ask their questions if they have any, because we're going to have a very esteemed immigration attorney who's going to join us and will be very happy to give you the answers. But before we head on to welcoming our guest for today, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope that you'll keep that in mind and feel free to join us. And you can do that by commenting wherever you're watching. We are live right now on YouTube, LinkedIn, and also on Facebook and on X. Check us out and do not forget to connect with us also, follow us, subscribe to our channel at Immigration Talk Show. That's our handle. And also, you can check us out. We are on Instagram. So join us, friends. And that said, today's discussion is going to be on what legal protections do international students have at US borders. Yes, students are really facing a lot of situations right now, I would say, with their CVIS, and also some of their visas are being revoked. We'll discuss all of that. And, to join us in this discussion today, it's my honor and a pleasure to, welcome one of Canada's top immigration minds, none other than David L.P. Garson, with over 30 years of experience. David is the managing partner at Garson Immigration Law and is certified as a specialist in immigration law by the Law Society of Ontario. So, yes, recognized by the international who's who of corporate immigration lawyers as one of the top 10 most highly regarded immigration attorneys in Canada. David brings unmatched insight into cross border business immigration as well. And he has advised everyone of multinational tech giants to senior executives and is a past chair of both the Canadian and American Immigration Lawyers Association. So, really very honored to have you with us today. Welcome, David, once again. How are you doing today?
I'm good. Thank you so much for having me. It's a pleasure to be here.
Always a pleasure. I mean, we met last year. So much has happened since we last met in
I would say
November.
so. I think that's an understatement. Yeah.
So true. Every day we are waking up to new updates, new rules, and things to keep in mind. So David is going to help us, with most of our questions today. I have some, and I'm hoping that viewers out there watching us are also going to drop their questions, since we are lucky to have David with us now for an hour. So, David, what would you like to tell folks out there? What can they expect in today's discussion?
Well, I think obviously there's been a lot of media with regard to everything that's been going on. It has become far more, um, I guess, prevalent in the sense of you see stories all the time of people that are going to the port of entry. they're having issues at the port of entry. A lot of it is certainly true, and a lot of it is, I think, generated a bit of anxiety and nervousness. So I think what we want to discuss or go through is, okay, so what's true and what isn't true, what's happening and what's not happening. Certainly there's headlines every single day as to what immigrants and non-immigrants are facing, not only at the port of entry, but when they're inside the United States and things of the sort. So, I think that we have to look at this kind of carefully, and we have to understand that while things have changed, certainly it isn't the same as it was a few months ago under the previous administration. I don't think anybody would acknowledge that that's the case. But at the same time, is it quite so severe as we are seeing now? So I think that's what we have to talk about, and we have to take a look at.
Today. And friends, stay with us. We are going to, discuss all of this. In fact, with all these news, with the 300 students and having their CVIS terminated, it's crazy. Having a normal day and getting sort of shock like this news. So I'm sure it's going to be interesting what we have, and to help us out with our questions, I have this first question to you, David. If you could tell us what basic rights do international students have, when especially they arrive at the US airport or the border.
Unfortunately, a student is a non-immigrant going to the United States. So any non-immigrant who's trying to enter the United States and is not a green card holder or a citizen doesn't have a lot of rights. You can't really avail yourself of the Constitution and say, here I am protected under this section or that section. So if you're a non-immigrant, a student or a worker or anyone, a visitor, and you're at a U.S. port of entry, an airport or a land port, then your rights aren't very fulsome. So an officer at a port of entry can question you and discuss why you're there, what you're doing, what your paperwork is in all of that situation. And, people say, well, do I have to answer? Well, yes, you do, if you want to try to gain entry to the United States. If you don't answer and you say, I refuse to answer that, or I'm not going to do this, then of course you are subject to removal and not being let into the United States. So, long-winded answer to your question, what rights does a student have? Not a lot. I mean, you in a polite way can request to clarification. If you think that things are going badly, you can ask for forbearance or patience. You can try to speak to the officer and determine why things are going this way, or what can be done to rectify that situation. But in terms of availing yourself of, a law or the Constitution, unfortunately, not a lot.
Okay, so I think there's not much, but it's always best to stay informed. I think knowledge is power in this case, especially when you talk about immigration. It's always good to stay updated because things are changing and we have to adapt every day.
And
So,
I think it's important to self-assess too before you go to a port of entry, right? You have to self-assess your risk. You have to take a look at, okay, well, this is what I've been involved in, or this is what I've been saying, or this is me on social media. And so before you go to a port of entry, you have to take a look at that and say, well, am I putting myself in a position where if somebody looks at my social media or looks at my tweets or, in where I've been, am I going to have a problem? I think this is such a shock to the system because this has not happened before in this type of numbers per se. I mean, there's always been people who've come to ports of entry and been refused entry to the United States. I mean, that happens daily, hourly, wherever it is. But I don't know that this has happened to such an extent, or certainly the media hasn't publicized this as happening to such an extent. So it is a very popular topic. And that being the case, when somebody goes to a port of entry, especially now, and they know that they've been doing things or saying things or being involved in things that the US would consider to be anti-nationalistic or anti-US, then you have to take a step back and assess, okay, so what could happen to me at the port, and is this a good idea for me to travel at this time?
Yes, I mean, I hear so many immigration attorneys saying it's best to not travel right now. If you're in the US, stay in the US and stuff like that.
Well, that's an interesting point. We know that there have been many students who got emails from the Department of State recently who basically who asked them to self-deport based on previous activities or minor criminality or things of the sort. So being in the U.S. doesn't necessarily help you either. If depends what you've been up to. But to your point, if you don't need to travel, then outside of the US, then probably not the best plan to travel in that regard. That being said, if you're a student who's going to school and you're in the US to study and you haven't been doing anything that would be considered untoward, then you shouldn't come, and your F1 is still valid, and nobody has sent you an email to self-deport, then you should be fine. I mean, you really should. I mean, I suppose any officer at any port of entry can give you a hard time, as they could, but I don't know that they would. I mean, we still have to consider that there's probably 1 million people or so traveling to the United States on a weekly basis, and the CBP doesn't have time to be obstreperous or stop people from going in, for frankly speaking, for the sake of it. So I think you do have to, as I say, look at this in that if you don't have to travel, maybe not a great idea to travel. But if there is something you need to go to, then I think that as long as, going back to our self-assessment again, as long as you are satisfied that, you know what, I'm here to study, I'm in my whatever STEM field or medical field or whatever you're doing, and I'm too busy to get involved in anything that I shouldn't, then I don't know that travel would be a problem.
Yes, very true. Very well put, I would say, David. Thank you so much. So, and also, about social media, like we were speaking, many are advised to also deactivate or even delete their accounts. So, that's it. Because, nowadays, social media has become everybody's part of life. They wake up to that, they put an update with everything. So, I think nobody thought that it would, come back at them so soon like this.
I think you also have to be careful too in your social media on a certain way. If you wipe everything, I know there are people saying, okay, well, bring a burner phone to the port of entry, or
Yeah.
wipe all your phone, the social media in your phone, or wipe your phone. I think that's going to raise a lot of questions if you do something like
Yes,
that.
it's going to
If you
raise suspicion.
Exactly, if you go to a port and they look at a phone, there's nothing on it. All of a sudden, the officer's going to go, wait a minute, what are you hiding? Right? Like, what's going on here? That's odd. I mean, look, I'm an old man. If you look at my phone, I have a bunch of stuff on my phone. It's not any, it would bore you to death, but there's a bunch of
Yeah.
stuff on the phone. But if I show up at this point with a phone that has nothing on it,
What
they're going to
happened?
think
Yeah.
bad thoughts. Exactly. Yeah.
True, very true. Yes, that's it. Folks out there, thank you so much for joining us. I do hope that you're enjoying this content and are able to, resonate. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Also, yes, like, share, and subscribe to our content. Hit that bell icon so that whenever we have, discussions like these, you're also notified and can join us by participating. Also, you can ask your questions, you can even contact attorney David Garson here. So also you can join us on call. You can call in this number, where you can call in is 425-436-6335, and the access code is 988-888. Okay, so David, I have more questions, and if you could
Sure.
also help me with a few answers, as in, like, even if with a valid F1 visa, can a
Mhm.
student still be turned away at the airport? And if so, why would that happen?
So, yes, the port of entry has ultimate responsibility for entry to the United States. So anybody can be turned away. So, for instance, people can get I'm a Canadian, and as a Canadian, for example, I don't need a visa from a consulate. So I could go to a border. I could say, I'm applying for an F1. I have my I-20. I'm going. Can you give me the status? And they can say yes, or they can say no. I can go to a consulate if I'm not a Canadian and I need to get a visa. And I go to the consulate, and the consulate issues the visa. And then I travel to the port of entry. But ultimately, it is the port of entry that has final decision-making power. Okay, so the U.S. immigration is run by several different departments of government. The consulates are run by the State Department. The port of entry is run by the Department of Homeland Security. If you file at a service center, it's USCIS. I mean, it's still under the Department of Homeland Security, but there's the Department of Labor. I mean, there's different organizations that have different purviews. So if you go to a port and you say, okay, I have a visa, whether it be an F1 or an H1 or any other kind of visa, and the port can say, sure, more often than not, they're going to let you in, right? You just got the visa from the consulate. Everything seems to be fine. Consulate was satisfied. You're attending the school you said you're attending, satisfied that your documents are in order. But when you get to a port of entry, that officer can ask a lot of questions. They can ask questions about where you've been. They can ask questions about what you do. They can ask questions about what are you studying? What clubs do you belong to? What are you interested in? They could ask to see your phone. They could ask to look through your computer. So they can ask all of these questions, and during that time, they may come up with something that they find is either, in their view, makes you inadmissible, or a possible problem, or expressing anti-U.S. sentiment. And if they see this, then yes, they can stop you. They can put you, if they want, into detention, or they could turn you around where you would have to leave. So ultimately, yes. Again, long-winded answer to your question, but the port of entry can absolutely stop you from entering. And they can cancel your visa at the port as well, if they want to.
Yes. I think what we need to do is raise no suspicion at all. You have to give them the idea that, what you're telling them you're going to be in the US for, you have to come here to just do that. Nothing else. I mean, even you may be
That's
passionate
exactly.
custodian. Yeah.
I mean, that's the debate, right? We can sit here and discuss this, but the absolute debate on this is, you're a student. You've had to go to great lengths to get that student visa. It's not easy to get a student visa to the United States, right? I mean, you have to prove temporary intent. You have to prove you have the funds available. You have to have been accepted at an institution that is notable and is able to issue an I-20. It's expensive to travel to the U.S. It's expensive to live in the U.S. I mean, there's a lot of stuff that goes into getting a student visa. And a lot of people want to get student visas to go to the United States because they think that will help them in their life and their career. And certainly there's no shortage of people who are applying. So as you're saying, I think you owe it to yourself to make sure that if you're going, that you're going for the reasons that the U.S. intends you to go for. The debate is free speech, right? The debate is that are you able to say what you want and do what you want? You're a person, you're entitled to have the ability to speak out on causes that are near to your heart. But you have to temper that, and I'm going to be practical here. Okay, this is a sort of a practical look at it. You have to temper that to the knowledge that you are not a U.S. citizen or green card holder, and therefore you have gotten permission to go to the United States and to go to school. So with that permission, the U.S. would argue you have responsibility. And the responsibility is to abide by their terms and conditions. Meaning, you want to come in here and study? Great, we're happy to have you. That being said, you have to play nicely with how we want you to play. And I appreciate that there are many people who find that wrong or annoying or stifling, but it's not a case where you're on equal footing here. It's a case where, again, you're asking permission to do something. And whenever you ask permission from someone to do something, you know what? You have to abide by
Yes.
the rules.
Exactly. You have to prove that you are worth it. I mean, why you ask that permission for, that you're allowed. So why do anything otherwise, right? So I
Hmm.
think we have to respect both I mean, we have to respect their decision that they have allowed you to come in to study. So just do that. And David, I would also like to know, there in Canada as well, are you facing anything in the borders, anything with regard to students you want to tell us?
It's interesting. I think that there are many people. It's an interesting time. I've never seen a time like this. I'm dual licensed. I'm licensed in Canada and the United States. So I see people coming to Canada and I see people going to the US. And it's an
Yes.
interesting, it's an interesting dichotomy. It's an interesting comparison because the people going to the US are going, and a lot of Canadians want to go to the US. I mean, since the election in our office, our inquiries to go to the US has tripled, because a lot of people are attracted to the sense of maybe capitalism and ability to get further ahead in the United States. And at the same time, you have people in the United States who are unsure about themselves there, and so they want to come to Canada. They feel that it may be easier for them in terms of the life they want to live. So we have seen people wanting to come to Canada to go to school, or people wanting to come to Canada to work or stay. There was a case, I think, and I don't know much about it, and I'm going to even talk, it's kind of hearsay, but there was a lady at Columbia University, or was quote unquote self-deported to Canada, meaning she doesn't have status in Canada, but came to Canada to avoid having issues with ICE in the United States. So you do see incidences of people who will come to Canada to try to avoid what they think may be problems for them in the US. That being said, Canada is well aware of that. And with the issue of tariffs and some combustibility between the two nations right now, I think Canada's being careful not to roll out a welcome mat, in the sense that, first of all, we have our own issues with regard to our economy and our ability to house people and all that kind of thing. And our immigration system has been severely problemed. I don't think that's a word, but I'm going to use it, for a number of years. Has had severe problems. How about that? For a number of years. And so I think people would want to say they want to come to Canada, but I think in Canada, the public may not have an appetite to take many more people in that regard.
Okay, that's very interesting. Like you said, it's a very interesting time because there's just so much happening, right? I think
Yep.
it's not like any other boring day. It's not like a day is repeating again. Every day
Mm-hmm.
is new with so many updates. So, yes, thank you, David. And let's go on with our questions. We got more. So, what actually happens during secondary inspection, and how should students handle that situation calmly and safely?
So in terms of secondary inspection, so what happens is that if you come to a port of entry and they have issues regarding you and your entry, they will send you to secondary inspection. Now, it depends where you're coming to a port of entry, but if it's a land port of entry, then they send you over to drive over to the side. If it's at an airport, there's a secondary inspection office. It's the office behind the booths. So when you come in and you see CBP officers standing at the counter, basically saying, okay, well, what are you here for? How long are you there? All that kind of thing. They'll send you over to secondary inspection. At secondary inspection, they'll ask you to sit down. As they look you up, they may go through your documentation. Now, at that point, they could start looking at you and your social media and things of the sort. And in fact, they sometimes do. And if you're going in and you say, I'm whatever, Mary Smith, then they'll look for Mary Smith and see what you've said or what you've written or things about you. If they Google you or they go on LinkedIn or something of the sort. When they, I guess, investigate, what they'll do is they'll come to you and say, all right, well, Mary, what have you been doing here? Where do you go to school? What is your, again, they'll ask the questions that we talked about before. Do you belong to any organizations? I see you said this on this date. What do you think of that? I mean, they can ask anything they like. Can we see your phone, please? Now, it's my thought on that, by the way, that if they ask to look through your phone and you are amenable to them looking at your phone, then I would unlock it. I don't necessarily know I give my code away, but I'd certainly unlock it and then give it to them. All that being said, they can seize your electronic items if they want to. They have that authority. And they can also not let you in they have that authority. If you don't acquiesce, or if you're not cooperative, then they can basically say, listen, we're not letting you in. Tough. It's too bad. They can do one of two, three things. They can expedite remove you, which is a very bad thing because it's a bar to the United States, or they could let you withdraw your application for entry, in which case you leave. In either event, obviously the bar is bad, but if they let you withdraw your application for entry, even though you're not barred, you're in the system. So it may make it difficult next time you want to go in.
There you go, friends. Try not to, create any sort of suspicion ever. And thank you, David, for taking this up as well. So, moving on, I have more questions. But before that, I would like to tell folks out there you can keep commenting, you can ask your questions, and we are going to address to them very, very soon. So, you can comment wherever you're watching. We are live right now on YouTube, LinkedIn, X, and also on Instagram. So do not forget to also subscribe to our channel. Our handle is at Immigration Talk Show. So that's it. Thank you, David, once again for joining us. In fact, you can also contact Attorney David Garson, and that you can do by, emailing him as well. Sometimes, you have your questions, you don't want to ask it here so publicly. You can leave him a message or email him at david@garsonil.com. Yes.
Yep.
So, David, another question I have for you is if students are required, to answer every single question that's asked by border officers, or are there limits to what they can be asked?
I mean, you would think so. I'm trying to answer this in a way. I don't know that an officer would ask a question that would be in a term inappropriate, or they shouldn't. And I think there's an ethical obligation that an officer has. And, it's a tough job to be a CBP officer. It is. I appreciate the fact that there's a lot of discussion on this. And Lord knows I see both sides. But it is a tough job. I don't know that an officer would ask a question that would be perceived to be, I'm putting this in quotes, inappropriate. I think that the questions they will ask will lend itself to, are you admissible to the United States? Are you a danger to people or to the U.S.? Have you done things that would make you inadmissible? Now, in terms of where the line is there, I guess everyone has their limits, or everyone has their ability to decide what they want to answer and what they don't. I was talking to someone who was telling me that they have a visa to get to the United States. And when they came into the US, the officer was asking lots of questions, and they answered the questions. And the officer basically was saying, well, why can't an American do what you're doing? This was not a student visa. And the person said, well, I don't know. I got a visa so I could do this. And I suppose it would be up to whoever made the decision to give me the visa to answer that question, which was a good answer, I think. But I think the way they said it, too, was a very, in a very practical, forthright way. I think it goes without saying, but an officer will also give back what they get. So if you're going in there and you create an attitude, then you're going to get a lot of attitude back. If you are polite, then they may not be polite back. I can't say they would be, but they're more likely to be polite in that regard. So when you say answer every single question, you can, if a question you don't think is appropriate, you can ask in a appropriate way. Well, I'm sorry, I don't understand. I'm trying to come in as a student. How does that relate? You know what I mean? In the sense of creating a situation that you can address the question and query it, meaning you could ask for clarification. You can be as careful as you can. That being said, again, you don't have a lot of wiggle room or rights in this regard at a port of entry. You just don't. And there's no magic bullet here that I can say, but you quote this section of the law or this case and they have to back up. That's just not the case.
There you go. Yes, I think sometimes we may not have the answers, and we don't understand. And is there anything like right to remain silent or anything as such, David?
I mean, you can certainly do that. They can't force you to answer questions, but again, that will go towards you being able to get in.
Hmm.
You know what I mean? You're talking about, you take the Fifth, which is a part of the U.S. Constitution under the Fifth Amendment, but at the same time, you as a non-immigrant, again, you really don't have constitutional rights in the United States.
Okay, right. And especially at the entrance, I guess, in the airport or
Oh
anything as
yeah,
such.
yeah, yeah.
Right. Thank you, David, for taking that up. And we have Drive 10. Hi, Drive. Thank you so much for joining us on YouTube. So let's take up his question. I am an international student and I'm planning to travel to India for a short trip.
Hmm.
But I've been hearing about students being stopped or even sent back at the airport when they return to the US. What kind of legal protections do I actually have at the border if something like that happens to me?
You have to be able to, as I said, you self-assess and you try to be as fulsome as possible with the documentation that you have and the information that you have. So, for instance, if you're coming to the port of entry and you've gone to India, you're coming back, and you have your all your documentation in order, I would probably have further documentation. In other words, when you got the student visa, you had to show evidence of your ties to India, right? You showed evidence that you had family there. You had showed evidence that you had financial ability to pay and the financial ability to support yourself. So I would actually have with you, you don't necessarily have to present it unless they ask for it. I would have copies of the information that you first submitted at the consulate to get the student visa, just to show that, yeah, no, everything is the same, and I have this. Also, if you're attending school and you're going home, um, where are we here? Where I guess we're coming to the end of the year. So if you have your next semester and you are registered in courses, I would have proof of that. I would have copies if you've gotten your marks from your previous semester. I would have proof of that, showing that you've attended school and that you've completed the courses you were supposed to complete. And if if you're staying in an apartment or a house and you have a lease, I'd have a copy of that. So I guess my point is that it's sort of a package of documentation that you may want to bring with you just in case. Because if they're going to deny people entry at the airport, they're going to tell them why, right? They're going to say you did this or you were there or the like, or we don't believe you're attending school or we don't believe you're going back to school. But if you show at least as much as you can that this is what you're doing, you are here to go to school, you have gone to school, and you're going to go to school, and you can support yourself, you have somewhere to live temporarily, then that could address a lot of the questions.
Right, right. Thank you so much, Drive 10, for joining us with your question. And thank you, David, for addressing this. So, coming back to our questions, if you could also talk about the important documents these international students should always carry, especially when entering the US to avoid any sort of problems.
Yeah, I mean, I think in terms of when you say always carry, you should always carry the documentation that you are a student, meaning you have the electronic. You should download a copy of the I-94 card. If they didn't give you the paper copy, you should have a copy of the I-20. You should have, as I said, if you're going to the school, you should absolutely have information that you're attending. If you're leaving the US, everything I just talked about, you should have with you, just because. Okay, if you come back just without any kind of real proof of anything else, then I think that you could invite more questions. They could say, well, how do I know you're going to school? Well, here, I have this. So you have somewhere, how do I know you can support yourself? Well, here. And shows you have ties at home. What were you doing? And be prepared to answer questions. I mean, I think that's the case. I mean, if somebody asks you a question, be prepared to answer the question. What are they going to ask you? What are they concerned about? This goes back to our self-assessment. They're concerned that you are coming to the United States to do what you said you're going to do. You're going to go to school. Show proof you're going to go to school. Show proof you've been in school. What if you belong to clubs? My advice, join clubs like the chess club. Okay? Join the yearbook. Don't join organizations that would be considered to be problematic organizations. And I think that if you're quite plainly. If you're smart enough to get a study permit, a student visa to go to school in the US, you can figure that out. You should know that, there are organizations that may not help you with regard to your US activities or your US student visa. And yes, I appreciate the fact that if you were a US citizen or you were a green card holder, you could do certain things, sure, but you're not. So keep that in mind.
Yes, absolutely. Thank you, David, for making that clear. And when you talk about studying in the US, I mean, whether it's just academia or so many co curricular activities that you need your grades on, it's going to really keep you so busy. I don't know how do people make time for any other things. Well, um, anyway, we got Kritika also joined us. Hi, Kritika. Thank you for joining us on YouTube. So let's take up her comment. I came here on a B1 visa that was valid for 6 months, and I ended up staying 8 months due to a medical emergency. I didn't
Mhm.
file any extension. Am I already in trouble? And is this $998 per day something I could actually be charged now? I think
I'm
this is
not
a
sure
new.
about the $998 per day, but in terms of in trouble, you overstayed. Unfortunately, you did overstay your visa. Yes, I would leave immediately. To be quite honest with you, I would not stay longer. Being out of status in the United States is never a good plan, especially now.
Yes.
So this isn't something you should play with. In that regard, and I'm sorry, I don't know what the $998 per day is.
Yes, actually. And Kritika, I understand it was a medical emergency, but I mean, it's crossed over 2 months. I really hope that you were not in a situation where you couldn't have informed. So if you were, it's going to maybe backfire at you again. So, but I hope that you're fine now, Kritika. Thank you so much for joining us with your question and all the best. Let's go on to our next question. And if you can tell us, can border officers go through a student's phone or laptop? We've already discussed this. If that happens, what can the student do? I mean, unlocking the phone and giving it to the officer. But yes, tell us more.
Yeah, just to go back on Critica's, uh, I lost you here for a minute. I'm sorry, I'm trying to find you. Do you see
No
me?
problem.
Or,
Yes, we can.
oh, okay. Going back to there I am. Going back to Critica's question too. The longer you stay, the worse it is. And if you get to that 180 days, it's a 3-year ban. So, leave. That's the best advice I can give there. Now, sorry, in terms of can they go through your phone? Absolutely, they can go through your phone. Yes, they can go through it. I mean, if you go to a port of entry and they say, I want to go through your phone or go through your computer, yes, they can do that. They can look through it. Now, if you don't give them the access code and you refuse to open it, then they have 2 or 3 options. The first is they can say, fine, they can stop you from going into the United States and turn you around. The second is they can let you in, but seize your phone and give you a receipt for the phone so that they can go through it. Or 3, they can let you in. Now, I don't know that the third option is going to be very likely, but they can absolutely do that.
Okay. Thank you, David, for taking that up as well. And now, if you can also tell us if a student is told that their visa is being cancelled at the airport, do
Mhm.
they have any right to ask for help or talk to someone before they are sent back?
They can ask for clarification, or they could ask to call an emergency contact or something of the sort. They don't have a right per se. They can ask to speak to a friend, or they can ask to speak to a lawyer. But I don't know that they'd be given the right to do that. If they're going to be canceled at the airport, they would have to be told why. I mean, they're going to be canceled at they
Okay.
normally would be told. There'd probably be an affidavit that they would have to sign. They'd be asked questions. It's an
Mm,
there'd be an interview with regard to what's going on, what they said, and then the officer would say, I am not letting you in, or I am canceling your visa under this section of the act. So if
mm.
that occurs, then they can ask for further clarification or to let someone know, or for any kind of I guess kindness the officer wants to show. But there's no right to any kind of appeal to a court or to a
Okay.
tribunal right there. No.
Okay, so that was just leading me to the next question, but probably it's going to be invalid because if someone is denied entry, and can they really challenge the decision, or is it like the final right there at the airport?
Well, it's pretty final at the airport. Let's put it that way. I mean, if you're at the airport, there's administrative appeals when you're within the United States. I don't claim to be an expert on when you're in the sense that and what appeals you have through courts and administrative bodies when you're in the United States. But at the airport, there's not a lot that can be done for you. If they're going to refuse you, they refuse you and they send you back.
There you go. Okay. Thank you so much, David. I know these answers are not very hopeful, but it's
No,
better to know than
I mean, but
now.
we are delving into the worst case scenarios here too,
Yeah.
and I appreciate why we're doing it, and that's absolutely fine. It's just that I think we do have to note that this is what happens if you're in that position. Okay, if you're in the position at the port where things are going south, then I think you have to be in a position, or as I say, have try to have the presence about around you to figure out, okay, what can I do or say to this officer that would make a difference for me? Meaning, even in a common sense, practical way, what can be done that helps me in this situation? Because if I try to be overly hostile, it's wrong. If I try to get overly nervous and so I can't speak and it becomes sort of, I get hysterical, that's wrong. That's not going to help you. I think the best thing you can do is to try to keep your wits about you and me, if I'm there, and understand what is going wrong and what I can do to try to remedy it. It
Mhm.
always helps. I keep going back to this, and I'm sorry, and I know I'm being repetitive, but it always helps to sort of be on the side of the angels, meaning be on the side where, okay, look, I haven't done anything wrong. I haven't said or belonged to organization. I haven't said anything that's going to be construed to be problematic, and I don't belong to organizations that the U.S. is concerned about. So why am I having a problem? Okay, because if you start in that premise where you are involved or saying things or doing stuff, then right away you're starting on the wrong foot, right on your back foot, and that could be an issue.
Okay, okay. So I think you really, really need to consult with an attorney because right now, I you may think that it's going to be okay to speak of few things, but I think it's best to know what to speak, what not to address, and yeah, how to stay compliant and safe. It's most important to play safe at this moment. So thank you so much, David. And yes, folks, you can also contact attorney David, and that you can do by emailing him. And his email address is david@garsonil.com. And go visit www.garsonil.com. So, David, we do have more folks who have joined us with their questions. So let's take up. This is Sonia. Sonia is asking, I'm still in the US on an H1B, but my I 94 expired 20 days ago while my employer is working on an extension. Can I still fix this without leaving the country, or does this situation now count as an overstay?
I mean, after your H1 expires, normally you can remain in the U.S. for a maximum of 60 days, or until the authorized validity period. But if it's expired, I mean, realistically speaking, there's not much you're going to do. I mean, in the sense of staying there that I can think of. Um, I mean, I guess the question is that why you didn't make an application to change status while you were still in H1 status, even to B status as a visitor, in that regard. I think that, and then try to change status back. In other words, just there's opportunity to submit documentation when you're in a certain status in the United States to help you. If you're outside, if you've expired, then chances are you're going to have to leave and go get a visa from a consulate. So your employer would have to get an approval, but then that goes into the cap too. If it's not an extension, then you may be back subject to the H1 cap, and then you may have to leave. If you get it, you then can go and get a new H1 visa, but the extension itself may not be possible.
Okay. All the best, Sonia, and I hope you figure out. And I think it's best to be safe, stay safe. And let's go on to our next question from Sony. Thank you, Sony, for joining us. Sony was there on our previous show as well. Thank you. Good to see you back again with another question. So saying my parents are coming to US and B1 visa for visit. How
Yep.
long can they stay here without issue, and what documents do they need with them while traveling? Do they need to carry passport all the time while traveling?
So, I mean, as you probably know, if they're coming to the United States on a B1 visa, once they come to the port of entry, they're granted, normally it's 6 months. Normally they get 6 months, meaning it goes into the system unless they do it differently. So you can, first of all, go on the USCIS website under My I-94 and check the status time you were given. So if you come to the port of entry and they let you in, then you can go on the USCIS website and check, okay, I was given status until whatever day I'm given status to. So then you'll know what the length of time is. The second thing is, as you probably heard, if you're going to stay longer than 30 days, then you have to register. Actually, no, if you're coming by airport and through, then you're given the I-94. So that should be fine. So there's no need for that. Secondly, when you come to the port of entry and they're asking, what are you doing? I would make sure they have their return ticket. So it shows when they're going back. If they're staying with you, they may want to have a letter from you saying they're going to be staying with me for this period of time. They're my parents. I'm in the US in this status. They're visiting me. If they're coming here, they should have, if you're, just have it with them. They don't have to present it unless they're asked to present it. But if they work, they should have proof that they're employed. If they live somewhere, proof that they have a house, in that sense. So if they're coming to the United States and they're going to the port and the port's saying, okay, well, why are you here? They're here to visit their child. And this is where they're staying. This is how long they're staying for. This is their return ticket. This is what they're going back to. Again, I think you want to bring copies of the documentation that you use to get the visa itself to begin with, and have it with you. You don't necessarily have to present it to them. If you can pick them up at the airport, maybe a good idea to show up at the airport and pick them up. But what they want to know when you come to a port of entry is that you're here for a temporary period. You can pay for yourself when you're here. You're not going to do anything. You're going to work without status or anything like that. And you have means to go home and a way to go home. So that's what they're going to look at.
Yes, and I think what has lately become very important is also your return ticket. So this
Mm-hmm.
is something that you might want to have it with you, even when you're entering the US. Your the proof that you're actually going to go back on that date. So
Yep.
yes, Somi, thank you for your question. Thank you for participating. And we have Rahul. Hi, Rahul. Thank you for joining us on YouTube. Saying, I have heard that American Civil Liberties Union offers resources and guidance on immigrants' rights and can provide assistance if you're facing issues related to your immigration status. How reliable is this?
Sure. No, you can, but you're not going to be able to avail of that when you're at a port of entry. I mean, when you're at a port of entry, they're not going to, it's not going to be very helpful. But if you're in the United States and you're facing issues with regard to your immigration status, you can absolutely avail yourself of the American Civil Liberties resources. You could also avail yourself of other immigration attorneys' resources, meaning if you're in the US. I have a unique type of practice in the sense that because I sit in Toronto, so we do a lot of border work. So I've been doing a lot of media myself with regard to the border and what happens at the border, because that's a lot of what I see. But let's say you're going to school in Oklahoma, or Texas or Florida, and you're running into problems there in those states, then yes, you can avail yourself of the resources of the American Civil Liberties Association. But also, there's many fine lawyers in those areas that can probably help you as well. If there's something to be appealed, if there's some way to sort of attack the problem. I think that, and it wouldn't be I mean, obviously, it's not me. It's people who are there on the ground, who you can see, who can give you a lay of the land. What I believe is that if, for instance, you are told to self-deport or there's issues with regard to your status, then the first stop you should go to is somebody that knows what they're doing and what they're talking about. It's easy to go online. It's easy to go on Quora or Reddit or something and ask questions, but you don't know who's answering those questions. If you can afford it, then you should see someone who can assist you and give you reliable information.
Very true. And it's best to consult with an immigration attorney and have one personal one for yourself always, because they will know your case in and out. They know where you were born, what you're doing, what you need to do, what your status is, and everything. So, yes, and in fact, if you need an attorney, especially if you're in Canada or the US, or you keep shuffling in these two countries, then why not contact Attorney David? Also, Attorney David Carson is going to be available on email, and you can email him at david@garsonil.com and go visit www.garsonil.com to get to know more about immigration attorney David Garson. So, well, David, we do have some more people who have asked their questions on our YouTube channel. So I would like to address to them as well quickly
Okay.
because I feel like they are a little related to our show right now. So this is like, I'm a business owner from Canada. Do you think I can self petition and apply for L1A?
So if you're a business owner in Canada and you have a company in Canada and then you want to establish a business in the United States, you can look at it it's called a startup L1, meaning you're starting up a business and you're transferring there. That being said, you can't be well, you can, but it'd be a very difficult L1 if you're the only employee, right? So in other words, if you can't, let's say I have a small business in Canada, I'm the only employer, myself and my spouse are the only employees, and I'm going to establish in the US and then do a startup L1 there. It's possible theoretically, but I would look at it, if you came to me, I would look at it and say, well, how strong is this case? Because I don't know it would be especially strong because they want to know that both companies are still going to be operating, that the Canadian company can support the US company. In those types of situations, you need a business plan. So I guess in answer to your question, yes, it's possible. That being said, the conditions and the criteria have to be met, and it has to be somewhat clear and precise.
Thank you, David, for taking that up. And folks out there, don't forget to subscribe to our channel, especially if you're resonating with all our content and what information Attorney David is here to give out to. I mean, it's very, very interesting so far. Been discussing from a different point of view, I would say also. So, yes, subscribe. Our handle is at Immigration Talk Show. And also check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Connect with us. Let's go on to our next one. This is from Status saying, ma'am, F1 visa refusal slots open or not?
I'm
That's
not
the
sure I
question.
understand the question.
Is F1 visa refusal slots open or not?
Sorry, what do you mean F1 visa refusal slots open or not? If you're
Exactly.
refused an F1, if you're refused an F1, then it's, you can reapply. If that's what you're asking, if you can reapply for the F1, yes. But frankly, if there's not a lot of documentation that's different, it would be a pretty tough application. So I don't know how that would go.
Yes. But thank you, David, for taking that up. Now we have Paulo asking, when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies.
Mhm.
That was the agreement they signed. Is that true, David? What do you want to say on this?
Yeah, there's a temporary intent requirement. I'm not sure if they're referring to immigration to Canada or immigration to the United States, but there is a temporary intent requirement. And when you're making application for an F1 visa to the US or a student visa, a study permit to Canada, you're absolutely saying that you will return to your home country. Where that became, if we're talking Canadian immigration, where that became, I guess you could say almost hypocritical, is the fact that a lot of Canada's immigrants came from the student population. So while you had to say that and prove that, at the same time, you could still enter the express entry pool to apply for permanent residence and everything of the sort. So it was odd. You're saying I'm going to go home, but at the same time, I'm applying for permanent residence. And in the US, it's kind of similar, right? I mean, you have to prove temporary intent when you apply for the F1, and then you do the OPT. And if you are in the STEM field, you have a longer term OPT, but then your employer, is trying to get you an H1, and then from the H1, possibly labor cert and then perm. So while you, again, the dichotomy or the separation is interesting. You're proving temporary intent because that's what you have to do. And at the same time, a lot of the immigrant population is taken from students who have had to prove temporary intent.
Okay. Well, that's interesting. And thank you so much, Paulo, for your question, and also David for, taking that up. And we got this one from Shreya. Quick question. What would be the RFE for someone who's working on job duties? Isn't much related to their master's degree. Would that be a specialty occupation? And my company gives very detailed job duties, roles, responsibilities, qualifications, etc. The only issue is my master's degree in information systems, MS, with data SC courses, and job in network engineering. However, I have STEM OPT Indian work experience for 2 years, BTech in CSC approved. So, and
I,
is specialty occupation is judging the role by company or the candidate who's applying? Seems like USCIS judges the role rather than the candidates.
well, for this, I'm assuming you're talking in H1. If we're looking at that, then I think that, yeah, they look at both. When you're doing the H1, your degree should be in a closely related field, in the sense that it makes sense that you could do this job and you've been trained to do this job, and it does go to the role as well, with regard to the duties and responsibilities of what is something that is clearly professional in a specialty occupation. So, I mean, in terms of what would the RFE, that's a request for evidence, be? In that regard, it depends upon what is written in the submission, but the degree should be in a field that is related to what you're doing, and the role itself should be in a field that's related to the degree or something that they're satisfied you can undertake.
Okay, okay. Thank you so much, David, for taking that up for Shreya. And Shreya, thank you once again for your question. And I think we have taken up our YouTube questions with that. So thank you, David. I still have more questions, so probably I'll quickly address to them since we are running short of time. So if you can tell us, can issues with a student's CVIS record,
Mhm.
like it was just fixed or was recently terminated, is it going to affect their chances of getting back into the US?
Oh, sure. I mean, yes. I mean, if your CVIS record is terminated, then you you need to get a new CVIS. If it's terminated by the school. There may be a reason for it being terminated by the schools, for whatever it is. But you should probably appeal that with the school, or see if you can get a new CVIS, meaning a new acceptance with another institution. And then if you can get that, then you may or may not have to apply for a new visa, depending upon the expiry of your current visa. But yes, if your CVIS has expired, then or has been terminated, you need a new CVIS, and you have to go back to the school to try to appeal that, or go to another school to try to get a new CVIS.
Okay. Thank you, David. Thank you for taking that up as well. And folks out there, I hope you're resonating. Do not forget to subscribe to our channel. It's at Immigration Talk Show. So, David, maybe I think what we could help out folks out there watching us, especially if they're students, what steps should students take before flying back into the US, to really make sure that they do not run into legal trouble at the border?
I mean, to wrap up, I think that we have to go back to where we started with, and that is, we self-assess. We determine what we've done, what could be our issues, where the problems could be. From that self-assessment, we then try to address what we think our weaknesses in when we're coming back. The best advice is not to do anything that would get you in trouble. It sounds trite and obvious and maybe a bit ridiculous, but understand, the climate, what's going on, what is expected of you and what your responsibilities are. It's just that, okay? Unless you want to be a martyr, unless you want to be an advocate in a certain situation that may not get you very far, then perhaps you have to consider what is expected and what you need to do. It's harsh. It's a harsh statement, and I appreciate that. And I appreciate the fact that, we talk about individual rights, and we talk about our ability to speak freely, and our ability to be who we are. All good. But, there's an old saying, do you want to die on this hill? I mean, that's it's, you don't want to be a person that ends up making a point, but having your visa canceled. So I guess the first thing is you self-assess. You do what you're supposed to do as best you can. Now, that isn't to say that you couldn't be have issues even when you do what you're supposed to do. But I think the chances of you getting into trouble are a lot less. I think you have the documentation with you that you're supposed to have, including, as I said, a copy of the application that you applied for with your F1, so that you have it on you in case there are questions. And in the end, I mean, you try to keep your wits about you, answer questions truthfully, transparently, and address the questions that the officer asks. So it's their job to ask you questions, and they're good at it. Let them ask you the questions. Answer those questions. Don't answer questions that aren't asked when you're at the port.
Exactly. Everybody's doing their job. And I think if you're going to be here in the US, you should also just come here and do your job. So thank you so much, David, for this really amazing and informative session, for so patiently taking up each of our questions, answering to them, and it was really lovely having you back here with us. I mean, this was our first show this year, so it was wonderful having you once again.
Pleasure being here. Thank you for having me, and be well.
You too, David. Thank you once
Thank
again.
you.
Folks out there, you can contact Attorney David Garson, and that you can do by emailing him. His email address is david@garsonil.com, and you can also go visit www.garsonil.com to get to know more about Attorney David Garson and the law offices of Garson. So thank you so much, David, once again. It was lovely having you. Such an honor and a pleasure, and I'm looking forward to having you back again soon.
Thank you so much. It's great to be here.
Thank you, folks. Thank you for joining us. Do
Bye-bye.
not forget to subscribe. Bye bye, David. And our handle is at Immigration Talk Show. Subscribe to our channel, hit that bell icon so that whenever we have these webinars, you're notified and you can join in by asking your questions or sharing our content, because there's so much people can benefit from all these amazing webinars we have, because they're very informative and they're free. So subscribe. I would say it's free of cost, and just be so let's support each other, I would say. So check us out, not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram as well. On X, we are at IMI Talk Show. That's our handle. But everywhere else, we are at Immigration Talk Show. So check us out. Also, friends, you can message me or call me on my number. My number is 408-335-6444. This is also my WhatsApp number. So in case you have any questions which we can address to our attorneys and guests who join us, feel free to leave your questions on messages. I will definitely check each one of them and, yes, address to them. Also, you can email me at nipa@staffingly.com. And once again, stay with us, because we have another very interesting session lined up just after less than an hour at 4 p.m. Eastern Time. I and my co host Sam are going to be back again with Daily Immigration Dose, where we're going to have another very interesting session, I would say. So stay with us. And until then, of course, keep enjoying your day and check our space out at Immigration Talk Show. Bye for now. Hello, everyone. Welcome back to Immigration Talk Show. I'm your host, Napasa, and I'm going to be your host for this session, which is lined up for you for an hour. So stay with us. I'm going to have our guest for today. And also, at the same time, friends, thank you so much for joining us. Before we start off with today's webinar, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, keeping that in mind, once again, welcome you to Immigration Talk Show. And it's going to be a very interesting session today because we are going to discuss the visa bulletin for May 2025 and what's moving, what's stuck, and what it means for you. So I hope that you're excited to know. And yes, so welcome, friends. We are streaming live right now on YouTube and also on LinkedIn, Facebook, X, and you can also check us out. We are on Instagram. So follow us. Our handle is at Immigration Talk Show. And if you haven't as yet subscribed to our channel, now is the time. What are you waiting for? Subscribe to our channel, hit that bell icon, and also share this content with all folks out there who can benefit, especially your friends, your loved ones, your family. So, yes, thank you once again for joining us. So, it's going to be a very interesting session we have lined up for you. And to join us in this session is none other than Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. And please, without further ado, help me welcome her back to the show. Hi, Prashanthi.
Hello, how are you, Nipasa?
I'm doing good, Prashanthi. It's always really nice to have you back on our show.
Same
So
here.
to folks out there, yes, thank you. To folks out there who is seeing Attorney Prashanthi Reddy for the first time, let me tell you that she has, this experience for almost 3 decades now on immigration, and you should check her out. Go check her out at www.readyesq.com. And yes, I think if you want to consult with an attorney, especially with regard to your case, whether it's a business visa or a family based visa or a student visa, do reach out to her. And her number is 212 354 1010. Once again, I repeat 212 354 1010. And you can also email Prashanthi at readyesq.com. So, Prashanthi, it's been a busy week, I'm sure, and we've already reached mid of April. So, please tell us how's the scene out there, especially with regard to immigration.
It's chaotic to say the least. Been extremely busy, but not in a good way. We've had a lot of CVS terminations, etc. So, talking to a lot of people every day. And of course, it's H1B season, so we're busy filing the H1s that we have. And yeah, so there are ups and downs, and the always in where immigration is concerned, that's what keeps it, I guess, interesting. But yeah, we're seeing those the downs right now, but hopefully things will settle down and we'll be back in business.
Absolutely. And it's the mid of April. So here we have the, excuse me, visa bulletin for May 2025. It always comes out for the next month in the mid of the previous month. So was this expected, Prashanthi, before we had this come out? Did you expect it to be this way?
Yes, I mean, we've seen that there is um, limited forward movement. There has been actually. Maybe last month was an exception, but otherwise we've seen limited forward movement. We've seen high demand, and we're continuing to see that, especially with EB2. We're seeing some forward movement with EB3. Always, it's EB3 is doing better than EB2 this year, and of course that's a seesaw as well, because then everybody starts filing in EB3, and then EB3 dates retrogress, so that happens a lot. Yeah, so it's always competition between EB2 and EB3 because people keep moving from one to the other, and some people have I-140s filed in both EB2 and EB3. And I'm of course talking about more so about Indian nationals, and of course Chinese nationals as well, because that's where the backlog is. But EB2 worldwide is also backlogged. So something to say for the backlogs. Family-based cases are also pretty much at a standstill, except for one category, and we'll look into that further as the show progresses. But yes, it's expected. Slow movement or no movement is expected this year.
For sure, for sure. And we also hear about the EB5, the investor visa category, which is going to see a pause for quite some time now. So I think without further ado, Prashanti, why don't you go ahead and give us a sneak peek into the visa bulletin for May 2025?
Sure. Do you want to pull the? Is it possible to get the visa bulletin up? There you go. So if you look into, let's first look into the final action dates for employment-based cases. Can you scroll to that? Okay, good. So if we look at the final action dates for employment-based cases, we'll see that I'm just comparing it to last month's visa bulletin just to get a comparison as to how the dates moved, if they moved or didn't move. So for EB1, India continues to be at February 15, 2022. So there's pretty much no change from the last month. China is November 8, 2022. Again, no change from the previous month. And for EB1, all other countries, that remains current. I think all other countries is current for EB1 and EB3, but EB2 again is backlogged. So EB2, you see, it's backlogged all over, not just for India and China, but for other countries as well. So having said that, let's go into EB2. For employment-based category 2, these are people, jobs that require a bachelor's degree plus 5 years of experience or a master's degree. India is, again, no change. We're stuck at January 1, 2013. China also, we don't see any change, October 1, 2020. And all other countries also is backlogged, but it's no change from last month. It's still June 22, 2023, June 22nd, 2023. So all other countries always fare a little better than China, and China always fares a little better than India, and India is the most backlogged. So those are the dates. Let's look into EB3 professionals and skilled workers. EB3 category is for those the jobs that require a bachelor's degree. Skilled workers is for those jobs that require less than a bachelor's degree. And EB1, since we didn't discuss EB1, EB1 is multinational executives, so people who qualify for an L1 or EB1. Extraordinary abilities, EB1, researcher categories, EB1. So those are EB1 people, and as you can see from the terminology that I'm using, not many people qualify for EB1, and therefore the backlog is also lower for EB1 when compared to EB2 and EB3. So let's go into EB3. The only movement that we see for the visa bulletin, I shouldn't say the only, but one of the movements that we see is for India. India advances marginally by 2 weeks. There's a 2-week progression, and it advances to April 15th, 2013. It was April 1st, so it's April 15th. So that's a 2-week progression, 2013, April 15, 2013. China, no movement, still November 1, 2020. All other countries, no movement. They remain at January 1, 2023. So EB3, all other countries is also backlogged, and EB2 is also backlogged for all other countries. So only EB1 is not backlogged. So you see, all other countries usually is current in EB2 and EB3 sometimes, but this year we've seen that even all of the countries have a high demand, but 2023 is not as bad as 2013 or 2020, so still good, but not current. EB1 is current, but EB2 and EB3 for all other countries is not. EB5 is where we see backward movement, that is retrogression is what we call it, for the unreserved category. For China, there was no change, January 22, 2014. India retrogresses by 6 months. This is a huge retrogression for India. It's moved back to May 1, 2019, and this retrogression is because of the high demand in the EB5 category for Indian nationals. Indian nationals never used to use EB5 categories as much as China would, but now it seems that there is no change in China and there's a retrogression in India, so it's catching up with China. 2019, China is 2014. All other countries remain current and for EB5, and India was current not a long time ago, so the retrogression is really surprising. Set aside categories, that is, jobs which are located in rural, high unemployment and infrastructure areas, they remain current for all countries, including for India and China. So EB5, we've looked at all the different categories. Now, if we can look at family-based, if you can go to family-based, dates for filing, not final action date, but dates for filing. So if you look at dates for filing, because we need to look at this because USCIS has said that for employment-based categories, they're going to look at final action date. But for family-based categories, since the backlog is not as much as employment-based categories, they're still looking at dates for filing category. But this, of course, might change, and they might start looking at final action dates. The advantage of dates for filing table is that usually they're more advanced than the final action date table because they're allowing you to file in advance. The premise is that USCIS is hoping that the dates will soon become current, and they're thinking that by the time they process your case, they're expecting the dates to become current, and that's what the dates for filing table is. So you're being allowed to file your adjustment of status ahead of time, before your priority date becomes current. So for the family-based category, the only significant change that I wanted to talk about is the F2A, so spouses and unmarried children under the age of 21 for permanent residents. So if you're a spouse of a permanent resident or a child of a permanent resident, you will see forward movement next month. So there's a movement of 3 months and 2 weeks across the board for all other countries, China, India, Mexico, and Philippines. So for India, the previous cutoff date for last month was October 15, 2024. Now it's moved up to February 1, 2025. For China, it was October 15, 2024, same as India. And again moved up to February 1, 2025. So India and China are exactly the same dates. For all other countries as well, it was October 15, 2024 and moved up to February 1, 2025. So same thing with Philippines, same thing with Mexico. All the dates are exactly the same as India and China. This is an anomaly because usually India, China are way behind on everything, all the dates, but here they're pretty much the same as all other countries and Mexico and Philippines. So February 1, 2025, folks, is the priority date, whichever country you're from, moved up by 3 months and 2 weeks. So if your priority date has been reached, please reach out to your attorney and file that adjustment of status application ASAP because the dates may not remain the same, may not move forward, may not remain the same, and may actually retrogress. So you never know until the beginning of next month what it'll look like for June. So be prepared, get ready to file your application next month. And what to be expected for the following months? For June, as I was telling Nipasa, we don't see any major forward movement, maybe a slight forward movement for EB3 category, and maybe some forward movement in the F2A family-based category, that is green card holders, spouses, and children. But otherwise, I'm not expecting to see a big forward movement in any other category. Nipasa?
Can you hear me? So I was just saying
Yes.
thank you so much, Prashanti, for highlighting those major changes in the F category and the E category for family and for employment-based categories, respectively. So those were the changes, friends, and the final action dates that you need to keep in mind and prepare yourself. So, yes, I also can see a lot of folks, who have joined us with their comments. So, hi to Hemant, Aduro, Jadav, and V2. Thank you for joining us. We're going to take your questions and comments very soon. Please stay with us. All right. So Prashanti, what do you expect? What's going to happen, and what is the now steps for people whose dates are current?
Nipasa, before I continue, can you actually see me because I
Yes,
can't?
we can see you.
Okay, all right, because I can't see you, so just letting you know.
Okay.
It's a blank screen for whatever reason, but it's okay as long as you can see me and you read out the questions to me. It's fine.
Okay, sure, sure.
So yeah, okay. So what was your question again? Please repeat.
So Prashanti, I was just going to ask you, like, what should the next steps be for folks out there who have their dates current right now?
For the dates, if your dates are current, please make sure you look up your make sure you have your birth certificate. Because those are documents, marriage certificates, because these are documents that sometimes people don't have ready. Get your make sure your passport is valid, very important. Make sure that you get your medicals done on time because sometimes medicals can delay things. And if you don't have your birth certificate because it was never issued or you lost it, if it was never issued, then make sure you contact your the city where you were born, the registration of births and deaths if you're from India or depending on whichever country you're from. And if it was never registered, if you're from India, then make sure you get a non-availability certificate and secondary evidence like affidavits from your parents, from other people who were present at the time of your birth, and maybe a school leaving certificate. And every country, just to let you know, has um, different uh, criteria for what to do if there's no birth certificate and when not having a birth certificate is acceptable.
Right.
But the marriage certificate you have to have if it's a spouse-based case. Um, and if you are in the US, then make sure you're in status otherwise.
Okay. And now we hear that, especially for marriage based, I mean, people who are married also, they really need to prove that their marriage is real, it's the real deal and not something they did just for getting a green card.
Correct. So you have to show that it's a bona fide marriage and it's not a sham marriage. And there is a presumption of fraud for all marriage based cases.
Okay.
So you have to show them that, the marriage is actually not a fraudulent marriage. So the onus is on us to prove to them that it's a real marriage and not a fraudulent marriage. And so there are a lot of documents required to that effect. And to name a few, you have to show that, you're living together, maybe show a lease with both names on it, plenty of photographs, the marriage pictures, maybe the wedding card, joint documents such as joint tax returns, joint bank statements, credit cards, health insurance, life insurance, as much as you can get that shows that you're, actually married and living together.
Mhm. Interesting.
Maybe affidavits from your neighbors, etc.
Yes, so much to prove. So just get ready with anything and everything possible to prove that your marriage is real, and especially your birth certificate. Also, in case you do not have it, there are alternatives. And in case you need an attorney to consult with, especially with regard to your case, why don't you check out Attorney Prashanti Reddy as well? You can call her up, and her number is 212-354-1010. You can also email Attorney Prashanti Reddy at Prashanti at reddyesq.com. You can check out the spellings on the screen and go visit www.reddyesq.com to get to know more about Attorney Prashanti Reddy and the law offices of Prashanti Reddy. So, also at this point, friends, I really hope that you're enjoying our content, and do not forget to subscribe if you haven't as yet already. So our handle is at Immigration Talk Show, and if you're watching us, you know where to hit the subscribe button and also the bell icon, so that whenever we have discussions like these, you're notified and you can participate and maybe ask your questions. Where we have the attorney, with us for an hour, and it's take it as your opportunity, as your privilege, because this is all for free. So join us, and don't forget to subscribe to us. So, Prashanti, I would let's take up some questions from the audience quickly before we hit our questions. Hemant is saying F2 to H1B process. So, I think if you can highlight a few steps.
F2 to H1B. Okay. So F2 is basically student visa, a dependent student visa, I must say. And he wants to move to a H1B, right? Hello?
Visa to H1B.
Hello?
Can you hear me?
I couldn't, now I can. So is it an F2 to a H1?
Yes, F2 to H1B process.
Okay. So in order to file for a change of status from an F to to a H1, first of all, you might be subject to the H1B cap. So you have to make sure that you've registered for the lottery, and if you get picked in the lottery, which I'm presuming he might have been picked, um, or maybe he's trying to file it for next year. But if you're picked in the lottery, then it's a simple change. Not simple, but it's a change of status process. You can file for a change of status. You don't have to leave the country. You can, if you want to, you can do consular processing, leave the country, come back on a H1 visa, or you can just file for a change of status from F2 to H. Key here is that you're able to show that you're the principal person, the F1 person who you're dependent on is maintaining his status. You have to show the marriage certificate to show that you are a dependent. So your spouse's documentation to show status, your marriage certificate are key. And of course, the rest of the documents to show with reference to a H1B, filling out the proper forms, submitting educational credentials, getting an evaluation done from an expert, um, and having a proper job description uh, and a job title to show that it's a specialty occupation and at least a bachelor's degree in a specific field is required for the position.
Okay. Thank you so much for taking that up for Hemant. And Hemant, I hope that you got the steps, highlighted and noted down, so you know what to do next. So all the best also. And now we have Oduro who's asking, so please can EB3 row move again?
I wish I knew, my dear. I wish I knew, and I wish I could say it will.
Yes.
And then um, there'll be a nice thing to say. But we don't know, to be honest, and we can't say. But in general, um, it's not looking that good. There might be some forward movement actually for EB3, since the demand seems to be higher for EB2 right now. Most people, Indian nationals, qualify for EB2 at least. So EB3 might move, since most people are filing in EB2 by default. Most of them have master's degrees or bachelor's plus plenty of experience. So yeah, you might see some forward movement in the EB3 category. How much? It's hard to say.
There you go. Oduro, I hope you've gotten your answer. And this sounded more like a prayer, right? And a wish. So let's hope for the best. Jadav, American Dream in trouble. US visa bulletin for May 2025 brings bad news for Indians. Will this trend continue under President Trump's administration?
To be honest, we can't blame President Trump's administration for everything. So the visa bulletin really is nothing to do with the administration. It's the question of demand and supply. But of course, the administration can help in the sense that they can pass a bill if they are able to gather enough votes in the Senate and the House to make some changes to, the priority dates or the way priority dates are counted, or to add priority dates to the system or to remove um, all restrictions on green cards, but it doesn't look like there's enough political will for that to happen right now. Immigration is not a hot topic in a good
Mhm.
way. I think also, even if you look at the general consensus, people are not very warm and fuzzy towards immigration right now. So it will. Can a miracle happen? Of course, it can happen. Um, I'm just hoping it will,
Mhm.
and that under the present administration, they will pass a bill which helps at least legal immigrants, stay here because they're all following the rules. They're doing everything they need to do, so it's only fair that they should be allowed to stay if they're following all the rules, and that they should have, at least the same opportunities that people from other countries have, right? So it seems unfair that Indian nationals have to have a much, much longer wait while other countries don't. So maybe, removing the per country limit to, I don't know what can be done. It really depends
Proportionate,
on
I
what the
think.
administration, yeah, is willing to do. So we have to wait and see. Let's hope it's good news.
Let's hope so also. Thank you, Jadav, for your question, and thank you, Prashanti, for taking that up. So now let's take up V2. V2 is asking, I have been laid off on H1B. I have a pending I-485 marriage based and approved EAD. If I can't find a job in 60 days, can I change status from H1B to B2? Will this impact my pending 485 petition?
So I don't understand why you want to change to a B2 if you have a pending 485 application. First of all, you will not get a B2 if you have a pending 485 application because you have a pending immigrant application, right? And for B2, you have to show that you have no intention to immigrate. And there's no necessity to change to a B2 because you are a pending 485. So you just move from your H1 to a pending adjustment of status. And I mean, once your EID gets approved, you can start working. And the good thing is you can work for any employer because it's a marriage based case. It's a family based case. It's not an employment based. So you don't have to stick to the employer that, filed the green card for you or worry about AC-21 or moving employers, etc., etc. So, I mean, just get on to the your green card adjustment of status unless you are worried that your 485 might get denied for some reason. Then I would advise you not to move, of course. But filing for a B2 may not be the solution because getting a B2 while your 485 is pending, because there's a question in the form. Have you ever filed an immigrant petition? And then you have to say yes, and then they may not approve the B2. So that's a problem.
Okay.
So if you don't foresee any issues with your family-based case, you should just move to that.
Okay. Okay, all the best, V2. But yes, I don't think you really need to shift to B2 for real. So thank you, Prashanti, for that good advice and for taking the question up for V2. Let's take up this one from Nirav now, and this is with regard to EB5 unreserved category visa for Indians would move backward by over 6 months to May 1st, 2019. China, on the other hand, remains on January 22nd, 2014. I think there is no question. It's just a remark, a statement.
Yeah, correct. Yeah, but China is much more backlogged than India. But now, as I said, India is catching up with the demand for EB5s. As EB1, EB2, and EB3 categories backlog, you will see EB5. There'll be more demand for EB5 as well, right? So, because a lot of you professionals who have been here for many years are willing to, invest in the country. It's not just It's not just businessmen or companies. It's also people who are willing to invest into the regional centers, like passive investors, are willing to invest for the sake of getting the green card. So we're seeing a lot of that happening because there's no scope of getting a green card in the near future in the EB2 and EB3 category, and now EB1 is also
Backlog.
backlogged.
Yeah.
So there's going to be pressure on all categories. And EB5 is the last of it, but now we're seeing pressure on EB5 as
Right,
well.
right. And with the Neerav's comment, actually, I also have an additional question, which is, since we see that the EB5 unreserved category for India, it has retrogressed by more than 6 months, but for China, the cutoff stayed the same. So, what does this contrast tell about, global EB5 demand and priority handling?
Um, China demand has always been high for EB5 because they don't come as much as the Indians do on professional visas. It's mostly passive investors. There's a lot of money in China and they just invest passively into the US and try to get a green card that way. India traditionally follows the employment-based route, the student route, employment-based, and then employment-based um, EB1, EB2, and EB3 category. Um, so now with those other categories failing, or because of the backlog, now people are looking into other ways of remaining in the country, and I think that's why EB5 India has the demand has increased for EB5 India.
Mhm.
Um, and I mean, as long as the other categories are backlogged, we will see more and more demand for EB5 India. And I think that is it. I don't think, I mean, the US has always been, um, you know, uh, a place that everybody wants to be, right? Anywhere in the world, people want to come to the US. And there's no exception with reference to Indians. But with reference to EB5 specifically, I think the demand is more because of the backlog in the other categories.
Right, and thank you so much. But Nirav is back asking another question: why there is a huge difference between the two countries?
Because China always the China EB5 program has always been backlogged for many years. Because as I said, I guess I just answered that question, right, Nimasa? I said that Chinese investors, they have a lot of money and their traditional route is business and investing. They don't come in the employment based route as much as Indian nationals do. That's why you see a huge backlog for EB2, EB3 in Indian nationals. In China also you see a backlog, but it's not as bad as the Indian
Right.
nationals. But EB5 backlog, you'll see the roles reverse and you see a
Mhm.
much bigger backlog for China
Right,
versus versus India.
right. So there you have it, Nirav. I hope you've gotten your answer, and thank you, Prashanti, for taking that up. And V2, by the way, says thanks, Prashanti, for reply. Thank you too, V2. So, coming to our questions, Prashanti, with employment based categories like we are discussing, EB1 and EB2, also they remain stagnant for India, China, and even other backlogged countries as well. So, what can applicants, realistically expect in the next few months? If you can just predict, maybe. I know it's hard.
Yeah, and I think we discussed this a little
Right.
bit, but we're not expecting any, um, surprises. I don't see why we will be surprised. I mean, um, so expect more of the same for the rest of the year. And we always see that by September, things become retrogress or they become completely unavailable. And then by October, um, the start of the new year, again, things come back to normal. Um, but generally, the trend has been since COVID. During COVID, we saw that the dates became available. There was a lot of forward movement for EB2, EB3 in India and EB1 as well, and rest of the world. But we've seen after COVID, when the demand at the consulates went up for family based as well as employment based, went up to normal levels. We've been seeing um, year after year that the number of visas uh, becoming available, the extra visas, usually the number of visas is always same, but the extra numbers becoming available because of other categories not being used, or other categories falling down into, EB2 and EB3. Family based falls down to employment based. EB1 falls down to EB2 and EB3. EB5,
Hmm.
um, you know, etc. So we've seen the extra visas available have gone down more and more over the years,
Yes.
and we've seen that trend. So I guess, um, I mean, for next year also it'll be the same, or you might see some lesser number of visas available. So I guess the time is ripe for some legislative action to happen, and I hope it does.
Yes, we all do. Really, really, Prashanti. But thank you so much for taking that up. And now, if we look at the family sponsored categories, they haven't moved much either for whether you say Mexico, Philippines. And if you can tell us what's really holding back these family based green card approvals, and do you think there'll be a relief soon in the horizon?
So the same thing for family based. I mean, Mexico is always backlogged because, I mean, of its proximity to the US, and they don't use employment based very rarely. They mostly immigrate through family based
Okay.
green card. So always have a higher backlog, and Philippines is the same, though they do use some employment based, but mostly they immigrate through family sponsorship.
Okay.
That's traditionally been the route that those countries have taken. So you can expect that family-based cases will be backlogged for these countries,
Mhm.
Mexico and Philippines. Um, and Again, I don't see a potential for forward movement unless the demand decreases, and maybe with the stricter vetting that the present administration is doing, people may not want to come to the
Mhm.
US. That's the only way the demand can decrease, or are scared to come to the US. That could be a way the demand would decrease. But um, for these kind of, I mean, I think that works more for asylum cases and people coming, undocumented people coming to the borders and applying for asylum or refugee status. Not so much for family-based categories because they come with a green card. They apply, and then everything gets approved at the consulate, and they come with a green card, so they're not worried about their status. But in general, obviously for there is some kind of negative impact on immigration on the whole when the vetting increases, and that could lead to the backlog decreasing. We have to wait and see.
Right, Prashanti, right. And also, maybe if you could tell us if there are new paths or legal workarounds, that they should explore while they wait for especially Mexicans and the Philippines out there.
So the other thing, Nipasa, again, what I remembered about reducing the number of cases, what could cause a reduction is also the public charge rule. During there was a public charge rule, then during Trump's administration last time, he really restricted who qualifies for a green card, and he expanded the public charge rule uh, quite significantly. Basically, to the extent that family-based cases, if you didn't have a job, then it's most likely that you could be denied a family-based application because they would say that you are likely to be a public charge and you didn't have an education, etc. So a lot of people from Mexico, Philippines, these who are not professionals, may not actually have jobs or an education, etc. Right? Um, so that could decrease again the amount of filing if he again restricts the public charge rule. But last year when he tried to, expand the public charge rule, the courts interfered and it was put on hold. So the same thing could happen, but that's one way if the present administration tries some measures to decrease legal immigration as well, which I mean they are doing in certain ways. That could decrease the demand, but we have to wait and see.
Yes.
What was your other question? Other ways, right, for
Yes. New
Mexicans and
pathways.
Philippines? I mean, they are. It is what it is. It's nothing new. And for Mexico, of course, you can do a TN visa,
Mhm.
That's a non-immigrant visa. So that's the additional visa available for people from Mexico. Philippines doesn't have a specific visa available. They just are like the rest of us. We make do with whatever visas they
Hmm.
are. Um, so yeah, it's either the H, the L,
F.
um, or you get the F, the student visas, or apply for employment-based or family-based green card. So those are the ones, those are the pathways. EB5, of course, if you're an investor.
Hmm.
There is an investor visa, but no one seems to be using it because it's not, doesn't lead to a green card. It's more like a humanitarian. It's like a parole, not humanitarian, but it's a parole. So not many people are using that investor visa category. Um, so yeah, that's all there is.
Any news on
I mean,
Trump's
there
gold
are pathways, but any news on what?
Trump's gold card, the 5 million gold card?
The gold card is not going to um, cause a significant influx of people into the country, and neither is it going to be helpful for 99.9% people because not many people can afford that 5 million.
True.
People who can afford the 5 million may not want to come to the US.
Yes.
Or they have other ways of coming to the US because they can apply for an L1, they can apply for EB5.
Correct.
So, with reference to the gold card, I think it's a good thing, but it shouldn't replace the EB5. If it replaces the EB5, then it's a bad thing.
Hmm.
But if it doesn't, then I think it's good because that provides an additional pathway for businesses to come to the US and investors to come to the US.
Right.
But there's no further news on it. We've not heard anything except for the proposal that we heard, last month.
Yes. Yes. But yes, let's hope for the best. Let's see what options we have, and folks out there, keep staying subscribed to us, and if you haven't as yet, subscribe now. But also at the same time, watch out our space, because we keep coming up with the latest updates on all immigration based news and updates that you don't want to miss out on. So yes, subscribe now. Our handle is at Immigration Talk Show, and you can also check us out not just on YouTube, but we are also there on LinkedIn, Facebook, X, and also on Instagram. On X, we are at Immy Talk Show. So check us out. And if you have any questions with regard to immigration, you can also tag us. All you have to do is write to us at Immy Talk Show. So we also have a few questions from our Facebook groups, right? Control, if you can also display them, please. But meanwhile, we can answer Prashanti, if you can tell us. We saw a small 2 week advancement on the EB3 India. Can we interpret this as a hopeful sign, or is it simply a technical adjustment without much of a practical benefit?
No, I mean, obviously there is still scope for, they think there's scope for it to move forward. The way the Department of State does this is they try to estimate, they do make an educated guess, is what I'm thinking of. What is the demand for EB3 and how much, um, how forward should they move the date so that all the numbers are used up? The ultimate goal is that all the visa numbers should be used up, right? So that's their goal. So they inch it forward based on what is the demand. They look at how many cases are pending, how many EB3 cases are pending, how many have been filed, etc. So um, yeah, so that's the basis for them to do that. It's based on something. It's not just a technical thing. It's based on an estimation of what is the demand for EB3, and we see the EB3 EB3 demand is slightly lower for India when compared to EB2. So I think there's still a little scope for forward movement since there is a difference in dates between EB3 and EB2. Uh, Previously, we saw that EB2 and EB3 dates were the same for India. Now there is forward movement because that's the reality, because the demand is not so much. So they're trying to push it forward a little bit so that it reflects, what the actual demand is.
All right. There you go. Thank you so much, Prashanti, for taking that up and for highlighting. Maybe yes, it's mostly on the demand. So Now we do have some questions from our Facebook groups. Let's address them also, Prashanti. Let's take up this first one. This is on the screen from Sheku. My friend details EB1B I-485 application date is 31st of January 2025. Fingerprints were on 26th of February 2025 and the priority date is May 2020. What is the likelihood of getting a green card by June 30th? Any information?
It's hard to predict um, how the dates will move, and sometimes it's hard to predict whether they'll move or not. Also, we've seen, EB1 has not moved at all for several months, and that's been the case with, a lot of the other categories as well.
Hmm.
So it's not like every month it moves a month. It doesn't work that way. For several months, it doesn't move at all. So difficult to predict whether it'll reach that date or not. That's all I have to say.
Okay. Well, thank you so much, Prashanti. Let's go on to our next one. And this is from Shabib. What is current time for EAD if I-485 pending with USCIS?
EAD is taking about 6 to 8 months, but again, they are not uniform in their processing times. Sometimes I've seen EADs getting approved faster, and sometimes they take longer. But I always tell my clients an average of 6 to 8 months,
Okay.
which could be 2 months this way or 2 months that way. But I know it's a big, it's the gap is wide, but that's what it is.
Okay. Thank you so much, Prashanti, for taking that up for Shabib. And now we have from Ghadir. How to apply for EB2 NIW?
How to apply? You have to file an I-140. Um, you have to show that how you qualify for a national interest waiver. You have to show that your work or whatever you've done is in the interests of the nation to give you a green card. So you have to show that you have exceptional ability in the STEM field, or it could be arts, or it could be science, math, whichever field, in sports, so whichever field you excel in, you have to show that you have that exceptional ability, and this is documented through awards, through memberships in prestigious organizations, through your research, if that's the basis for your qualification, through your publications, through press. Uh, if you have press on your name, because if you have extraordinary ability, exceptional ability, I would think that people would know about it and they would write about it. So there's many ways of documenting this, but you provide all the documentation, maybe reviews from people that are top in your field, saying that your work is exceptional, um, and also you have to the basic document that you have to provide other than the I-140 application is a memo, a brief showing how you fit into those categories. So there's several categories, and under each category you have to give information as to how you fit into that category and provide documentation to supplement it.
Okay. Documentation has become definitely very, very important. So, friends, I hope you're keeping a check that they're all updated, by the way. So, God, now let's go on to our next one. We have up there question. Hello, everyone. Has anyone on a non immigrant visa, F1 or J1, with a pending or approved I-140, recently traveled without facing any issue at the airport? I am talking about the current time.
Yeah, so that is always could be problematic, because if you are an F1 or a J1, there's no dual intent. So you're not allowed to file a green card and be on that status, because you have to show that you do not have the intent to immigrate. And that is true even if you're on a B1 or a B2. So when you travel back into the country, there is a possibility that you may not be able to come back. But having said that, I've also seen many, many instances where people on a B2 who have an I-130 approved or pending, which is the family-based immigration, right? Come in, no problem at all. Some come in even after they're asked the question as to why you're coming, they say, "Oh, we're coming to visit our spouse. We have an I-130 approved," and they don't seem to have an issue with it. So if they want to, they can use that as a reason not to allow you in. And that's always been the case. And I would presume now with extreme vetting, and if they want to decrease the number of, uh, uh, allow less people into the country, then that would definitely be a sufficient reason for them to stop you from entering into the country.
Thank you so much, Prashanti, for taking that up. And now we have Sam's question. Hi everyone, my I-765 got denied over an error on my part, and my I-485 is still pending on RFE, which I responded to over 2 months ago. But the status hasn't changed, so I don't know if they even received my response. Anyone went through this before?
The status on the 485 really doesn't matter because they don't always update the status. So don't worry about it. If you submitted the RFE, and I'm hoping you submitted by some kind of courier service, or if you submitted it online and you've received confirmation that it's been received, then you should be okay. I wouldn't worry about it.
Okay. All the best, Sam. Thank you so much, Prashanti, for taking that up. And with that, we have completed taking up our questions from our Facebook group. But that said, Prashanti, I also have a couple more questions. Maybe we can address them before we leave. So, the options, what options do EB5 investors from oversubscribed countries they have, if they're caught in retrogression and if they want to switch to a reserved category like rural or any other, do you think it's a viable solution?
Well, they have to first of all then invest in that area. Um, so they'll have to move their investment from that category to the other
Okay.
category. Um, and in some instances, I mean, if you belong to China, the wait is so long that I don't know if AB5 even makes sense anymore because the processing time, first of all, for AB5 is about 3 years just to for the first step to be processed. Then you have to wait 2 years and remove conditions, and that is taking another, if they process it again in a year or two. So altogether, you just for processing and getting a green card, it's 5 years, right? And then if your visa number is not available, it means you can't file for adjustment. So you can't actually get the green card. You'll only be, in a pending status. So then you might as well file in the EB2, EB3 category or EB1 category, as a multinational executive. So and you don't have to then invest, all that money in the US. So I think because of the delays in processing times and because of the oversubscribed, because of the priority dates not being available, it's becoming less and less of a sought after visa as it used to be, the EB5.
Mhm.
Um, because even if your visa number is available, you again switch to your category and you apply in a rural area, um, you still have a wait because of the processing time.
Yep.
So you have to weigh your options depending on which country you come from. Might make sense, might not make sense. So it's an individual's decision, and always, speak to an immigration attorney, and they can give you proper guidance on, what is the best option for you.
Right, right, friends. And if you're looking for one, why not check out Attorney Prashanti Reddy also? You can call her up, and her number you can note down is 212-354-1010. And you can also email Attorney Prashanti Reddy at prashanti@reddyesq.com. Please check these spellings out. It's displayed on the screen below. And you can also go visit www.reddyesq.com. Yes, and friends, also don't forget to subscribe to our channel, especially folks out there who are resonating with our content, who are getting their answers, especially Neera, V2, Jadav, Ajuro, Hemant. Thank you once again for joining us with your questions. I hope that you know now what to do next, and even if not, friends, check us out, check out our space because we have a lot of updates that you do not want to miss out on. So, yes, Prashanti, also, before we leave, if you could just tell us, with President Trump's administration renewing America First immigration approach, what impact are we seeing in legal immigration trends, especially for skilled workers and investors?
Yeah, so I think we discussed this a little bit, right? When
Yes,
I was talking about what to expect with reference to visa retrogression
yes.
and
And
priority dates,
if
etc.
only we could reduce the
Um,
per country cap, also the percentage.
right. Right. So we were discussing that because of the America First agenda, if that results in less people wanting to come to the US because it's just harder, it just makes it harder for both legal immigration, non-immigrant visas as well as immigrant visas, then you'll see that, more visa numbers will become available to people who are already in the country.
Mhm.
Uh, but to what extent that will happen, we have to wait and see. So that I would say is an impact that uh, Trump's America First policies could have on the priority dates, especially for people who are in the country. Um will it have any impact on priority dates with reference to new legislation? I don't see that happening right now. Nobody seems to want to do anything positive with reference to immigration right now. There seems to be a lot of negative thinking on immigration. So I don't know if that's going to change, but you never know because we never know really. So let me just say that and hope for the best
Yes,
that there'll be some legislation introduced which I mean, if the legislation is introduced that's pro-immigration, pro-legal immigration, I think it'll have a very good chance of passing
yes,
the House and the Senate because first thing is Republicans have both the House and Senate right now, and Democrats are willing to pass that kind of legislation as long as Republicans are. So it has a good chance of passing, but I don't know if there's any will to do that right now.
right. Right. Thank you so much. I think, Prashanti, with that, we have definitely covered quite a bit. And maybe if you have any end notes to wrap up our session for today, especially for folks out there who are watching us right now, it would be great.
So all I have to say is no matter what your priority date is,
Yeah.
what your status is, just be safe and make sure that you maintain your status at all given points of time. Uh, make sure you know what the laws are and make sure you follow them very carefully. Um, keep track of your status as to when it's expiring. Read up about immigration laws. Even simple things like traffic violations now can hurt your status. So just be vigilant and be safe, and also, make sure that you're aware of what the law is.
Yes, it's very important. Knowledge is power now, friends, and keep yourself updated. And I think you are on the perfect place right now. This is Immigration Talk Show, and our handle is at Immigration Talk Show. Subscribe to our channel, hit the bell icon, and keep watching our content because there are so many updates you don't want to miss out on, especially with new changes coming up and new updates every day. So we do have a lot to share with you. Check us out. And also, in case you want to have a one on one consultation with attorney Prashanti Reddy, go call her up. Her number is 212-354-1010. And you can also email Prashanti at prashanti@reddyesq.com. And go visit www.reddyesq.com to get to know more about attorney Prashanti Reddy and the law offices of Prashanti Reddy. That's it, friends. Thank you so much for joining us. In case you have any questions that you want to direct to me, and maybe I can forward to the attorney, just email me at neep@staffingme.com, or you can call me also, WhatsApp me on this number. This is my number, 408-335-6444. Once again, I repeat, 408-335-6444. Thank you so much, everyone, for joining us today. I hope you had a good time. And once again, do not forget to subscribe to our channel in case you've forgotten or you haven't as yet. Do that and share this content with all your friends and family who could benefit a lot more from just being there on your phone. So, thank you so much. And Prashanti, thank you for joining us today. It was a real pleasure and an honor having you back again. So, hoping to see you soon.
Thank you. Thanks, Napasa.
Thank you. Have a good day. And everyone out there, y'all also have a good day. Thank you for joining us once again. And yes, this is Napasa saying bye for now. But stay tuned because we have daily immigration dose, which I'm going to come back again with my co host Sam. So join us there and let's discuss a few things together. Thank you, everyone. Bye for now. Happy to be back here. And thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also Twitter. And I'm happy to tell you that you can also participate in this webinar with us. But before we move ahead, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, thank you so much for joining us today. And we've got a great session lined up for you. And today we are diving into a topic that's vital for many businesses and workers across the United States, the H2 visa program. And so, whether you are a business owner seeking to sponsor seasonal or temporary workers, or a worker instead in learning more about your options, this webinar will be invaluable. And I'm really thrilled to be welcoming our guest for the first time on Immigration and Jobs Talk Show, none other than Megan Kirkner, who is the founder of Kirkner Law PLLC. With nearly a decade of experience in immigration law, Megan has become an expert in H2A and H2B immigration matters, and she'll be walking us through everything today you need to know about legally sponsoring workers and also exploring the processes of working as a seasonal temporary worker in the United States. So yes, I think you can go grab a pen or paper if you're still the old school, or maybe even note down some pointers in your tab or your phone or your iPad. Thank you so much for joining us, and let's get ready to really learn some key highlights today and these insights that Megan is going to, share with us. So, Megan, thank you so much for joining us today. Really happy to have you here.
Hi, great to be here. Thanks for having me.
Yes, Megan. I don't know if the introduction was enough, but we would love to know you much better. Please tell us about yourself and how busy you are these days.
Sure, like many immigration practitioners, it's a hot time. There's with unemployment where it is, everybody is just looking for people to fill empty slots. The H2B and H2A realm is just extremely busy. I service employers all around the U.S. In both H2A, which is agricultural, and H2B, which is non-agricultural workers in the seasonal temporary visa process. Been doing immigration for over 10 years now, and it is a hot segment right now, and we're all on pins and needles with the U.S. political climate, and just hoping we stay busy.
We are. I already feel it is, and especially with the elections just over just some time back, and everything
Yes.
changing right now. And in the next coming months, we are going to see a lot more
Mhm.
changes. I think there's a lot
Yeah,
on our plates, on everyone's plate. So,
very much so. A whole another segment for that.
for sure, Megan, for sure. And today's topic. So, what can folks out there expect from today's webinar from us?
Sure. So today's focus is really going to be on the H2B side of the seasonal worker program. The agricultural H2A side, it would have to be a whole nother show. But what you should learn, how an employer would get involved in the program, whether or not they would qualify, how the process looks, what the risks are. What compliance components they need to be aware of, what workers should know, and what they should know their rights are in the process so that they are not taken advantage of. So really just trying to focus on giving a little background knowledge from start to end, on the employer side, and touch on the, employer rights side as much as we can.
We will. And I'm sure folks out there are very excited as well. So happy to tell you that you can participate wherever you're watching us. And if you have any questions, especially regarding the topic, please feel free to drop them in the comments. And Megan is definitely going to be very happy to take them up later in the show. So I'm excited too, Megan. Thank you so much for doing this today. And
Sure,
without
happy
further
to.
ado, I have a few questions lined up. So let's go ahead with the first one.
Sure.
So, what are the key steps an employer must take to obtain a temporary labor certification from the Department of Labor for H2B workers, and what documentation is required?
So, just as a little bit more background, the H-2B is a full-time temporary non-immigrant visa. It is seasonal. So unlike many other visa types, it's something you have to apply for every year. Unless you're doing a one-time need, that's a separate category for like a nanny or a caregiver. That would be for up to 3 years. The rest of the visas, the bulk of the H-2B process, for your hospitality, landscaping, seafood industries, construction industries, those are seasonal or peak load, meaning it's an annual application. It involves 3 separate government agencies. That's Department of Labor first. We'll get into what that entails in a minute. The USCIS, U.S. Immigration Services, is the second agency, and the third would be Department of State. That's the consular processing. So that's where the worker would come in, and that's at the point that they would go get their visa. The first step in the process is critical. One of the key compliance components of this program is that all workers are paid at least a prevailing wage, which is mandated by the government. It's to ensure that they're receiving a fair wage based on the type of position they're working in, and the location and experience required for that position. So, it just really ensures that the program maintains its integrity and no one's being paid something that's too low for what they're working on. That's the first step in the process. All of these steps in this process can be time intensive. So it is very much sensitive to what part of the year you're applying for, what your dates of need are. So this prevailing wage step takes up to 60 days sometimes. So you really have, for all parts of this process, you need to allocate at least 6 months. You need to know at least 6 months ahead of time in order to ensure you have enough time to file with each agency. The way the program is set up is that there's 2 halves of the fiscal year. So that if you're based on your start date of need. So if your start date of need is in October, you'd really start prevailing wages more than likely in April, so that you can file in July. You file your H-2B application, which is an ETA 9142B. That's the second step in the process. Once you have prevailing wage, you can start that process. And again, if you're at April 1st start date or later in the second half of the year, it goes by the government fiscal year, which starts in October. My apologies. you will need to start that process probably in August of the preceding year. If you're looking for instance, starting an H-2B worker April 1st, 2025, you're going to need to have already started that process. It may be too late at this point to get a prevailing wage back in time to start the process for next spring. That being said, once you've gotten that prevailing wage and you file the second step in the process also with Department of Labor, that actual H-2B temporary labor certification, that would require you to set forth with the government whether you're filing for one-time needs, seasonal, or peak load. So that would entail documentation if you're a new filer, a new employer, establishing your seasonality, establishing your season and your need for the number of workers you're requesting. Typical documentation would be a statement of need, which again explains your business, your season, your industry. Taxes for the company, could be revenue charts, payroll showing when you have workers. Those are very common documents, as well as contracts. Really what you're showing at this stage is that your business operates either seasonally, meaning you only operate during the season, the times that you're telling the government you operate, or that you're peak load, meaning you operate year round, but there's a peak, there's an objective increase in your business or revenue during particular months of the year. That would be your season. So all of those kinds of business documents can prove that seasonality, prove that temporary need. Now, that application gets lodged with the government on one of two time periods, depending again on your start date of need. It's either July 3rd for October 1st filings or January 1st for April 1st filings. There's technically a 3-day filing window that you have at the beginning, but it starts on January 1st and July 3rd, unless it's a leap year. So that's when you file that application. The next step after you actually lodge the application with your supporting documentation is your company will be, this is what they talk about when they talk about the H-2B lottery. All of the employers are put into a pot in a computer and randomized. Your company will be assigned a group letter, A, B, C, D, and so on and so forth. And while that letter or that group doesn't truly dictate whether or not you get workers, it's more nuanced than that. It does impact the timelines, and more so for the spring visa half than the winter. That letter will determine whether you beat the cap from in all cases for the most part for the spring. It's there's enough employers or applications for the number of workers in Group A, for instance, in the spring to encompass the entire cap. So if you don't get it, that's not to say that if you don't get Group A, you're not going to get workers. We'll get into it later in the program over what the cap is, if there's other ways to get in under the cap or other mechanisms to file with supplemental visas. We'll talk about that in a little bit. But assuming you get in and there are still visas available to file the next step is filing with Immigration Services. You take your certification from Department of Labor and you file it with the USCIS. If you're approved, then you can move on to Department of State and file for the actual visas. There are more steps, such as recruitment, involved in the Department of Labor step before you get your certification, but we'll kind of delve into that a little bit later when we talk about recruitment and things like that. So there are a few more steps involved with Department of Labor before you get to USCIS, but that's kind of in a nutshell, the general steps.
Thank you so much, Megan. Those are really good points to keep in mind. And thank you so much for highlighting, especially the documents required. So thank you so much. Folks out there, I know you are excited as well. Thank you so much for joining us. I'll quickly say hello to Tanya and Nishtha, who have commented with their questions. Please stay with us. We are going to take them up a little later. So right now, another question I have for you, Megan, and that is, how does an employer demonstrate that there are not enough U.S. workers who are able or willing or qualified and available to perform the temporary work as required by the H-2B program?
Sure. So that is what I alluded to a little bit ago with the
Yes.
additional steps that are really happen between filing your temporary labor certification application with Department of Labor before you get certified. There's something called recruitment. At this point, the recruitment, every employer, once they get a notice of acceptance, they will, meaning that the government hasn't asked for any additional documentation, the government could issue what's called a notice of deficiency asking for more information. But if they don't do that, you get a notice of acceptance and then starts recruitment. The recruitment process is how the government essentially asks each employer to test the U.S. labor market to ensure there are no qualified U.S. applicants who can fill these roles. The recruitment period lasts 15 business days for most of these steps. However, every employer still beyond this recruitment period, at the close of which, at the end of the 15 calendar days, the employer will file a recruitment report which details every U.S. applicant, how they applied, whether or not they were hired, the outcome of that interview, if there was one, if they're able to reach them. Based on that recruitment report, the government will then certify the employer for either the full complement of H-2B workers requested, or they will reduce that number based on how many U.S. hires they make. So if you're asking for 10 H-2B workers and you are able to hire 2 U.S. workers, then you've proven to the government that there are 2 qualified U.S. workers. So your true need is only 8 workers. But in order to get to that process, there are a number of recruitment steps that every employer must take. The first of which is an internal posting notice in their job at the job site. So whether that is a break room or an HR office or a primary office, at least 2 spots at the place of employment must post this H-2B job order. So that would have the terms and conditions of the H-2B position, any job description, title, location, deductions, benefits, all of that information is required in this job order that gets posted at the work site. Now, in addition, that same posting, the same content at least, is posted on the state workforce agency. Every state has a different process for posting jobs that are available to local candidates. Think of it as like Indeed, but it's run by a state. So these postings get put online with the state workforce agency, and every employer must field applicants that are interested in the position. Another required recruitment step is, which again protects U.S. workers, is every prior U.S. worker that employer has had in the past year must get a copy of that job order so that they know they're hiring for that position again. The only exclusion would be workers that were terminated for cause or workers that quit or abandoned the job. So those workers would not get a letter, but other U.S. workers that may have worked seasonally in the past year would be entitled to know that this job is open again. Another item that could be by phone or certified mail is the best way, so the employer is protected and you can prove you've sent it to them, the last known address. Another less common recruitment step is if the employer participates in a collective bargaining agreement, they must publish that job with the CBA representative so that it's advertised across the organization. If the employer has a website or somewhere else internally, an intranet, they normally post jobs, that would also be somewhere that would need to have the job posted if they have one. If they don't have one, it's not something that they need to create for the purposes of H-2B. It's only if it's normal course of business for them to post jobs in that manner. The last part of recruitment is performed by Department of Labor. Department of Labor will post the job order on seasonaljobs.gov and make it available nationally so that anybody who's looking for H-2B jobs or anybody that's looking for a job it'll come up on a search. So if someone searched landscaping in Richmond, Virginia, it may come up. It would be available on that website. So the last component that is important for U.S. workers is to know is that this job rec, even once that 15 calendar or business days have passed, while it won't impact the number of workers the employer is able to get with H-2B, they do need to continue to accept U.S. based applicants up until 21 days before the start date. So it's not going to impact their H-2B worker count, but they do still need to field U.S. applicants. They are obligated to do so. Again, the purpose of that is just to ensure that there's no additional opportunity afforded to foreign workers over U.S. workers.
All right. Thank you so much, Megan, for for the detailed explanation and helping us with the answer for that. Thank you so much. I have this next question for you.
Mhm.
So, what is the current cap on
Mhm.
H-2B visas for fiscal year 2025, and how can an employer access the additional supplemental visas announced by DHS?
Sure. The annual quota for H-2B has been 66,000 since the 90s. And it's divided into two halves. The first half of the government fiscal year on October 1st, that gets there is allotted 33,000. The second half of the government fiscal year, which opens on April 1st, is also allotted 33,000. That the demand far outpaces supply for those initial visas year over year and has for a decade. So in 2017, they started issuing what are called supplemental visas. They are not in the regulations. They're not guaranteed, but the government does have the ability to issue additional visas if they elect to do so, if they can agree to do so. This year, they did announce that they will issue almost 65,000 additional visas for this fiscal year. However, the text is not yet available for the 2025 fiscal year, but if we assume it's the same as the past two fiscal years, which it has been largely the same as far as eligibility and compliance, then we can expect it to be broken down such that a portion of those additional visas will be allocated to the first half of the fiscal year and what they call returning workers. So if you've never had an H-2B, you're not going to qualify for the supplemental visas under returning worker exemption. Those are workers that have had an H-2B at least one time with any employer in the past 3 government fiscal years. So if you had worked for anybody, you would be eligible if your employer wants to file for supplemental visas. So again, that is just a little bit of a security net for employers that miss the initial cap, that they have a second opportunity to try and take advantage of the H-2B visas for this year. There's also an allotment similar to that for the spring. In other words, if you miss the cap for April 1st in the spring, again, if you have workers or know of workers that have had an H-2B at least once in the past 3 years, they would qualify as returning workers. And there will be visas in the spring as well in that same category. Additionally, the spring has another category of returning workers. Typically, that is reserved for late season H-2B employers. So if your start date of need is not April 1st, if it's May 15th or later in the year, there's a separate carve out for supplemental visas in that for returning workers for those dates for those employers. The last option for supplemental visas is what used to be called Northern Triangle. Now it's called country-specific allocation. It is open to workers from a specific set of countries that have never held an H-2B visa, but employers, there's a brand new cap from these supplementals. So if the employer will take recruits from this subset of countries, then there's a whole extra 20,000 visas available to employers who will recruit from these separate countries. Those are Haiti, Honduras, El Salvador, Guatemala. They just added Costa Rica, Ecuador, and Colombia last year. And so I think I might have missed one. Honduras, I think I'm not sure I've said that already, but those countries are a great option for employers who don't have returning workers and have missed the cap. Because the nice thing about that part of the supplemental visas is in the years that they've been offering those, that cap has not been hit to date. As there's first year for everything, but those are a more reliable and a little less risky pool of visas to pull from because they have been more open.
All right. So, yes, thank you so much, Megan, for saying that for us also, and for the detailed explanation. Well, maybe you could highlight also, how the H2B is different from the other employment visas,
Oh, sure.
for folks out there who want to know where can they categorize themselves.
Right. So, as we know, there's an alphabet soup of non-immigrant visas available. All of them have their own eligibility requirements and stipulations. H2A, those who are going to qualify for H2B probably will qualify for H2A from the worker standpoint. Employer standpoint, that's reserved for agricultural companies, employers that work in the agriculture sector, section. It may be farms. That do produce. It just depends. There's a lot of agricultural employers that take advantage of H2A. There are other visas, that so H2A and H2E generally don't require degrees. That's not necessarily true across the board, but it is the only category that's going to have people, without any required specific training. There may be experience or training requirements employer to employer, but as overall, if you're from a country that's on the eligible country list, which you can find online, there will be ways for you to get seasonal employment if you don't have a degree. Those are what H2A and H2B are really good for,
Mhm.
as far from a worker standpoint or from a prospective visa holder standpoint. There's TN visas if you have a degree that, if you're from Canada or Mexico, there's a whole list of occupations and there's no cap for TN. So if you have a degree and you're from one of those countries, or if you're, an employer looking for a particular occupation that falls on the TN list, that's a great way to, have workers come in that way.
Mhm.
TN, there can be some crossover for some of the occupations that are very similar to the kinds of roles that you may want for H2B. For instance, a landscape architect would fall under a TN, or
Mhm.
veterinarian or an animal breeder or something like that that's related to farms, but maybe you need someone with more skills, more training.
All
Um,
right.
so something like that. And there's a whole host of other visas I could go over. I don't know how many of them you'd like me to talk about.
But yes, thank you so much. Thank you so much for highlighting those differences of the H2B and other employment visas. Thank you, Megan. And Megan, we have a viewer who has joined us. So nice of him. This is George from Nigeria. Really happy that you have joined us. So we would love to take a couple of questions from George if he has any. So Control, if you could just let him in. Um, yeah, please ask your question. George, are you there?
Yeah, can you hear me?
Yes.
Yes, we can hear you now. Great.
Okay. Um, the question I was gonna ask had to do with um, you loosening up a little bit regarding your policies. Um, like I said yesterday, everyone does not have to come to America. Okay.
Mhm.
If you if the government actually loosen up a little bit, let's say, just like what you're talking about, they have quarters they're giving for H2B visas. So if you have search for remote, you tell the companies, look, you can get anyone outside of this country. They don't have to come to America, but they're going to be working on the remote basis, right? And
Mhm.
before you have to pay their salaries, then do what they call tax deduction from the salaries before you pay out, right? So I think if that would be looked at, it will be a very good idea, because one of the reasons why you have the Americans coming up with several immigration policies is because you have a lot of people
Can you hear it? I can't hear.
I think, yeah.
papers or documents are being expired, and then they also want to continue the work. Can you still hear me?
I
Yes.
missed that middle part.
Yeah.
I heard that if their documents are expired, but I missed a part
Hi,
of
can you
that.
hear me?
Yes, we can hear you. Could you just repeat the part where just some time back you were saying? George, are you there?
Yeah, I'm
I
here.
think
So,
okay.
did you get what I said?
No, we didn't hear the question part. I'm sorry.
Could you just repeat your question, please? The question you just asked some time back. George, if you're still there.
Yeah, I'm here.
Uh, so sorry, we couldn't get your question. Could you just tell us what your question was?
Okay, the question is, can American government look at, loosening up a little bit and allowing companies, independent companies, actually employ people from other countries without they coming to America and, the American government providing some sort of tax identification number for remote workers. I think if you encourage that, that would actually strengthen the job quality you have over there, and also
The government here in the U.S. has been very apprehensive about changing policy. I mean, like I said, just in my experience with H2B, the quotas have not changed since the 90s. So while there may be many ideas that would be beneficial to both the U.S. economy and workers abroad, I would not expect there to be any meaningful change or positive additions to immigration, particularly with the upcoming administration change. I would not expect that to happen right now. That's not to say it would never happen, but I wouldn't expect a tremendous amount of change, at this point. There are many other countries that allow, such as things like digital nomad visas where they can come work remotely from their home country in the US and do things like that. We don't have anything like that here. Our immigration categories have been fairly static for quite a long time. We have not had comprehensive immigration reform since the 90s. And with the polarization of this topic overall, from an employment and family-based side, I just would not expect there to be any change. There may be many great ideas that people could bring to the table, but adoption or passage of that would be very difficult in this climate.
Thank you so much for taking that up. And George, do you have any other questions? George, are you still there? All right. Thank you so much, Megan, for taking that up for George. I think there might be some network issue, but I hope George got the answer he was looking for.
Sure.
And if he has any further questions, I'm sure George will drop them in the comments or maybe rejoin us soon.
Sure.
Meanwhile, I think let's take up Tanya's question. I run a small landscaping business and want to hire workers for our busiest season. How do I start the process of sponsoring workers under the H2B visa? And are there specific forms or steps I need to prioritize? I think we touched on this earlier already, but if you could just
Yes.
highlight, yeah, anything.
Yes. If it's landscaping, I would assume your busiest season would fall in the spring. So at this point, the first step is starting to file a prevailing wage application with Department of Labor. That's the very first step required, no matter where you're filing, what position you're filing. So you just need to know what position you're filing for and get that application lodged with the government. You can't move on to any other step if you don't do that first. So you should find someone that can file that for you. I have a great number of landscaping clients. So I'm very familiar with that process from start to finish. At this point being mid to late November, it would be very tight to try and get that filed for next spring. Unfortunately, it's not impossible, but timing would really have to work out in your favor. that's the first thing you need to prioritize. And if the only other thing I can say that is if you have workers you want from a particular country, make sure they're on the country list. I get a lot of questions that say they know somebody from X country and that country is not eligible for H2B at all. So if you're wedded to one particular person, make sure that they qualify before you bother starting the process.
Great. Thank you so much for taking that up for Tanya, Megan. Thank you so
Mhm.
much, Tanya, for participating with your question. And well, I have more questions lined up, but let's take up Nishta's question first. I've worked under an H2A visa before. Can I apply for H2B visa next, or do I need to wait for a certain period of time before reapplying? Uh, and how soon can I reapply for an H2 visa after my current one expires? Is there a limit or on how many times I can apply?
Mhm. Okay. So the answer is it depends. You for part of that. So if you have been on an H2A visa, whether or not you can apply for the H2B visa, it just depends on how long you were here on the H2A visa. So one of the eligibility requirements for H2 workers, whether that's H2B or A, you have up to 3 years of H eligibility, at which point, if you enter, say, January 1st, 2020, then your H authorization would have expired in January 2023. So you have 3 full years of eligibility. You can reset that by, if you've been outside the US for 3 consecutive months, then you reset your H time and you get another 3 years. So there's no limit to the number of times you can be on an H2 visa, A or B, but there are time limits for each stay. So if you were to come in, like I said, say April 1st, and you change employers, so you're never out of the country for more than 3 months, then you're going to be limited to 3 years. And at some point during that 3 years, you need to reset. You need to be outside of the US for 3 months to get more H time. And that, you can certainly have an H2A visa, go home, get an H2B visa, and come back. That's fine. You can do both. There's nothing to preclude you from participating in both programs. You just need to make sure you're aware of what your limit is and make sure that you've been out to reset that clock at least for 3 months if you're here for that long.
Okay. Okay. Thank you so much for taking that up for Nishta and for the detailed explanation, Megan. And now we have Samuel. Samuel is on YouTube. He also has a question asking administrative processing in H1B visa for 9 months. What can be the cause?
There is not very much transparency for administrative processing. For instance, if I, as the attorney, email the consulate and ask, why is this an administrative processing? What do you need from me? What do you need for the worker? They will give me a canned response that just says it's an administrative processing and we'll contact you if we need anything. There could be a whole host of reasons why you might be administrative processing. Your name, it could be something as simple as your name is similar to someone who has some overstay issues or a travel issue or is on a list somewhere, flagged in the system. It could be that you've overstayed. It could be that they're unsure of your intent to return home. That's called, immigrant intent. They could be questioning whether or not you will stay permanently if you're issued the visa. There's a whole number of reasons that we'll probably never know the answer to, unfortunately. For instance, I just had someone try to process in South Korea, and she has no red flags. She's no criminal history, one prior U.S. visit. There's nothing on paper that should have precluded her from being issued a visa, but she was put in administrative processing briefly, and then, certainly not 9 months. But the reason they gave ultimately for being refused was that they questioned whether or not she would return to her home country at the end of the visa. There's the consular officers are given a great bit of discretion to review the applications, and they don't give us a lot of transparency. I said South Korea for that process. So, there can be any, and this would come up from any country, anybody from any country on the eligible list. And sometimes there's a surprise like that. For instance, that client, it was a surprise to have that happen. There were no indications prior to going to that interview that there would be any issues. So I wish there was some way to find out why you're in administrative processing.
Right.
But there's not very many good ways to do it.
All right. Thank you so much. Thank you so much for taking that up for Samuel. Samuel, if you have any further questions, you can keep commenting and we'll be addressing them very, very soon. Thank you. And now let's take up Mukesh's question. This is also on YouTube. He asks, if our company hires an H2 worker who doesn't show up, what are our obligations and potential liabilities? And what happens if an H2 worker gets injured on the job? Are we liable?
So I'll take up the first part of the question first. So if you have H2 workers and someone disappears, they abscond. If they have, that's typically if they haven't reported to work for 5 days, they have been non-responsive, they're AWOL, they've been absent without leave for at least 5 days. You can report them as as an abscondment. So, and you are required to report them if you know they're not coming back. For instance, if they've quit or left in some way, and you know they're not coming back, and you haven't given them permission to leave. People leave all the time, but your obligation as an employer is within 2 days of knowing that they're not coming back. So they told you they weren't coming back, or it's been 5 or more days, and they haven't reported to work. No one knows where they are. You can assume that they've absconded. You have to report the departure to the government. You have to report it to Department of Labor, and you have to report it to Immigration Services. That will insulate the company from being on the hook for the 3/4 guarantee when the worker's not there. So that's one of the compliance requirements. We didn't get a chance to get into those today. But on the employer side, one of the requirements is the 3/4 guarantee, meaning that it's a full-time position, 35 hours or more. Mm-hmm. You have to, as an employer, offer them at least 3/4 of those hours offered, whether you say it's 35 hours or 40 hours. If you have to report them as missing or absconded, or if you fire them, you still have to report them as an early departure. It's one of the compliance requirements is to report a missing worker. As far as workplace injury, that falls outside of the scope of immigration, and it's going to be based on your state law, whatever your state workman's comp is. You would be liable in the same fashion as you would a U.S. worker. So if would be liable for workman's comp for a U.S. worker, it's going to apply for an H2 worker. Now, on the worker side of that, if they're injured on the job and need surgery and can't travel and the end of their visa is coming, they need to look at changing it from an H2 visa to a B visa, a visitor visa, and do a change of status so that they're not here unlawfully on the H2 because they're no longer working. So it comes up in rare cases, but yes, if someone's injured, they need to make sure, and they can't travel home for treatment, we have to be able to make sure they stay in status.
Right. Thank you so much, Megan, for highlighting and for giving us such important points today. And thank you for also taking up Mukesh's questions at the same time. Thank you, Mukesh, and you can keep commenting if you have more questions. Now, coming back to our questions, Megan, I have another question, and that is, what are the robust protections in place for both American and foreign workers, under the H2B program, and how must employers ensure that these protections are met?
Right. So there's many protections for both U.S. and foreign workers. On the U.S. side, there's basically it boils down to making sure that a possible U.S. worker is not treated in any less fairly or afforded any fewer opportunities or no more requirements than would be required of a U.S. worker. For instance, if you're filing a landscaping position, a corresponding worker couldn't be required in the U.S. to have 5 years experience when you require 0 experience for a foreign worker. So, each business, when they file the application with the Department of Labor, has to sign an attestation with all these compliance requirements listed, noting that they understand what those requirements are and that they will abide by them while they're participating in the program. Now, workers, to start out with, for corresponding workers or foreign workers, they should get before they start, or if they're a corresponding worker and they may already be working, because that could be a worker that's worked for a year or less with the same employer. So again, corresponding worker means it's a U.S. worker either present, already working, or one that you hire during the recruitment process that performs substantially similar duties, same job. That would not be your secretary or your landscape manager if you're coming in as a groundskeeper. If you're just doing a landscape laborer job, corresponding workers for on the U.S. side would be the same position, not something that's unrelated. So again, the employer can't impose any requirements or obligations they wouldn't impose on the H-2B worker, and they also, have to pay them at least the same as they're paying the H-2 worker. Now, anyone in the H-2B process, which is going to apply to corresponding workers as well as H-2B, because if you have H-2B, then you have corresponding workers more than likely. A big component is prevailing wage. That prevailing wage is the first step. I talked about the employer process, but it's important for the workers because when you get the terms and conditions of employment before you start, which tells you what kind of job you're applying for, where it is, who you're working for, what the wages are, whether or not there's overtime, what benefits are included, all of that is given to you. So you can track it. You can make sure you're being paid what you should be. And that includes the prevailing wage. Every position is set by the government, and you have to at least make the H-2B prevailing wage. So you get that protection. Also, in H-2B, you're going to need to be paid at least every 2 weeks. They can't pay you once a month. There has to be regular paychecks. It's another requirement. On that same note, every employer is required to provide you with a pay stub, which provides you with the hours offered and the hours worked, the pay rate, overtime rate for every pay period. So that should be something that you get. Also, deductions. Unlike H-2A, which does not have to have with tax withholdings on it, H-2B does have tax withholding. So your federal taxes and Social Security withholdings are withheld from your paycheck as required by law. But any other deduction aside from those lawful, required deductions, the employer has to have your approval to deduct it. So if you, one difference between H-2A and H-2B is that H-2A housing is provided, H-2B, the worker is responsible for their own housing. That being said, some employers will give workers the option to stay in employer housing, which means you pay fair market rent and utilities. If you are opting into that as a worker, you have to either pay the employer directly, or you can have it withheld from your paycheck. So things like that, health insurance, rent, utilities. Let's see, what's another common one? Loans, things like that could be a deduction on your paycheck need to be approved by you. And they need to be on your pay stub so that you can see what the deduction is. So, you just need to know what's coming out of your check, and you're entitled to know that. I talked a little bit earlier about the 3-quarter guarantee on the employer side. It's another thing for employees is that H-2B is a full-time role. If you are offered 35 hours on your contract, you are entitled to at least 3/4 of those. If you're offered 40 hours, you need to be offered at least 32 hours, so you've got some minimum protections to make sure you're not doing nothing. You're getting paid for the work that you expected to be here to perform. And if they don't have enough work, they're still required to pay you for it. If it's rained, and it goes for every 12-week period. So there's a calculation for that you can look up. The employer should be aware of. That's an important guarantee to make sure you're paid as the contract says. Another important item that comes up is tools and equipment. There's no reason you should be charged for tools and equipment. That the employer provides all tools and equipment to perform the job. So that should not be something that happens. Another important note for protection for workers is visa fees. There's under no circumstance should the worker be paying for visa fees. You may pay them at the consulate. Some employers will do that, but you have to be reimbursed the first work week when you get here. Inbound travel, also something that is covered by the employer as part of the H2B program. That one is most employers will prepay it for you. Some may pay it when you get here. The regulatory requirement is that as long as you stay, you have to stay for half the employment contract to get the inbound transportation. But with federal wage requirements, a lot of times they just pay that with your visa fees up front because they can't take you below the federally mandated minimum wage by virtue of withholding that, by not having you reimbursing that travel. So the bulk of you will have your travel reimbursed when you get here, if not prepaid. Same thing, if you complete your contract, you do not leave early, you're not terminated, you're entitled to have the employer cover your return transportation. So you finish the work contract at the end of the season, your employer is responsible for sending you back to your point of origin. So that wherever country you came from, you get travel reimbursement back to your home. Very important. Same thing if you're terminated, you still get return transportation. The only time you don't get return transportation is if you quit early or if you transfer to another H2 employer, then that new employer is responsible for paying your travel to the new employment site. So those are very important. Another very important thing that workers should know, and this comes up not in the employer context, it is an employer compliance requirement. Employers should sign something if they're using a recruiter, the employer should have something signed that the recruiter says that they're not going to charge workers a fee. No H2B worker should pay an employer or a recruiter a fee to be referred to H2B. Very important. It's not something that you should be responsible for. And violations for this, there are audits from Department of Labor, there are site visits, inspections. Employers are required to maintain an audit file with all of this documentation, copies of your pay stubs, copies of reimbursements. The employer should have copies of all of this. And workers also, there should be an H2B rights poster that the employer posts in the work site. That also will have details on how you can whistleblow, how you can report it. There's anti-retaliation components as well, so that the employer can't retaliate if you report wrongdoing or mistreatment.
Wow. Those are, a great number of protection rights and laws and rules and regulations you highlighted. And thank you so much, Megan. I think once you have the passion to work and you have the right documents and you're on the right path, I think nothing can stop you.
Right.
So thank you, Megan. And we have Samuel who's back with another question. I think we should take that up. He's asking, can my spouse, who is my dependent on an H1B visa that is in administrative processing, apply for a visiting visa?
There's nothing to preclude her from doing so. But again, there's very little transparency into that application process. So, it's possible for a spouse to also be put in administrative processing for anybody can be put in administrative processing for any visa, for them to review it. But there's nothing, just because you have a visa pending, that also doesn't mean she couldn't apply for her own H1B, her own visitor visa. There's nothing to preclude, again, assuming she's eligible or can qualify. Your being in administrative processing isn't going to prevent her from doing something else. Even if she's on an H4, she could still theoretically apply for a visitor visa. Whether or not it's approved, is anybody's guess.
That's cool. Thank you so much for taking that up. And Samuel, I hope you've got your answer. Thank you for participating. I have another question, Megan, and that is, how does the H2B program ensure that foreign workers are not exploited by the employers?
Right. So that a lot of the same things will apply from the compliance requirements. All of those compliance requirements are in place so that workers are not exploited. You have a prevailing wage to ensure the worker is not paid too little. There's, again, reporting opportunities with Department of Labor to report employers that are, misusing the program, so that your protections remain in place. There's also, depending on your state, there may be nonprofit or volunteer groups that can also provide services to help if you are, being subject to mistreatment. So, all of these protections and compliance requirements that you should be entitled to, they can be enforced in the same way. Though you can report them and they can be subject to penalties for that. And I don't know if we'll get to the penalty question or whether I should cover that here, but there are penalties that the employer can suffer based on that, depending on what the violation is. Again, the anti-retaliation requirements are important for that. Workers can file a complaint with the Wage and Hour Division with Department of Labor for any of those violations, for being charged a fee, not making your hours, not being paid the correct wage, being denied. Again, another thing that it doesn't come up often, but when there's severe negligence or mistreatment of workers, another thing you should report absolutely is if your employer is holding your passport. Your employer should not have your passport or visa. You should have free autonomy to leave at any time. Be aware of as a worker, the terms and conditions of your visa, and make sure you're not, by leaving, having an issue with your status because you're no longer at the employer. So, there are things to consider for that, but it shouldn't deter you from reporting mistreatment.
Right.
I don't know if you want to jump ahead to the repercussions for employers. I know that's another question, or if I should just get to that later.
Yes, we could get to that a little later, or maybe in our next episode as well, because there's so much to talk about H2B. But
Sure.
I would also like to tell our folks out there, that it's always best to consult an attorney and be guided with your case, because every case is different and needs proper attention. And I would say, why not contact attorney Megan Kirkner in her number, and her number is 434 226 0586. You can note it down. You can also email Megan. Her email address is megan@kirkerimmigration.com. You can check out the spelling on the screen and go visit www.kirknerimmigration.com to get to know more about Megan. Thank you so much, Megan. It was really great. But of course, so much to talk about this. I think we should definitely do another episode on H2A and H2B visas again.
Sure. Be happy to.
Yeah. But before we go, what do you have to say about Trump and, starting 2025? What can we expect maybe, or what do you think the immigration scene is going to look like?
I was just at a conference in DC with other immigration attorneys on Friday, and we're all just ready to buckle up for the ride. H2 in particular was a little more insulated from some of the trials and tribulations that came from the administration last time. A lot of the other employment visas, family-based visas, are going to have much tighter scrutiny. Requirements may change. It's going to be more difficult. Again, I know you mentioned a lot of people file on their own, but particularly with this administration change, having an attorney navigate the process will be more important than ever, because it's going to change, and it will change quickly, and more than likely not in any way that makes it easier.
I know everybody is so anxious, and I really hope that, things fall in place as soon as possible, or at least folks out there get to know what can happen or what may happen with their case. So thank you so much, Megan, once again. It was great having you, and I really hope to see you in the coming week.
Nice to be here, and thank you for having me, and best of luck to everyone watching, and reach out if they have any questions.
Yes, absolutely. Thank you so much. And also Samuel, and then we had George who had joined us. Unfortunately, the line was a little disturbing, but I still hope that, George, if you have any further questions, you can comment, because after the stream has ended, this is going to be published, and it'll be really nice to have you comment with your question. And I'm sure, Megan, you can address that. I will put that up to you.
Yeah.
You do.
Sure.
Yeah. Anything else you want to say to the folks out there with regard to the topic before we leave them? Because I feel like we're just ending it so abruptly right now.
Yes, where this is just the tip of the iceberg for the H2 world. I wasn't really able to dive in at a really granular level as far as what employers need to do, how long it takes. So
Yes.
I really just want everybody to know that it can be a long process, but with the right help, and starting at the right time, it doesn't have to be a painful process as long as you start. But their timelines are critical for this program.
Right. Right. Thank you so much for that hopeful note and an end note. Thank you, Megan. And you have a splendid week ahead, and I'll see you soon.
You as well. Thank you.
Thank you. And folks out there, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter. It was really nice having you, and especially with your questions in the comments. So feel free to like, share, and also subscribe to our channel. Hit that bell icon so that whenever we have discussions like these, you are notified. And really, I'm also looking forward for Megan to join us again in the coming week, because there's so much to discuss about H2 visa, and I'm sure you too have a lot more questions. So thank you so much for doing this today, and don't go anywhere, because we have more webinars and discussions lined up on Immigration and Jobs Talk Show.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are here lined up with another very exciting and very informative webinar that is lined up just for you. So make sure to watch this session till the end, as this is going to be really productive and very informative. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use at your own risk, and the information is completely on you. All right, so before directly inviting to our guest, let me also introduce the topic in front of you, and that is laid off on an H1B. Here's what you can do in your 60-day grace period. So recently, friends, we got up with the news that tech giants have laid off the H1B visa holders, right? And if you are one of them or know someone who has been through this situation, then I think it's really tough time for you guys. There are so many things that might be coming in your mind, so stressed, so disheartened, and confused right now. But I think if you still have that 60 days grace period time, then you can still make some changes. At least you can make your situation a better one. But for that, I think you need expert guidance and a right advice. And for that, we have an expert over here, one of the finest immigration attorney, attorney Uma Mantravadi. So, thank you so much, Uma, for being here. Again, I'm so excited for this session. And welcome back to Immigration Talk Show.
Good afternoon, Sam. It's good to be back.
That's great. And to our viewers also, friends, if you haven't subscribed to our channel yet, then make sure to like, share, and subscribe to Immigration Talk Show. And we are live here at 3 p.m. EDT on YouTube and also available on LinkedIn, Facebook, X, and on Instagram as well. And if you have any questions regarding the topic, as this is a very hot topic and a very important one, then please go ahead, put your questions on the comment section, because until and unless you're not going to ask the questions, we won't be able to help you out. All right, so Uma, I think before diving into the topic, what our viewers can expect from today's webinar?
Every webinar we've done has been always extremely informative with the most current information as to what's happening in the immigration world. We are bringing all this information to only, keep people appraised of what is happening. These are not meant to be looked at as negative. We're not trying to make things more difficult or negative for anybody, but just to update you and update the viewers as to what is happening and how they can help themselves. These are always going to be those kind of webinars, very educative, very informative, because I get news almost every single day, every
Yeah.
single hour from Ayla.
That's perfectly put. And I think it's really a difficult time, especially for the H1B holders. And, so many things are there, Uma, that I have prepared to ask questions. But I think before into that, I just want to have like answer on like why are H1B layoffs happening? What can be the
Well,
reasons behind it?
well, the layoffs are happening because the job cuts. As you all know, there is DOG, the organization that has been cutting a lot of federal jobs, and due to that, there's a lot of federal projects that are
Mm-hmm.
being disconnected, and they are no longer available for employers who had already planned the jobs, and the jobs are gone. Even for the cap cases that are going to be filed right now after this election was picked up, as you know, Sam, a lot of employers, I'm hearing from them, is that we don't have the project anymore. It's gone. So we are not able to even file the cap case. So it can be very disheartening and disappointing for the H1B employee.
That's right. That's absolutely correct. And friends, if you know someone or if you are one of them who is facing this situation, then I would suggest that please watch this webinar because this is a must watch session for you guys only. And we are here to answer your questions or, to provide you the right answer and the right solution. And with that, Uma, as we all know that after being laid off of the H1B visa holders, they get a grace period of time, and that's like 60 days. So, my
Correct.
question to you is that does the grace period start after the termination notice date, or the last working day, or the final paycheck? When does that
Typically, it is the final paycheck. It's not because they may give notice. Let's say we're going to lay you off in a month, or we're going to lay you off in 2 weeks, or 6 weeks. So they're just giving notice, but the actual layoff occurs on the last paycheck day, because after that they're not getting paid.
That's right. That's right. And when do they see that they are no more a candidate? I mean, an employee of that company. So after how many days does it take for the employer to give the final paycheck and everything?
I wouldn't know that. That's something very internal. You know,
Right. All right.
that's
All right.
between the employer and employee.
Mhm.
Whatever their understanding is as per their employment agreement or their offer letter, whatever they've been told, they have a clause for the termination. So whatever the employment agreement says about the termination.
All right, that's completely all right. It depends upon the offer letters and everything, the clauses that.
Employment agreement, whatever they've had. It's not that an email
Mhm.
stating we'll do this, do that when you get terminated. So that is something between the employer and employer.
All right. Okay. And also talking about common mistakes, because, Ma, this is a little tough time for the H1B holders. So maybe they are so stressed out, they're so confused. So they might take some wrong steps. So you are the attorney, and that too with lots and lots of years of experience. So according to you, what are the common mistakes that H1B workers make during this period of time?
One of the mistakes that I normally see is calculating the 60-day grace period. A lot
Okay.
of people have made mistakes thinking that, they get laid off on a certain date, but actually they got laid off on another date. And they made a mistake calculating those dates and they filed things wrongly and they were denied because they went out of status.
Hmm. That's right.
I've had people even assuming going by blogs or vlogs or, whatever online social platforms. Somebody told them you have 90 days or 6 months. So they followed that.
All right.
So,
Mhm.
people make these mistakes constantly. And I tell people don't follow those blogs, you know, this is not the correct information. Either you go to uscis.gov and get that information, or please consult an attorney
Absolutely.
because you make these mistakes. I've heard this so often, Sam, it's not even funny, people making these mistakes, thinking that it's somebody told me it's 90 days, somebody told me 120, somebody told me 6 months. I don't even know where they're getting these, kind of dates. So that is one big mistake I see.
That's right. I think it's a huge one, and that too we are not
Yes,
sure like from where these informations are being spread, and that too such a wrong one.
correct.
But
And
any
and
tips?
and
Yeah.
people sometimes do it thinking it's a joke,
Mhm.
putting up this information. Haha, let me put this up, and funny people are following. But people are not realizing this may be a joke for you, but it's a life of someone. So please, you know, let's not joke around on issues like this.
That's right. And any
If you're
tips,
dealing
Ma?
with people, uh, I would say if you don't know what the grace period is, please contact an attorney.
That's right.
Find out when does my grace period start? What can I do? What are my options? Contact an attorney because each one's situation is individual.
Mm-hmm.
There's no copy paste for me. I can't copy Sam or I can't copy anyone. I have my own individual situation. We're all born differently, exactly the same way. Our situations are different. So we cannot, unfortunately, copy paste somebody else's, and that is another big mistake that people make all the time. My friend, he did this in January. Why can't I do it? I'll do the same thing. My friend did this in December of 2024. It's not too far back. Why can't I do this? No, it's not going to work.
That's
What
right.
happened yesterday will not work today.
And I think in 2025 we just be with this statement. What happened yesterday can't happen this way. That's right.
Exactly.
Okay. I
We every day we get so many surprises, Sam, about everything. I'm not talking one topic, and I'm not going into other topics. But generally speaking, there's always, maybe the location has changed for the filing, the fee may have changed, the policy may have changed, the document requirements may have changed. Anything can change.
mm-hmm. That's right.
And we as attorneys also, we don't take it for granted. What I do yesterday, I don't do it today. I make sure that I'm following the policies, the rules, the requirement.
Mm-hmm. That's absolutely correct. And I think this is quite difficult, I would say challenging for all of us because,
This
every day.
is a very challenging period since
Yeah.
2025 for whatever reason. It
Mm-hmm.
has been a little more challenging than it was in 2024. Yes, and every year is going to be different. Maybe 26 will be different. Maybe 27 will be different. So, we have to go by what it is in the current time. Yes, it is good to know history, only to learn lessons from the history,
That's right. And I think
not for anything else.
mm-hmm.
I tell people the simple thing, Sam, if you may allow me to say this. When we are driving, we look into the rear view mirror, right? Just to make sure we're doing the right thing. But then you don't continue to drive by looking into the rear view mirror. You look forward after that. We only briefly look into the rear view and then we look forward. Life is the same thing.
Absolutely. And that's very well put up, a very, I would say, smart statement that you put up, Uma. So thank you so much for that. And I hope that our viewers understood right now, like what are the important things and, how you have to take each and every step very carefully. And any doubt, any problem, I would suggest that it is the best time, and very important time to get in touch with the right attorney. And I would suggest the attorney who is having a show with us is full of knowledge. You can also reach out to her as well. The details are on the screen. Let me read out the contact details. The number is 713-787-5297. You can also email her on her email ID, that is uma@mantralaw.com, and surely visit her website, that is www.mantralaw.com. So, okay, this was the contact details. And moving ahead with my next question, Uma, I have this thing that whenever we have to go with the grace period, we have one option that one can transfer their H1B visa to a new employer. So what
Right.
steps should one take to transfer their H1B visa to a new employer during the grace period?
Well, the first step is they have to reach out to a employer. They're going from employer A to employer B. So the first step they have to take is find an employer B. And if the employer B is willing to, sponsor their H1 and
Mhm.
bring them on board with their company. So those are the first steps. And once they're agreeing to do this, they should also let them know that they've been laid off and they are in the grace period, so
Mhm.
that there are no surprises for the employer, the new employer. And then, of course, let them know when the grace period is ending, when is the 60 days ending for them, so that the new employer will take the steps to ensure that they file their H1 in a timely manner.
All right. Okay. And there's another question, Uma. For example, if somebody is not able to, get a sponsorship or not able to get a job, then what other visa options might be available for them? Like they can also change their visa status, right, from H1B
Correct,
to other visa.
correct,
Yeah.
correct. They can change it to a tourist visa, they can change it to an F1 visa, provided they get admission into a school, get the I-20 in a timely manner.
Mm-hmm.
So I have done a lot of H1B employees who got laid off. As you can remember, even back in 2020, when COVID occurred,
Yeah.
lots and lots and lots of people lost jobs, particularly during that period,
Mm-hmm.
the first year of COVID. So we had to do a lot of change of status to either a B2 or to an F1 or even a non-cap H1B, meaning working for an employer who is a nonprofit or, one of those educational institutions. They can even transfer to that. So it all depends on the individual's background, education, experience, whether they can fit into a non-cap case and transfer the H1 to that. So those are the options, going to a B2, going to an F1. And particularly during COVID, if you remember, Sam, a lot of people couldn't even travel out of the country because the flights were all canceled.
Mm-hmm.
So
That's
that happened, and so based on that, the government was extremely understanding, and they did not make a fuss about it to allow people to change their status.
mhm. That's right. So I think this can also be the options for the one those who have been
Sure.
laid off. Mhm.
And I see this happening with particularly with a lot of people who are married and have children, and the children are in the middle of school year,
Mhm.
and they have no option but to stay here until the child finishes the school year, so that in case they plan to go back to their home country, they've at least allowed the kid to complete the schooling and then go back to their home country.
Yeah, I'm so sorry. I think I was on mute. Okay, so this was the thing that we asked regarding one of the ways, like how H1B layoffs can do another thing, right? And also, what
Right.
happens to the one for the green card process? Because they might also be the one in the middle of their layoff that can happen. So, what can you suggest to them?
Well, the green card process may continue by the employer who filed their green card, provided it all depends on their relationship with that employer. Now, if you got fired and you're gone, or the employer doesn't like you anymore, they can say, we're not going to continue with the perm or the I-140 process. Let's say the perm got approved and they are waiting to file the I-140, but if you left on a bad note or things didn't work out between you and your employer, they may say that. We don't know that. But there are some employers who say, you know what, we've come this far. I'll complete the I-140. We'll help you out with it. You can go to another employer. That's okay. You and I don't get along, but we'll still help you out. So it just depends on different employers, employees, their relationship, how they maintain it. So, which is why we advise people that even if you're breaking off from an employer, don't burn your bridges. You know,
Yeah,
keep your friendship, leave in a good note.
yeah, that's so true. And I think that's how it should be. But things are changing and people are becoming very intense. So don't know whether this is applicable this time or not.
Sure.
Okay, all right. And also moving ahead with my next question, Uma, like, does the 60-day grace period apply if someone voluntarily resigned from the H1B job, or is it only for the layoff thing?
No, it can be a layoff if you're fired, if you resign, any of them.
Oh,
And
okay.
this is not just for the H1, this applies to the H1, L1, TN. There's a category, as we discussed way back, the E2,
Mm-hmm.
and there's the E3, which is applicable to Australia.
All right.
So the 60 days applies to all these categories.
Okay, all right. And also, let me go ahead and see that we have joined by some of the viewers. Jay is here, Yuri is here, Kritika is here. So, hi guys, and thank you so much for being here and participating in this webinar. We will take up your questions, just stay patient, and after half an hour, we will take up these questions. So, friends, if you haven't put up your questions or asked any query that you want us to know, then please go ahead and put them in the comment section, and we will definitely try our best to provide you the solution. Until now, I would say Yuri, Jay, or Kritika, guys, if you haven't subscribed to our channel yet, then make sure to like, share, and subscribe to Immigration Talk Show as we come up with latest updates on immigration, and we'll definitely try our best to be the one and the credible source to provide you the recent and a very trustable source on immigration. Okay, so let me go ahead with another question, Uma. We already talked about the 60-day grace period, applying voluntarily, and if it goes with a resign or not. So, what are an employer's legal obligations during layoffs? And are they required to notify USCIS or cover return cost? What do you have to say on that?
Well, in the form, the H1B form, they do sign, the employer does sign that they will pay for the repatriation of their employee if the employee decides not to go to another employer. They don't want to file for a change of status, and they're telling the employer, you know what, give my ticket and I'm going to go back. That's fine. And if they say that, then the employer does have the obligation
Mm-hmm.
to pay for the repatriation because that's what they have signed on the I-129H supplement. That is the employer's obligation. Are they required to notify to the USCIS? Now, if they are firing an employee or they're laying off and they want to revoke the H1, they can do that. They can notify. It's a good practice to notify.
All right. Okay. And there's another question that should an H1B holder file for a change of status immediately upon a layoff, or they should wait until closer to day 60?
That I cannot tell them what to do because, each one looks at it differently. Somebody wants to take their time in finding an employer. They may want to take 30 days, 40 days, 50 days, So we don't tell an employee when, how soon they should file because that is going to be their decision. That is something they will decide and let us know. And as an attorney, I will follow what they want to do, you know. Because
Mhm.
let's say I told them file it day 5 for a change of status, and then they find an employer, they're going to blame the attorney saying, you asked me to file it. So I won't do that. I will not. They're going to be the ones to tell me, you know what, I waited 40 days, 50 days. I don't think I'm going to find an employer who's willing to sponsor my H1 and change employers. So I'm ready to go ahead, file a B2 or an F1. They're going to tell us what they want to do.
That's right. Okay. And also talking about documents, as documents are very important. So, Uma, what documents should someone keep handy so that they can prove that they stayed in status if USCIS ever asks from them?
Paychecks, W2s,
Okay. All right.
proof of maintaining status. Yes.
All right. So these three documents are important. And friends, you just make sure that these three documents should be there and you have to keep it handy. Okay, and now I think Uma, I do have one of the case study that I want to just let you know and ask a question regarding it.
Yeah.
That few days back, I just scrolling down Reddit, Quora, and so many things. So I just went through one of the case study that was little catchy from my side. So I just want to make it in front of you. That
Yeah.
there was a man on Reddit and he posted that previously he was on an H1B visa, but he got laid off few days back.
Okay.
And
Okay.
after the layoff, he found a new job. Luckily, he found a new job, and his employer also filed the H1B transfer petition. So
Okay.
then the process was okay, everything was smooth. But what happened? The transfer was still pending from the USCIS side because they didn't send the approval.
Okay.
So yeah, during this waiting period, during the till the time the USCIS didn't approve, that man traveled outside the US because he thought that he will re-enter.
Meaning he left the United States.
Yeah, he thought that he'll be coming back to the United States with the same visa because that is going to be available. But what happened at the US port of entry, the CBP officer saw that the H1B visa is no longer active. I mean, the job is no longer active. So he wasn't, able to enter the US, and he got cancelled both his H1B and the B1 visa also if he had that one. So this was the situation that he went through. And I want to know it from you, like what advice you can give for anyone, who is in this situation or similar situation to avoid visa cancellations.
Well, first of all, he won't have an H1B stamping that is valid anymore, because
Mhm.
whatever he may have had may have expired. I'm not sure if he got laid off in 3 months, 6 months, 1 year, 3 years. I'm not sure of that. But if he had the H1B period still valid and he was trying to travel on that to H1 and come back, he couldn't, because once you leave the country, when the application for your H1B change of employer or an extension is pending and you leave the country, you basically abandon your application. You can no longer come back. You have to then do a consular processing because you abandoned your application. You
Mhm.
travel, you abandon.
That's right.
So,
Mhm.
what is the advice? Before you go, contact an attorney. Find out, should I be traveling? Can I? What are
That's
the repercussions if I do?
mhm. Of
People, again, they just follow somebody says, oh, I travel, nothing happened. But you don't know that person's situation. You don't know whole story about that person.
mhm.
So
Absolutely.
my advice, contact an attorney.
That's right. And also, we can put this point in one of the list of what are the common mistakes that the H1B holders do during the grace period time. They just get influenced with some others scenario or other situation, and then they keep on implementing the same, pointers or results on their own situation. So it becomes more like it makes the situation even worse if they are
Right.
going to rely on other situation. So, of course, that's very well explained, Uma. And once again, thank you so much for putting up those, great pointers in front of us. And friends, I'm hoping that you guys have, so many questions from your end. And sure, we are going to take them. But before that, let's take a short break. And after a break, I'm directly going to take questions from comment section. And also, we are going to take some questions from Facebook as well. So you have 2 minutes time. Ask as many questions as possible. Just go ahead and put them on the comment section. It's me, Sam, with the attorney Uma Mantravadi, and we'll be soon coming here with another second session of this episode. So don't go anywhere. Keep watching Immigration Talk Show, and we'll be coming back soon. Hello, everyone, and once again, welcome back to Immigration Talk Show. I'm your host, Sam, and today I'm joined by one of the finest immigration attorney Uma Mantravadi. And the topic of discussion is another very important and very timely, and that is laid off on an H1B visa. Here's what you can do in your 60-day grace period. So till now, friends, we have got to know lots and lots of questions. We understood why is this layoffs happening, and also what common mistakes are there, and so many things like what steps you can take. So I'm sure our viewers have got lots of information with them, and now you are ready with your questions. So I think without any further ado, Uma, let's go ahead and take up our viewers' questions. So let me take Jay's one first. So hi Jay, and thank you so much for participating here. Jay is asking, I just got laid off while on an H1B and I'm in shock. So what exactly does the 60-day grace period mean for me? And do I have to leave the country if I don't find a new job within that time?
Well, 60 days grace period, we just explained the whole process when it begins and ends. So I'm not going to repeat that part of it. But during the 60 days, you can either find an employer, move to a new employer who's willing to sponsor you, or you can change your status to a B2 or an F1. Now, do you have to leave the country? You don't. You have these options. But a lot of people prefer saying, you know what, I don't want to spend money going into student. I don't have the money, so I'm just going to go back. So that is something, if you decide to, you can do that.
That's right. Okay, so Jay, I think you got your answer. And in case if you still have any follow up question, then please go ahead and ask us and we will take them up. Until the time, let me know that whether you have subscribed to Immigration Talk Show or not. If you haven't, then please do it right now. Okay, let me go ahead with Yuri's question now. And Yuri is asking, my H1B is tied to my employer and I was just let go. If I leave the country during my grace period, will I be able to come back without issues or will this affect my future visa applications?
Under the current administration, there is no guarantees that you can come back without issues, even for a straightforward case. There's so many issues happening at the airport. The CBP is, putting additional requirements, and they may say you don't have a job. What are you coming back for?
Mhm.
So that's going to be the biggest question if you don't have one. So at the moment, I am not telling anyone to travel out because, if you go, the chances may be slim
That's right.
or maybe not.
Mhm.
Advisors, contact an attorney, talk individually what you want to do.
Absolutely. And Yuri, I think this is a question that not you are asking. There are so many people who wants to know that whether they will be coming back to the US if there is some problem regarding their visa. So it is better that if you don't travel outside the US, I think that will be little like the safest option. So do as what attorneys are saying, and still, if you have any question, then you can directly go ahead, and we have shared the contact details of attorney Uma Mantravadi, and you can also reach out to her. And let me go ahead and take up Kritika's question. So Kritika is saying, "Hi, can you walk me through the process of filing for a change of status, such as transitioning to a B2 tourist visa or an F1 student visa?" During the 60-day grace period, and what are the potential risk and benefit of this strategy? Yes, Uma.
I cannot walk you through for the process because it's a lengthy one. Either you have to learn on your own by going to the USCIS website what to do, or you can contact me for doing the process, but I cannot walk you through the process.
Okay, all right. And Kritika, I think it will be better because self learning gives more and more experience. So you can go ahead and learn it from yourself. In case if you have any question after that, then please come ahead and ask us, and we will definitely provide the answer and try to clarify your doubt. Okay, let me take up Sanjay's question now. Sanjay is asking, how does the 60-day grace period impact the dependents of an H1B holders, such as spouses on H4 visa or children on H4 visas? And what steps should be taken to ensure their immigration status is maintained or transitioned during this time?
Well, they'll have the same 60-day grace period as the H1B holder, and they will be doing whatever the H1B holder is doing. If they are moving to another employer, then they will be filing for the H4 extension. Or if the H1B holder is going to a B2, then they can go to a B2. Or if they're going to an F1, they'll become an F2 dependent. So it all depends what the H1B holder is going to do.
Okay, all right. So,
And
Sanjay,
coming back to the previous question, I know you were mentioning to the lady Kritika, yeah, you can file things on your own, but then, experimenting life in the immigration world under the current circumstances is not one of the wisest things to do because things are changing so rampantly, so quickly. Even the websites, they're not able to change it that quickly.
that's
So
right.
whatever information you're getting could be stale. So contact an attorney. That is the biggest advice I can give people right now because you don't want to gamble with your life.
That's right. And I would suggest, Kritika, it's little high time. And it's not only for you, but for everyone to be little extra careful, to be little extra cautious. And I think if you're staying updated with all the things, then I don't find that any problem you might fall into. But still, it is better to be like updated with all the information. And if you haven't subscribed to our channel, I would suggest that if you want to stay updated, then please subscribe to our channel right now, as we provide latest immigration shows and also information and news regarding immigration world. So that will be really good. And Sanjay is also we have taken, Jazz also we have taken, and Uma, with your permission, we would like to head on to Facebook questions.
Yeah.
Okay. So, Control, if you could please share your screen and go through us with the Facebook questions. So, this one we got from one of the groups, and it is, my friend's Ivan 40 got denied recently at first attempt, even without getting an RFE. So, has anyone got this experience? Any chance to be approved? EB3 unskilled.
I wouldn't know whether there is a chance to be approved without looking at what is written in the notice of decision. I'm sure they would have written whatever the reasons are for denial. So unless I read that, I cannot tell you whether it may get approved again if you refile it or there is an inherent mistake. I wouldn't know that till I review the document that this individual got from USCIS or the friend.
All right. All right. I think we will ask them to get in touch with you so that you can give them a personal guidance and can give them the right advice.
Because
Okay.
the decision will tell me, Sam, what the reasons are.
Absolutely. Absolutely. Completely agree with you. And we'll try our best so that this individual can get his answer. And let's move ahead with our next question that we got. Hello, usually how long the process of I-130? My husband is my sponsor for my I-130. He applied, that was last year August. Thank you.
Well, you can go and look up the processing time on the USCIS website, depending on the service center it's filed with. So it gives you the approximation of the processing timings with the receipt number. Some service centers are doing 1 year, some are doing 2 years. I know California Service Center had huge backlogs where they were processing I-130s for up to 5 years. So each service center is different.
All right.
There is the processing time that is provided freely by USCIS, but that's an approximation, not an exact.
All right. Okay. And let's move ahead with our next question. This we received from anonymous member and hi everyone, I'm currently on an H1B and recently transferred roles within the same company from a product manager position to a software engineer role. I made the move assuming it would be a smooth internal transition, but I have now realized that an H1B amendment should have been filed before switching since the roles are quite different. So, has anyone been in a similar situation and did you face any consequences or were you able to fix it by filing the amendment after the switch? Any guidance or suggestion would be really appreciated. Trying to stay calm and figure out the best next steps before talking to HR or legal. Yes, Uma.
Well, if your company has an attorney, the attorney should have advised HR that any change in the position, location, job responsibilities have changed. They have to file an H1B amendment immediately. What is the fix to it? I mean, if the USCIS comes to, or if there is a site visit by the FDNS, and you were working as a product manager, let's say at a third party location, and they don't find you there anymore because your role has changed. You're now a software engineer, and your end client is somewhere else, different city, different state. They're going to say, well, we didn't find you at location A based on what you filed with your LCA, but you're at location B, and we don't know that you moved to location B.
Yeah.
They can definitely, revoke the H1. So the HR should be telling all this to the attorneys who filed the H1, and they will advise accordingly.
All right. Okay, so thank you so much, Uma, for going with that. And let's move ahead with our next question as well. And this we got from Vignesh Yadav. So Vignesh is asking, when can I expect my PD to become current? EB2 India May 2050.
I have no way of guessing when it will become current. All I can say is we all have to keep looking at the visa bulletins to get the updates.
That's right.
No
That's
way of predicting. As I was joking a few weeks ago when we did the episode that, I'll have to get one of those tarot cards to determine the answers to these questions.
all right. Okay. So Vignesh, I think it's just that you have to be aware about these things and you have to keep in touch with the visa bulletin all throughout the time and then if you have any problem then please come up with your question and we will provide you the solution to that. Well, thank you so much Vignesh for being here and let's move ahead with the next question. Okay, so this is the question that we got from anonymous participant. If
Mhm.
F1 student decide to change it E2 in the middle of the degree, will it have a negative impact during interview?
E2 is not for all countries, it's only for certain countries, which is a treaty investor visa. You can, but the question will come up. There is no interview if you're doing it as a change of status in the United States. But if you're doing consular, yeah, they can have questions because they'll say you initially went with the intent of being a student and you never completed that. You never fulfilled what you said you're going to do, and they can deny it. So if you're doing a change of status in the U.S., shouldn't be a problem. Maybe they'll give an RFE for that, and we can always answer that.
That's right, that's right. Okay, so I think let's move ahead with the next one. Okay, so I think these many questions were there. that viewers have asked us. And Uma, I think with that we have covered all the questions that I prepared, and we got from comments also, live chats as well. So I think successfully we have went through all the questions, and we have covered so many queries regarding, whatsoever the layoffs are happening. So any last advice or any last message you want to share with those H1B visa holders who got laid off? What they can do right now? Any message that will be helpful for them?
Well, it's a tough time for them. It's not going to be easy. And I'm extremely empathetic to that situation. Nobody should be facing this in these tough times. But unfortunately, because of job cuts, project cuts, the employers are having no choice but to lay off their employees. So the best thing would be, constantly keep working on your resumes, maybe keep interviewing for the jobs even while you have a job. So
Mhm.
maybe there is a bank you're building up with employers, and should there be a situation, at least you can reach out to that employer B or C or D saying, listen, I interviewed with you a month ago, and do you have a position? I'm ready to jump into your company. I can do that. So this is how I would, you know, work things out. Plan ahead. Also, if you think you may get laid off, what kind of school do you want to attend? I would, make sure you give all your transcripts to that school so that if you need an I-20, at least you're not starting from scratch.
Yeah,
So these are things, backups that you can do.
that's right. And I think our viewers have noted so many pointers today. And I hope, friends, that you like this webinar. And absolutely, whenever Attorney Uma Mantravadi comes, she has lots of information to share with us. So I would say, Uma, thank you so much for your time, for your so many information. Our viewers are finding
Most
it really
welcome.
great, and these shows are really insightful. So thank you so much. And friends, also there's a contact detail of Attorney Uma Mantravadi. In case if you are having any complexities regarding your immigration journey, go ahead and dial up the number, that is 713-787-5297. And you can also you can also ask your question in her email ID, that is uma@mantralaw.com, and visit her website, that is www.mantralaw.com. So with that, thank you so much, Uma, for being here. It was really
Thank you. I do want to say something also. I feel that the viewers, listeners, whoever join us on these talk shows, need to appreciate the people behind the scenes who bring this to them, the technical support for everything that they do for every episode. It's not I'm in the forefront, you're in the forefront, but there's a lot of work that goes behind the scenes to bring all these episodes to people. There's a lot of work, time involved, and efforts involved. So I want everyone to thank them. Personally, I want to thank them for doing what they're doing, patiently doing this week after week, week after week, not just one episode, but so many episodes with different attorneys. So I think all of you should really go online and thank them. Whether you know their name or you don't know, that's fine. You can just thank people for and appreciate their effort.
wow, that's so sweet of you, Uma, and so kind of you. Thank you so much to
Not
you
at all.
too. Because of your such great discussion, also, we really feel motivated to have these shows and keep on preparing such a great questions, because we know that we are going to get such great answers. So again, that was really so sweet of you, and thank you so much, and hoping to see you soon again.
You bet. Thank you, and everyone have a great weekend.
All right. So, with that, friends, this was it for today's webinar. I hope you liked it. And, still, if you have any question or query, please put them on the comment section. Even after the stream live ends, we are going to take those questions, and our team is going to provide you the answer. Until the time, if you haven't subscribed to our channel, then make sure to like, share, and subscribe to Immigration Talk Show. We are live on YouTube, also available on LinkedIn, Facebook, X, and on Instagram as well. Do follow us on these many platforms, and it will be great if you could also hit the bell icon so that whenever we come up with any live webinar or any news update, you will directly get the notification. And that is the best way to keep you updated regarding everything that's happening in the world of immigration. So, lastly, friends, subscribe to our channel, and thank you so much for watching us till the end. And hoping to see you soon on Monday. Till then, happy weekend. Take care, everyone, and also enjoy yourself. Thank you, everyone.